Okay. Good morning, everyone. Sorry for the delay, but we seem to be up and running, and I hope not only the participants, but any observers can see and hear our proceedings. Thank you all for joining us for this evidentiary hearing in the Amtrak-Gulf Coast proceeding. To briefly summarize the case, Amtrak has filed an application with the board under 49 U.S.C. 24308E, seeking an order requiring CSX and Norfolk Southern to allow Amtrak to operate 2 round-trip intercity passenger trains per day over the rail line of CSX and NS between New Orleans, Louisiana, and Mobile, Alabama. There's been discovery in the case, and the board has received numerous filings, including evidence and argument by Amtrak, CSX, NS, and the Mobile. In mid-February, we had a hearing in which the public provided comment, and then we convened a trial conference with the parties. Today's proceeding is a formal evidentiary hearing on the record under 24308E involving the 4 parties. Before we begin, I want to say a special thank you to our IT team and other board staff who have worked so hard to make sure this happens successfully. First, I want to go over a few procedural and technical matters, and then we will get into some of the substantive issues of the hearing. First, as always, please silence your cell phones. Turn off your cameras when you're not presenting or participating in examination or cross-examination, and mute yourselves in Zoom when you're not speaking. When you are presenting opening statements or closing arguments, we had planned to have a timer, but as you'll see in a few minutes, we're not going to apply a timer at this point. We will be using breakout rooms in Zoom when confidential and highly confidential information and evidence is presented. When it is necessary to enter the breakout room, our Zoom moderator, Matt Cross, will place the appropriate participants in the breakout room. There may be a slight delay while this happens. I will make an announcement when we have entered a confidential or highly confidential session, and board staff will be monitoring the list of participants in those sessions. But if you happen to be inadvertently placed in a confidential or high confidential session and have not signed the appropriate undertakings, please remove yourself from the Zoom room. Also, if you have multiple people together in a conference room, we will rely upon the parties to monitor who is permitted to remain during a confidential or highly confidential portion. As a reminder, to minimize our need to go in and out of these breakout rooms, we ask that the parties try to keep their discussion and questioning of confidential or highly confidential information to 1 session per witness. If possible, we're not going to cut you off if that can't happen, however. Let me also just say to the public who may be witnessing this on YouTube, when we go into these confidential breakout rooms, then you will not be able to see or hear what's going on, because the reason for this is the parties have filed proprietary information, which is allowed to be kept from public disclosure under the law. And so to honor those requests, we may from time to time have to leave you sitting there watching an empty room until we come back. So hopefully you will bear with us, but understand this is legitimate protection for parties' information. Panelists, you will have access to the chat function in Zoom, but please only use this for technical questions. If you become disconnected from the hearing and are not able to connect via Zoom, there is a phone number you may use to call in, included in the hearing information you were provided. If you do need to call via phone, please email us at hearings@stb.gov with the phone number you're calling from, so we can identify you and reach out to you with further instructions. You can also refer to the frequently asked questions on the board's website for any further troubleshooting or contact information. This hearing is also being streamed on YouTube, and the link is available on the board's website. A transcript of the public portion of the hearing will be on the board's website after the close of the hearing, and a recording will be available as well. For the benefit of our court reporters, please speak clearly into your microphone and minimize background noise. They're welcome to interject to tell us if they can't hear. We plan to take an approximately 30-minute break lunch each day from about 12:30 to 1 p.m. Eastern. We will also take several short breaks throughout the day, and I would say to counsel, if any of you feel the need for a brief break, please feel free to ask for one. We will try to conclude each day by 5 p.m. Eastern, I'd say 5 to 5:30, although we may go slightly longer if it allows the parties to finish up with a witness or allows us to reach a logical stopping point. Now we have some preliminary matters to go through. First, we received a number of materials from the parties as exhibits, as they were directed to do, and I want to make sure that all of us, at least the 5 board members and the parties, all have the same materials. And helpfully, we received, they weren't in the packages, and so I was a little bit lost, but we did receive cover letters from counsel involving these materials. So I want to go through these one by one and ask the parties to confirm that we are all in sync. We also received letters dated March 30th from counsel for all the parties except the port, referring to various potential objections and other aspects of the exhibits, which I want to cover in a couple of minutes. So first of all, we received 3 large volumes of 3-ring volumes. They're about 6 inches thick each, that are listed as joint exhibits. Do I understand that these are joint exhibits of all 4 parties, and they are to be, and you are asking us to admit them without objection? Can I hear confirmation of that from counsel?
Yes, Mr. Chairman, Matt Warren for CSX. They are, I think technically they are already admitted, because those joint exhibit volumes are the prior, filings of the parties in this case, which I believe one of the board's prior orders indicated was already admitted.
All right, but I want to make sure there are no objections to any.
Yes, of course. We have no objections. CSX and has no objections.
And is that the same for everybody else?
No objections.
That was definitely a no objection. Sounds like that.
No objection from Norfolk Southern.
All right, Amtrak. Was that you, Jessica, trying to tell me something?
Amtrak.
Yeah, all right. And the port? Is Mr.
No objection.
All right, thank
No
you.
objection.
Then I received 2, we received 2 relatively thick 3-ring binders that are listed as joint exhibits of CSX and NS. Is that correct? The total filing?
Yes, Mr. Chairman.
All right. Then I received, and it's the only one I could pick up by hand, a relatively small volume or 3-ring binder from Amtrak. And those are the only exhibits beyond the joint exhibits, Amtrak, that you are offering?
Yes, that's correct.
Okay. And finally, I received some oversized pieces of paper about 1/4 inch thick with no cover letter, but a list, and the list refers to them, each number, as a port exhibit. So I assume these are the exhibits submitted only by the port, and these are all the exhibits that the port has in addition to the joint exhibits. Is that correct?
That is generally correct, Mr. Chairman. There was one of the exhibits that we sent, which was in 2 parts, Port 1A and Port 1B. We discovered during the weekend that the maps that we sent you, while they are not inaccurate, did not contain all of the information that we wanted to convey in those maps. We arranged yesterday evening through Mr. Folan to send new electronic versions of those maps, port 1A and port 1B, and circulated those last night.
All right, I don't know that I have seen those. We're going to get into objections here in a moment, but just on, Robert, I can't see, is this Robert Wimbush talking?
It's Rob, yeah, it's me.
Yeah. Is there any objection from any of the parties to Mr. Wimbush's late night correction of an exhibit?
No, Mr. Chairman, not from CSX.
Amtrak?
Not from Amtrak.
And NS?
No objection from Norfolk Southern.
All right. So if there are other objections, we'll deal with those later. But in terms of the timeliness of it, I guess we need to make sure that the board members can see it. I'm going to worry about that later, Mr. Wimbush, when we get to your part of the case and you want to offer the exhibit. So other than objections, well, I want to talk about the objections for a moment. We also received a joint stipulation as to uncontested facts and issues. And so as to the facts part of that stipulation, those facts, unless I hear otherwise, at this moment will be considered as having been established. Third, we received a letter on March 28th from Brian Dunn, U.S. Coast Guard, which was, because of the way it was filed, has already been placed in the docket. We received a letter from all counsel alerting us to the fact that we would be getting a letter, or might be, and objecting to any communications with the Guard that were not in writing and not placed in the docket. To my knowledge, staff can correct me, I don't believe there has been any communication with the Coast Guard other than that letter. And unless there is any objection, I would order that that letter be admitted as evidence. Is there any objection?
No objection from CSX.
None from Norfolk Southern.
Objection from Amtrak.
None from the board.
All right. So that will be admitted. Fourth, and this is a matter you may have heard me refer to at the outset, we received a letter from counsel for CSX and NS listing Thomas Crowley to be called as a hostile witness because he was no longer going to be called as a witness by Amtrak. Is there an objection to calling Mr. Crowley as an adverse witness?
Mr. Chairman, if I may, we've had some discussions with Amtrak since that letter went in, and my understanding is that Amtrak is now planning on calling Mr. Crowley as a witness during their case in chief, and we don't have any objection to that. But I'll let Jesse speak for Amtrak.
That's correct, Mr. Chairman. We worked it out among the parties such that we would call Mr. Crowley during our case in chief to give the other parties the opportunity to cross-examine him as well.
All right. Good. I was going to, we were going to have some discussion about that, but that has been mooted, so we can move forward. So at the outset, now there are some other objections that were raised, and I want to just comment on them in the record, because you've all raised them in your letters, and I wasn't sure how you were expecting, how and when you were expecting us to deal with them. So first, in the letter dated March 30th from Mr. Mullins and Mr. Warren concerning Amtrak's Exhibit 6, basically you are saying that if Amtrak's Exhibit 6 and the testimony of Clayton Johnson get into area which you contend was part of his previous disclosures, that you may object. I would say on that and the other issues that the time for us to, and I'm glad you raised the issue to alert us to it so we can be ready for it, but obviously which cannot be ruled on in a vacuum until the testimony is offered. And if you want to preserve those objections, raise them at the time and we'll deal with them at that time. You also, in the same letter, you say you reserve the right to object to any part of the exhibit based on the context of which it is offered. Can you enlighten me on what you're talking about?
Yeah, I think Mr. Chairman, there could be instances and where an exhibit is offered for witness that doesn't know anything about the exhibit, or an exhibit is being offered in some way where it would be, where we don't think it would be a fair representation of the record. And I think this would apply to both sides, that, as exhibits come in during trial, I think both, or during our evidentiary hearing, I think that both sides would have the ability to raise objections that they think might be appropriate based on the context in which the exhibit is being offered.
Well, that wouldn't go to admissibility. If you aren't objecting to admissibility, you might have a relevant foundation question, as you say, if it's raised with a witness who doesn't know anything about it, although I don't know why a party would do that. But I mean, either you have an objection to the admissibility or you don't. So you say generally you have no pre-hearing objections to their exhibits, but then you may have an objection. So I think we need to know whether these are admitted at this point or not. You may object to the use of an exhibit, as it sounds to me like what you're saying, in a context, but that doesn't go to admissibility. Is that a fair understanding of what your concern is?
I think that's generally fair, Mr. Chairman, and other than Exhibit 6, which you've noted that we may have some concerns about whether that proposed demonstrative, reflects analysis that wasn't actually included in any of Mr. Johansson's prior verified statements. We obviously have reserved that. The documents, which other than the demonstratives, which would not be admitted under any circumstances, they would just be demonstratives. I don't think we have any particular objection to the admissibility of any of the exhibits on Amtrak's exhibit list.
All right, I wanted to clear that up. Next, Amtrak has raised a concern about use of drone footage. Well, there's several issues that are raised in Amtrak's letter of March 30th from Ms. Amundsen. Amtrak asked for a stipulation as to some use of the drone footage, which was not agreed to. I would say on that matter, Amtrak, you could preserve your objection to that, and if and when the drone footage is shown, we should focus on the specifics of your concerns and rule on them at that time. So again, I'm appreciative. I think the board members are being alerted to the areas where there will be discussion. You raised the same question. Are we still on here? My screen just. Can everybody hear?
We can hear and see you.
Okay, very good. Same concern was raised with certain photographs listed in the March 30th letter. So as to both of those, I note your objections are reserved and you should raise them at the appropriate time. Amtrak also raises objections to CSX NS exhibits 172 through 266. I haven't looked at those. It refers to letters submitted by non-parties. I assume these are the many comments we received, not all of them, but whatever ones you selected from the public. Is that what those are, Matt?
Yes, that's correct.
All right. And for what purpose are you offering them?
I don't believe that we would be intending to introduce all of them, but some of them, I think are relevant to the views of those interested third parties, and they may be introduced with certain witnesses.
Well, all right, then again, I think we'll reserve, Amtrak's reserved its objections. We'll deal with them one at a time if you offer any of those letters. And then we'll deal with their admissibility at that point. And then Amtrak raises a concern referring to matters as visual aids or demonstratives. Again, not unlike the point, Matt, that you just raised. I think we'll deal with, it's hard to deal with them in the abstract, and we have so many maps and photographs and drawings that at the time these exhibits are used, the party should identify them as whether they're intended to be demonstrative exhibits or actual substantive matters, and then we'll deal with objections at the time. So let me talk a little bit about evidentiary objections. In order for this matter to function, it has been determined that as to evidentiary objections, I will be ruling on those objections initially. However, this is a full board proceeding. So if any board member disagrees or wants to raise an issue, then the board will debate it and, if necessary, vote on it. If there are no objections raised by the board members, then my rulings will be deemed to be the rulings of the board. So everybody knows where we stand, but I see no need, unless the other board members see it, to vote on every objection on an evidentiary or other procedural matter that comes up. So with that introduction, I am going to rule that with the exception of the items specifically reserved in the March 30th letters from counsel for both sides as follows. The Amtrak exhibits, with the exception of Exhibit 6, are admitted, and the port exhibits, including the late filed one, which I haven't seen, are admitted. And the NSCSX exhibits, with the exception of all the items itemized in Ms. Amundsen's March 30th, 2022 letter, are admitted. The ones that are reserved in those letters, as I said, our objections are reserved and we'll deal with them at the time.
Yeah, Mr. Chairman, if I may, Amtrak's exhibit number 5 is a demonstrative exhibit. And while we don't object to it as a demonstrative, we would think that it falls within the same reservation that Ms. Amundsen raised with our demonstrative exhibits, that those demonstratives would not actually be admitted as exhibits.
I will modify that ruling and we'll reserve judgment on Exhibit 5 as well.
Thank you.
So we get there. Otherwise, all of the Amtrak exhibits are admitted and the others are admitted. Thank you. That
Mr. Chairman,
smooths that out.
Mr. Chairman, Jesse Amundsen for.
Yeah, Jesse.
Just briefly, in our letter, the objection to photos was also as to the port photos that were offered. So just to make sure that that's noted as well.
Oh, thank you for clearing that up. So are you objecting to all of the port exhibits or just the photographs?
The photographs.
Okay, so with the exception of the port photographs, all the port exhibits are admitted, and then we'll raise those objections at the time. By the way, when counsel is speaking, I can't see you, and it's helpful to me if you turn your cameras on when you're speaking so I can see who I'm talking to.
So Chairman, this is Ray. Just so you know that our feed, our audio feed is going through our witness video feed. So anytime you hear counsel speaking, you're in presentation or speaker mode, it's going to show probably an empty chair. We can't have two different mics set up. It creates too much feedback. So to see us, you're going to need to put gallery mode on. So you'll always have a camera showing you counsel in the gallery view, but only our witness, the audio is tied to our witness chair.
All right, well, I just clicked on gallery view.
And you can see me and the four of us.
I cannot see you. I can see Rob Wimbush.
There should be one for CSX NS counsel.
Let me see here. Oh, you know what? There you go. I can see there was a blockage across it. I see that. Oh, and I see Jesse. Okay. But you're saying,
Mr. Chairman, if I may, we will have a similar central microphone for our presentation as well. We have all of our witnesses and counsel in the same room, but we are all accessing this presentation from separate computer stations, and as a consequence of that, to avoid the feedback issue that counsel for CSX has pointed out and Mr. Atkins has pointed out, we will be doing the same thing. We will coordinate with your IT people to make sure that when our opportunities come for presentations, that when our times come, that you see both the attorney and the witness when we present. But we will certainly coordinate with IT if you're having any difficulties with that.
so trying to come into the 21st century here, let me figure this out. If I want to see, when we get into the evidence, I won't have to be in gallery view to see counsel and a witness. Is that what you're saying?
So Chairman, when we start to do direct for CSX and Norfolk Southern of a witness, you will if you're in portrait view, you will always see our witness, and we will be in a thumbnail. Even when we're talking, the video feed will always be on the witness. So if you want to see us, you'll need to use gallery view to see both the witness and counsel who are doing direct.
Okay, we'll figure it out. I have no idea what the YouTube folks are saying, but hopefully they can see all of it. Okay, so now we are going to proceed. As you know, we originally set a schedule for opening and closing statements for the parties. We also, on March 14th, issued an order directing the parties to be prepared to address 5 listed issues at the hearing. I'm going to request that the council address those issues in their part of their opening statements prior to the beginning of evidence. And for that reason, we're not going to impose the oral argument, opening argument time limitations on you, because those are issues which may well need more time than you were otherwise planning to address us in your opening statements. And I would also say, by the way, that just because we ask you to address those issues in your opening statements does not mean that you cannot address them later, as the topics may relate to what's being litigated at the moment in the hearing with witnesses, and certainly in your closing arguments. But I think it would be, just to finish, I think it would be beneficial to the board members to lay out at least the parties' contentions, if not a full-blown discussion of the answers to the questions we posed.
So Chairman Orman, may I just remind the board that we filed briefs on Friday that lay out our position on all of those issues. So so did Amtrak, as all the parties did, the port did as well. So you have before you our full position on those legal questions. I would submit that it might be more beneficial to just to refer to those legal documents, and then we can have a robust conversation about it in closing, rather than for us to just reiterate what we said in our briefs to the board on Friday. which just to be candid, I mean, I can do it, but it wasn't a part of my prepared opening remarks.
Yeah, and Mr. Chairman, I might add that that was done with the consent of all parties between a meet and confer, that we would all file legal briefs and address it that way rather than taking time. We certainly can take time if that is what you prefer, but it is in the pre-hearing trial briefs.
Well, I must confess, I am unaware of those filings. I don't know if the other board members have read them. I see now they're in the, on our docket, but I think like most other board members, I was pouring through the vast volume of stuff you sent us. And so perhaps you can, we'll read them, of course. I'll read those at breaks, but in the meantime, I think it would be beneficial if you could give us a brief summary of at least what your positions are, and then you don't have to go into fulsome legal argument as to how you got there. But I think we'd at least like to know what your contentions are.
Understood.
Let me ask the board members if that's okay with them. If anybody has a different approach.
I'm fine, Marty.
Okay. All right. So I'm still going to give you some additional, let's not overdo it, but additional time in your opening statements. We have a lot of witnesses to get to address those 5 issues. So with that, we will begin the parties' opening statements. Does CSX or which among CSX and NS wants to begin? Your
Chairman, this is Ray Atkins on behalf of CSX. I'll begin for CSX, and then Bill Mullins will follow me.
Very good.
As you can see, I've just switched myself into the witness chair, just so you can actually see me for the presentation for no difficulties. Bill will join me after we're done. May I begin, Chairman Overman?
Please begin, Ray.
Thank you, Chairman Overman, members of the board. Ray Atkins on behalf of CSX. For over 40 years, there has been an established process to accommodate requests for new passenger service. That process has 2 key ingredients. The first ingredient is a robust study. The study must examine the impact on existing freight and passenger service. As you heard last month, and as this hearing will make crystal clear, the rail traffic controller model is the gold standard. The second key ingredient is collaboration. Once the model is done, the parties need to work together to settle on the right infrastructure solutions. We can use the RTC model to test different ideas, but you need collaboration between the parties to settle on the most cost-effective way to add the new passenger trains without harming existing service. The normal industry process here completely fell apart in this case. The first ingredient was tantalizingly close to being done. You will hear testimony that the joint RTC study was 2 to 3 months from being complete when Amtrak pulled the plug. We expect Amtrak will try to lay blame on the railroads and a lack of transparency in the modeling inputs. But the process was proceeding along a perfectly normal path, where all the confidential traffic information was provided to Amtrak's own expert pursuant to a data sharing agreement between the parties. That was the entire point of identifying and retaining a well-regarded independent RTC expert. But for whatever reason, Amtrak made it clear it was no longer interested in the completion of that RTC study, refused to let the railroads pay to finish the study, and instead filed this case with the STB. But the law and the record will not support Amtrak's aggressive demands. And let there be no doubt, Amtrak's demands are aggressive. Amtrak maintains it is entitled to immediate access to the Gulf Coast line without any study of the impact or a single penny of infrastructure. The aggressive nature of this request is best illustrated by Amtrak's refusal to build a dedicated station track in Mobile before it begins operation. As you know, That project was identified by the Gulf Coast Working Group in its report to Congress as an essential project for obvious reasons. Otherwise, the Amtrak trains will sit on the main line while they load and unload passengers and will traverse the congested Mobile terminal 8 times as it goes back and forth from the station to wherever it will park between trips. And this aggressive demand for immediate access with no study and no infrastructure cannot be reconciled with the billions in public funding that Congress has allocated to expand the national transportation passenger footprint. If not spent here, then where? What will this hearing show? Well, first, Charlie Banks from RL Banks and Associates will talk about how the RTC model creates a rigorous way to find solutions needed to accommodate passenger trains. And he will describe the process that CSX and NS witnesses followed to develop the RTC model that is before the board in this proceeding. Once Charlie sets the stage, 2 witnesses are going to transport the STB to the Gulf Coast line with maps, pictures, and drone footage. Mr. Ricky Johnson, the chief engineer for CSX, will guide the members through the CSX portion of the route. He will describe all of the complex operating features of the line, which is mostly mainline track, with 7 movable bridges, local traffic, foreign trains, hundreds of grade crossings, all operating between 2 of the most important rail terminals in the region. He will be followed by his counterpart from Norfolk Southern to describe the particular challenges in the New Orleans Gateway. Once you have visited the line virtually, the RTC model that Amtrak hoped to bury will fully reveal itself. For CSX, you will hear from Ms. Hannah Ross about the efforts she took to make sure the CSX inputs were accurate. You will also hear from her counterpart at Norfolk Southern. Far from the disparaging claims by Amtrak about our trying to manipulate the data by including yard trains or foreign trains or even the bridge tender movements, it will be clear that the inputs are all sound and reliable and gathered by 2 professionals with absolutely no incentive other than to provide a complete and accurate picture of the line. Then you will hear from Mark Dingler from HNTB, who will walk the members through the RTC model. The RTC model will show immediate harm to freight service from adding 4 additional passenger trains into this busy corridor. The model is predicting a 4.5% decrease in fluidity, which translates into 13 hours of delay per day, a 33% increase in delays to interchange partners in New Orleans, and a staggering 45% increase in delays to local traffic around Mobile. If that were not bad enough, you will have complete gridlock in 20 years with only modest projected freight growth. That is unreasonable impairment under any definition of the word unreasonable. Third, you will hear in this hearing from Larry Guthrie from RL Banks about the exhaustive verification process we undertook to assure the model was complete and accurate. In my 2 decades of working in this industry, I have never seen an RTC model where the inputs were more carefully scrutinized, the model performed by a more talented team of experts, or the entire process validated in a more thorough and professional manner. I am confident at the end of this hearing, you will agree. This hearing will also show that Amtrak is not serious about showing potential impacts of this new service. It has refused to model the line using the RTC model, claiming that it didn't have enough time and information. Amtrak instead submitted a static mathematical model by DB of the capacity of the line. Now, we will demonstrate in this hearing some serious flaws in that methodology. But DB's analysis is completely irrelevant. They have missed the entire point of this hearing. Both the RTC model and Amtrak's expert conclude there is sufficient capacity on the line to run 4 additional trains right now. But the question is, what is going to happen to existing freight service when you add 4 high-speed and high-priority Amtrak trains? What will be the impact on existing customers? What will be the impact on interchange partners? What will be the impact on the Port of Mobile? Indeed, what will be the impact on all of the stakeholders who appeared before the STB last month and asked you to be careful not to harm local Alabama industries? That is the only legal question presented in this hearing. What is the impact and whether that impact is reasonable? The mathematical exercise by Amtrak says nothing on that issue. It just says there may be room on the line. The RTC model can answer that question about impact, can test different solutions, which is why it's the gold standard used by everyone. And you don't need to listen to me or our experts about the flaws in Amtrak's case. In a stunning flip-flop, Amtrak's own witness, Mr. Crowley, submitted a verified statement for a different client, Metra, in the CP-KCS merger just a few weeks ago that says the polar opposite of everything Amtrak would want you to believe today. He submitted a complete RTC model, which appears to have been constructed from scratch on a fast procedural schedule for Metra. He explains how you needed to add into the model foreign trains that do not appear in the data. And he bashes mathematical models of theoretical capacity and explains eloquently why the RTC model is vastly superior. Chairman Oberman, members of the board, throughout this entire proceeding, you should be asking yourself a simple question. Why? Why did Amtrak really pull the plug on its own RTC expert? Why didn't they submit a competing RTC model? It's not really a mystery. Any credible RTC model would have shown an impact that would have undermined their demand for immediate access. Finally, in this hearing, you will hear about some infrastructure projects that would address this impact. The experts will explain that these projects are not about providing any kind of freight benefit to the railroads. It's just about making sure service does not get worse. Indeed, CSX will tell you it has no incentive to propose a penny more than is needed because CSX will be on the hook in perpetuity to maintain, repair, and replace the new infrastructure once it's built. And you will hear that this Gulf Coast line is 5 times more expensive to maintain than any other part of the CSXT network, in part because of how often it has to be rebuilt after a tropical storm or a hurricane. In the end, applying the law to these facts can lead to only one outcome: denial of Amtrak's demand for immediate access. But where does that leave us? CSX is committed to finding a solution in good faith that works for Amtrak and protects the interests of all parties. As I started my opening, the 2 key ingredients needed to accommodate a request for new service is a good RTC study and then collaboration between the parties. We now have the first ingredient. We still lack the second. The STB can fix that. After this hearing is done, the STB should order board-sponsored mediation. You can create a confidential settlement forum for candid discussions. You can assign a mediator with national credentials and a reputation to help guide the parties. You can invite key stakeholders to the table, and you can provide your own technical RTC experts so everyone has confidence in the solutions. Frank settlement discussions and a genuine long-term solution is still within reach. But Amtrak's demands for immediate access is doomed. It was doomed the moment Amtrak abandoned the normal process that has been followed for decades, deliberately blinded itself to the impact on the line by pulling the plug on its own RTC expert, and then claimed the right for immediate access without any idea what will happen to local customers. Amtrak needs to hear that from this agency so we can move beyond aggressive legal posturing and beyond past grievances and find a workable negotiated solution. So that ends my prepared remarks. If I will just for a moment touch on the questions that the chairman asked at the outset. I'll break them into basically 2 categories, but refer the members to our legal pleadings, which are more robust. And we will be happy to take all of this up, of course, in closing after you've seen the presentation of all the evidence. The first question has to go to the contract. I'm going to need to be very careful here because everything about the contract is highly confidential. Those contracts cannot be shared between CSX and Norfolk Southern. I will just tell you, you can read from our pleadings. It is our position that those contracts are not governing here. There is no agreement between the parties to have this service be governed by those agreements. So any question about compensation and infrastructure at this point in time would have to be determined either in this proceeding by this board. On the broader question about can the board require infrastructure to be as part of a board order, if you conclude that we have satisfied our burden of proof, which I believe we clearly have, to show unreasonable impairment, then it is CSX's position that the board does have the authority to advise the Amtrak about the scope of infrastructure projects that it would have to build in order to address that impairment. And at that point in time, they could offer in the sense of like a declaratory order that Amtrak would have a right to access once those projects were completed. We think that's well within the board's authority, if you were so inclined to do so. Although, as you can tell from my ending, our recommendation would be is for the board to simply rule on our having carried our burden of proof and then move this entire controversy into a board-sponsored mediation, which I think would be more productive than the board itself. But it is our position you have that authority. With that, other than those broad questions, I'm actually going to, unless there's follow-up questions, I'll defer the considerations to our pleadings, which were submitted on Friday, and we will, of course, address any particular legal questions you have in the closing remarks. And I'm going to turn it over to Mr. Mullins, who's going to present for Norfolk Southern.
Before you do that, Ray, I have a couple of questions for you and other board members in May. I want to be clear on a couple of things without going into confidential material. It's CSX's contention that anything to do with compensation or payment for infrastructure is governed by the statute and not by your existing contracts. Is that in a nutshell?
In a nutshell, until there's if you need a meeting of the minds between the parties in order for the contract to govern, and at this point in time, CSX has not yet agreed to this service and therefore does not believe that the terms of that contract govern.
All right. Number two, when you say we have the authority, under what statute section do we have the authority, in your view, to order Amtrak? And I noticed in your pleadings, as I was going back over them yesterday, that sometimes at least you refer to funding the infrastructure as opposed to building it, which could be a difference, but whichever it's funding or building, under what statutory language do you contend we have that authority?
So I would submit it depends on the findings that the board issues. So I believe if you conclude that we have satisfied our burden of proof to show unreasonable impairment, then I do believe that in the sense of how, like, the board issues deck orders where they describe the rights of the parties, you could say in that order, if Amtrak builds the 14 projects that have been identified by the parties, that would alleviate the showing of unreasonable impairment, and then they would be authorized under subsection E for access. So I think that's a perfectly valid statutory authority for you to issue that. It'd be a combination of E and your general authority under the APA to clarify, remove ambiguity and clarify the rights of the parties under the statute. If you were to conclude somehow, based on this record, that there has been no showing unreasonable impairment, it is clear from the statute that infrastructure and whatever other compensation can be determined under subsection A. So we believe you have the authority under one of two sections, and that. But so I mean, in the end of the day, CSX believes you guys have the authority to provide guidance to the parties about the infrastructure that is needed before they can come on the line.
Well, it's one thing to provide guidance. What I'm trying to be clear about, and it's one of the reasons we asked you the question. There's nothing in subsection E on its face that even uses the word infrastructure. So is it CSX's contention that E can be construed? It sounds like you're suggesting, and by the way, I just got a message from staff that, and I don't know how our electronic system works, that you're not, I don't know if all of them, but at least some of the parties' pleadings and answers to the question didn't actually get posted till this morning, even though they were filed sometime Friday, and that may be because of the weekend. So it's unfortunate that none of us knew about these or had a chance to read them before today, but that's okay. We will read them. But I just want to be clear, Ray, is there some language in subsection E, which you are relying on to say we can order the infrastructure. And it sounds like that the kind of order you would envisage is the kind of say a conditional order we might enter in a merger. The train ordered conditioned on Amtrak's doing X, Y, or Z. Is that the kind of order you're envisaging?
Honestly, that's what I'm envisioning. There is I can see every council's looking at me. Matt may want to weigh in here and give you
all the board members are looking at you too, because we're trying to get educated.
Well, and just appreciate, Chairman, we did a lot of preparation for this opening, and it did, we were assuming we would talk about these legal questions on Wednesday when it comes up. It's not that I'm not prepared, but just so yes, that's the way I have envisioned it. There's clearly a provision in the statute in E though that indicates that compensation can be determined. But my vision for your authority is that if you were to conclude based on this record that if these 14 projects were built, that there would no longer be unreasonable impairment such that they would be entitled to access, that you have the authority to indicate that to Amtrak. That I think it's just an inherent authority, and it's no different than if Amtrak had come in here from the outset in their complaint and said, we are going to build all 14 of these projects. We want a board order that says once completed, we are entitled to right to this line. So that is CSX's position, that you have this authority, and it's inherent in your authority to deny it if they don't build any of the infrastructure. So I can see.
It sounds like you're suggesting that the authority isn't to order Amtrak to build infrastructure. The authority is to make a finding, if you're in accordance with your contentions, that without the infrastructure, the statutory standard will be violated, so that the only way to meet the statutory standard of unreasonable impairment is to build the infrastructure.
I agree completely,
Is
Chairman.
that what you're saying? Is that what you're saying?
Yes, I agree completely.
And you think that is inherent in our powers?
Yes, sir.
Okay. The second question I had.
Marty?
Yeah, go ahead.
Before we move on from that point, it looks like Karen has a question and I do as well.
Oh, I'm sorry. Okay, I was looking at my papers. Karen, go ahead.
Yeah, my question is, if we find that without additional infrastructure, there's unreasonable impairment, does that mean all we can do is order all of the infrastructure that CSX and NS are requesting? Or do we have the ability to determine that there's some lesser level of infrastructure that may be appropriate that relieves the unreasonable burden?
Ray, are you with us?
Sorry, I muted my own mic. All right, I'm going to start over. Member Hudlin, I think you're an adjudicatory body in this context, which means you get to look at the evidence and conclude, what the evidence demonstrates. So if there were evidence in this record to demonstrate that, say, 9 of the projects was all that was necessary to assure that there was no unreasonable impairment, then that would be the type of order that when I was talking to the chairman about, that you would be able to submit. I do, but it needs to be based on the record that's been developed in this case. So you're going to need to know what the infrastructure projects are that you've narrowed it down to. You're going to need an RTC model that demonstrates that with that infrastructure set that you've alleviated the solutions, and then you could make a lesser finding than the 14. So CSX is not arguing that this 14 is some sort of magic bullet or a perfect solution, but you asked us in August to come forward with a solution set that would address the harm. So we came forward with one. To date, is to the best of my knowledge, Amtrak has refused to commit to any infrastructure investments whatsoever.
Thank you for the clarification.
Patrick.
Hey, Ray, I also would like a clarification. Is it your position that if the board were to order infrastructure under either subsection, obviously would the host railroads be obligated to accept that infrastructure if Amtrak or another party were to offer to pay for it?
That's a good question. I'm just thinking about it because I don't think I've seen that in the papers or discussed. Let me just, with a caveat that we might change our mind by the end of the trial, as I talk to others. I believe that answer is yes. If the board were to say, I don't believe that CSX could simultaneously say that you need to build extended track, dedicated track out of Mobile as a condition for access, and then you order it, and then we refuse to let them build the track. I'm not exactly sure where the statutory authority is, but that just doesn't make a great deal of common sense. So if we have a refinement on my answer, we'll offer it in closing.
Thank you.
Ray, two other questions. Does the board have the authority to apportion the cost of the infrastructure between the railroads and Amtrak, or between the railroads themselves and Amtrak?
So if this moves into an A case, then I would expect that the board might have authority to apportion. I can't understand why that would be the case, since the infrastructure that we've proposed is designed to offset Amtrak and is specifically designed to not provide a freight benefit to the railroads. It's just to offset the impact from adding 4 passenger trains onto the line. I do think that if you conclude that, I could see some authority under A for that as a general matter. I just don't think the facts of this case would support any kind of non-arbitrary way of allocating the cost of those infrastructure projects.
But that assumes, you're assuming that the board concludes that as you contend, that all of the infrastructure only benefits Amtrak, does not benefit the freights.
That is correct.
And if we can conclude otherwise, do we have the authority under E to apportion? In other words, in the kind of conditioning order that you said, could we include those conditions that Amtrak build X and CSX build Y?
If it was premised on the record and findings that were supported by the evidence, then I think the answer is yes.
Okay. The only other question I had was procedurally. It wasn't clear to me. In your view, would the board have to find that the railroads have made their prima facie case in order to order the parties into mediation? Or are you just saying you want us to find that and then order you into mediation? I wasn't clear.
Excellent question, Chairman. So we don't care which way we get into board-sponsored mediation, because we just think that is a useful vehicle. However, based on the filings in this case, I think it would be tremendously helpful for some clarity from the board that there is going to be unreasonable impairment, and that Amtrak's position is too aggressive, so that we can go into that mediation with the understanding that we need to find a solution. And that solution means finding the right suite of infrastructure projects to accommodate Amtrak's desires to start service, but protects all of those Alabama stakeholders that you heard from last month. So, Chairman, I don't think it's a prerequisite. If the board were so inclined, you could simply push us into mediation. I would actually recommend you do it right away, because I think everyone is tired of the amount of time that has lapsed. So you could easily push this into board-sponsored mediation and then rule on the record while we're in board-sponsored mediation. And the last point I'd make is CSX does not want to delay this proceeding at all. So although we are advocating for board-sponsored mediation, we are not doing so with any desire to slow down the board from reaching a determination in this case.
Could the board, I suppose, then the board could also find that the railroads have not made their prima facie case and still order you into mediation?
Yeah.
Your view.
Well, I don't see how in this record you could make that finding, but I appreciate that's what you're to decide.
We realize we haven't decided the case yet.
Yeah, understood. You can push parties into board-sponsored mediation anytime it is likely to resolve in a better outcome, and I cannot imagine a better case than this one for board-sponsored mediation.
As we said in our order Friday, I don't know that I disagree with you, but it would have been nice to have had this request a long time. But we will. If you are finished, we will move forward.
Yeah,
are you
thank you.
Actually,
I'm done.
I'm sorry, Michelle has a question.
Yeah, Marty, actually, just to follow up on your question, with regard to the possibility of apportionment of the cost related to infrastructure, Ray, from your view, could that be done under either subsection E or subsection A?
It clearly could be done under subsection A. I believe subsection E is better attuned for if we're under subsection E, you've agreed with us that we've carried our burden of proof of showing unreasonable impairment, that the RT6 study is the best evidence of record, and that what it is showing is unreasonable. In that case, I think the path for the board would be to clarify to Amtrak that they need to commit to put these infrastructures in place in order to alleviate that. In that circumstance, I don't see how the railroads should be responsible for anything, because we're the ones who demonstrated unreasonable impairment. If this gets kicked into a subsection A case, then, which I think Norfolk Southern will talk a little bit more about in terms of their response is a little just slightly nuanced, different from CSX, then I think apportionment would be more properly to be considered when you're trying to figure out if you've got a particular project and it's going to cost $100 million, should Amtrak pay for the whole $100 million, or is there some small portion of it that should be borne by the freight railroad?
Thank you.
Chairman, members of the board, thank you very much for the opportunity to submit opening testimony, and I'm going to turn it over to Bill Mullins, who's going to come up and take my seat so that you can see him.
Thank you, Ray.
Before I begin, Matt Cross, did we fix the technical issues there in terms of the feedback? We did?
Yes, it's better. Thank you.
Okay, thank you. So Chairman Oberman and Vice Chairman Schultz, members Fuchs, Primus, and Headland. My name is Bill Mullins, partner of Baker & Miller. I represent Norfolk Southern Railway. I am joined today by my co-counsel, Don Donahoe of Burns and White. He is a very experienced trial attorney who's done many trials for Norfolk Southern. It's been an honor to work with him and to get to know him, and I've learned a lot from his experience. I'm also joined by my senior associate, Crystal Zorba, who's been an absolutely invaluable asset to the preparation of this case. So, members of the board, this is an historic occasion. It's historic in two ways. We are all participating in history. And I say that for two reasons. First, for the format. Never before in my 34 years of experience at the ICC and the STB has there ever been an on-the-record hearing in front of the ICC commissioners or the board members. I've also polled members of the transportation bar, people who have 50, 60 years of experience. They do not remember any such type of hearing. So you are setting history today. You're making history today. We all are. We're also making history today because this is the first application of 24308E to be decided by the STB. But we really shouldn't have to be here today. This could have been settled long ago. I say that because if you really think about it and look at the history, everybody agreed on the process. Every person who had an interest in this proceeding had agreed on the process. The Southern Rail Commission supported RTC. They've acknowledged the need for infrastructure. Indeed, they were awarded a CRISI grant to help pay for the infrastructure on any proposed Gulf Coast service. The Gulf Coast Working Group recommended use of RTC and recommended infrastructure. Amtrak, CSX, NS, all supported a process that used RTC, knowing that that would result in recommended infrastructure. In fact, the RTC model was almost done. Initial infrastructure was already being debated, and then Amtrak withdrew and eventually filed its access request. But even after Amtrak's filing, NS has consistently expressed its willingness to negotiate what is the proper amount of infrastructure and the process for moving forward so that none of us in the future have to come back to the board. Indeed, it was in that light that NS took one more shot at attempting to resolve this and asked for mediation. But of course, Amtrak rejected mediation. But this can still be resolved, but not until the hearing is over. So here we are. But this hearing need not be difficult, and it should not be contentious. There is a solution. The board and its decision-making should do what Amtrak refused to do, and that is accept the RTC model, order infrastructure to be built as set out in the model and NS's and CSX's evidence, and grant Amtrak its access. But only on the condition that the RTC model infrastructure be built and subject to the standard conditions that freights and Amtrak have always agreed to. Why is that the right decision? It is the right thing to do for 4 reasons. First, as noted, that is the process that Southern Rail Commission, Gulf Coast Working Group, and the parties, including Amtrak, originally agreed to follow and implement. Second, doing so is fully consistent with the long-standing precedent and process of how the parties have acted. In fact, you heard the testimonies of many third parties during the February hearings that RTC with infrastructure has always been the model and the process of negotiation in the past. And former NS and Amtrak CEO Wick Moorman's testimony comes to mind, as well as that of Virginia Congresswoman and Director of Rail and Public Transportation, Thelma Drake. That is a process that has always occurred. It can occur again. Third, granting Amtrak access with infrastructure is fully within the board's legal authority. As NS set out in its pre-hearing brief, this case in Norfolk Southern's view was brought under the wrong section. This was brought under Section E. We believe it should have been brought under Section A. But even if E is the applicable statute, Norfolk Southern believes that the board has the legal authority under E to impose infrastructure. And if the board has doubts, the board can invoke Section A to authorize that infrastructure. Indeed, Section E even has a specific reference to allowing the board to invoke A to set the terms. Fourth, the right thing to do to grant Amtrak access with infrastructure is because the facts support that. And you will hear that in today's hearing. For Norfolk Southern, you will hear from Randy Hunt and Holly Sincannon. Mr. Hunt is currently Senior Director of Interline Services at Norfolk Southern Corporation and has more than a decade's experience in working with Amtrak to either introduce new service or expand existing service. Mr. Hunt has worked on several Amtrak projects, including projects where Amtrak agreed to fund and implement $450 million worth of infrastructure. So when you hear 400 million, that's not unprecedented. It's been done before. It was been done as part of negotiations. In all of those projects in the past, it was a negotiation. And most of those projects, the infrastructure was put in place prior to expansion or the introduction of passenger service. In all of those projects, RTC was the accepted model. Mr. Hunt will also address the infrastructure projects required on the NS line to prevent unreasonable impairment. This includes the freight lead extension, which is a necessary component to prevent significant and substantial disruptions in the numerous interchanges among the 5 other Class I carriers that occur in New Orleans. You will hear from Holly Sincannon. She has significant experience in dispatching and modeling. She will point out how Mr. Dingler's RTC model, as independently verified by Mr. Banks and Mr. Guthrie, followed the same RTC process that Amtrak and NS have followed before. She will explain the importance of not just running the model, but the importance of doing field studies and interviews to determine what is actually happening on the line. All of her data was supplied to Amtrak. They had the ability to do an RTC model, and they should have done so. She will also note that in most of our RTC projects, infrastructure was recommended, and that without required infrastructure, there would be substantial and unreasonable impairment of freight operations. And as noted by Mr. Atkins, you will hear from Mr. Banks, Charlie Banks, who has worked on the rail industry for 50 years, a man I've known for about 30 years. I have the greatest respect for him and his firm. They have the greatest reputation for integrity and calling it as it is. It is because of that reputation that his firm has been hired by all sides. They've been hired by railroads, commuter agencies, passenger operations, Amtrak, government agencies, and freight customers. Part of the R.O. Banks team was Mr. Larry Guthrie. He has 50 years of railroad experience and has participated in somewhere between 50 and 100 RTC projects. R.O. Banks was specifically brought in to provide an independent and third-party analysis. In other words, to make sure that things were being done right. They'll explain how that model and its recommended infrastructure was the right process and was consistent with what happens in the industry. They will also confirm that failure to impose infrastructure will create impairments to freight service that no party could call reasonable. And as for Amtrak, here's what you will not hear. You will not hear that they did not model or analyze any impacts on customers, local traffic, the port's rail operations, or impacts to the dock workers who unload the ships. They did not analyze delays to public road crossings, impacts on rail employees, or environmental impacts. More importantly, they did not, until the very last minute, even attempt to address any impacts on the interchanges that occur in New Orleans among 6 railroads. They won't tell you that if you even ordered access tomorrow, it would take them 2 to 3 years to build the $66 million that has already been set aside for the specific infrastructure, and that this is the exact same time it would take for the railroads to build their infrastructure. So they can't get on the line without infrastructure. While they're building theirs, we're building ours. Get on the line. You will not be told that Amtrak has access to billions of dollars for expansion of new routes and the building of infrastructure. And they will not tell you that their model has never been used for determining whether freights and Amtraks can work together. And is primarily used in Europe for deciding whether to add passenger train to a passenger-centric operation. They will not tell you that failure to impose infrastructure will result in the freight railroads struggling to meet their on-time performance requirements while trying to meet the needs of the shippers. But what you will hear is that Amtrak deserves high reliability, high priority, and high speed. But Amtrak should not have to contribute to the infrastructure needed to accommodate such demands. In conclusion, this case should have and still could be resolved through negotiation, settlement, or board-sponsored mediation. But Amtrak is not willing to do that. Why? They want the precedent. They want the historic precedent. And I would ask the board to be careful. Remember that your decision is historic. If you impose access without infrastructure, that will set a precedent for the entire future. Such a decision will be putting the needs of Amtrak above those of the freight customers, the railroads, and their employees. This the board should not do. The statute allows you to impose infrastructure, and NS asks you to do so. Thank you.
Thank you, Bill. I have a few comments and questions. First of all, I think I appreciate your opening observations. I don't think I had been aware that not only in recent history, but apparently ancient history, and that deals with both your and my time on this planet. The commission or the board never actually conducted an evidentiary hearing itself. I was told it wasn't much precedent for this. All I can say is you have a very energetic group of 5 people, And we were very enthusiastic about fulfilling our obligation to hear this case. We're aimed at trying not to screw it up. And I say only partly facetiously that, like in any tribunal, we have to rely on the skill of counsel to make sure that we don't. And that applies to you, Ray, Jesse, and Rob in particular. I have a couple of questions. If you concluded that this case should have been brought under A rather than E, why did you not file a motion to dismiss?
Well, we did file a motion to dismiss
Well, but
and
not
jointly with CSX and
but
we
not
did
on that
drop it.
basis. Not on that basis. As I
Well, that's a long answer to the question. It was mentioned in that original filing of the motion to dismiss.
it was in a footnote.
Yes, it was in a footnote. You're correct. And it was clear by that time that most likely all the parties believed that E applied. We continue to believe E is not the applicable statute. And that is why we put that in the footnote of the joint filing. And we continue.
I have to jump in here, Bill. Sorry to,
Yes.
you didn't make that contention in the footnote. You said it might be more suitable. You didn't say one way or the other.
Well, we're making that contention now, and we're making that contention on our pretrial brief.
All right, I have you said that if Amtrak were going to build the $66 million worth of infrastructure that's been referred to, it would take it as long to do that as it would take the railroad to build its own infrastructure. What were you referring to? What infrastructure are you referring to that the railroad would build?
Well, whatever infrastructure you would order. I think the argument is that somehow if you order us to put in infrastructure or that Amtrak has to pay for it in order to be put in, that the argument that we make, which is that should be put in before Amtrak service begins, and Amtrak is saying, no, we shouldn't have to do that. We should give us immediate access. But their immediate access is contingent on putting on their own infrastructure, for which they already have $66 million for. So my simple point was that at the same time they're building their infrastructure, which they cannot run without that infrastructure, that we will have our infrastructure be built if you ordered it, paid for by Amtrak. And so that by the time the 2 years are up, the service can begin with all infrastructure.
Well, as I understand it, the only immediate infrastructure referred to, at least in the working group report, was the $5 million roughly for a station in Mobile. Would that take 2 years? Is that what you're referring? I'm just trying to figure out what you're referring.
That may take 2 years. They are not exactly sure where that's going to go. There's NEPA requirements to be done. They've been granted $66 million, and the Southern Rail Commission has, through a Chrissy grant and a matching, to put in recommended infrastructure. I don't have the list of all of what that $66 million is dedicated to, but that's there was I think a storage track that they needed to build that was needed to be funded. So there was a Chrissy grant that lays out exactly what they were going to spend that money on.
Is it, do you have a position as to whether, if the board orders any amount of infrastructure, it can also order the trains to begin at a certain point and the infrastructure phased in? Because in the papers, there's a great deal of reference to all of the projects have to be built before the first train runs. I'm wondering if you believe the board would have the authority to phase in whatever infrastructure might be ordered.
I believe if it's a part, Norfolk Southern would say this, if it's part of a board order, then it needs to be built before Amtrak access. And my point is that we can build that in the same time that they're building theirs, so that, you know, the immediate access isn't really immediate access, nor should it be. It should be contingent on infrastructure being built. But this is why it was so important that we should have used a process of settlement, a process of negotiation, because in those processes, as NS has done before in the past, there are proper instances where you can negotiate based upon certain timetables and certain contracts, a phased implementation. But that can't be done absent consent, specific provisions about when certain trains and schedules will go on. And so the board doesn't really have the legal authority nor the ability to impose that because they don't have the facts and the evidence and they're not part of the decision making.
Well, once we hear the evidence, do you think we have the authority to order a phased-in infrastructure?
I don't think the evidence that you'll hear will actually goes into the timing and the structure of when that infrastructure would be built. We know that it should be built or else we're going to be impaired in our freight service. So I would say that from the board standpoint and the evidence that you will hear and on your legal authority, that it has to be built before Amtrak service begins.
Do you have a position on the board's authority to order an apportionment of the cost of whatever infrastructure is ordered?
I think if this becomes an A case, which we believe it should have been brought under A in the first place, but even if you do decide it under E, we think that you could then convert this to an A case. And under an A case, you as Mr. Atkins pointed out, you do have authority if a project, if it's the evidence shows that a project is mainly or mostly or entirely for the benefit of the freight railroad, perhaps you have some authority, but that's what would be decided and debated in the context of an A case.
Do you, and I did not ask this of Ray, this idea of converting this to an A case, procedurally, how would you envision that would happen within the proceeding? Within this trial this week at a future date, how would that take place?
I think you have the ability to take the evidence that is in this case and you have ability to accept that into a record as a new proceeding under an A case. Then you have the ability of the parties to ask the parties to provide opening comments on whether or not this record is sufficient or whether or not additional information is provided, allow reply comments, and then you can make a full record based upon what was already developed in E. You can make that in the context of A. I don't think you have to totally start over. You just take this evidence and record, convert it to an A case, allow the parties to provide additional statements on the basis of what happens in an A case, and then issue a decision.
Well, so you are saying that we might not have to start over in terms of the evidence, but in terms of procedure, legal argument, briefing, comment, replies, we would have to establish a schedule for the parties to handle that under A if that's what we determine to do, which would involve some months extension of reaching a decision, would it not?
Mr. Chairman, that is correct. It would involve some months extension. Absolutely. It doesn't have to be lengthy. Proper time. It doesn't have to be a 2-year, 1-year A case because you already have the evidentiary record for most of it.
All right, I just have one other comment I want to make. There's already been a great deal of discussion and criticism by both you and Ray about Amtrak's mediation position or lack thereof. The board already made its views known on Friday on our view, very simply about our views about mediation. In my judgment, and I speak only for myself here, I think it is inappropriate. I don't think it's inappropriate for you and Ray to have raised the point, so I'm not saying that. But I think it is inappropriate for the tribunal to reach a decision on the evidence and on the merits based on whether the parties agreed or did not agree to mediate. In fact, in most courts, as you know, the trial judge is not allowed to be told which party refused an offer to mediate just for that reason. It's clear we've already know where the parties have come from, but for the record, in evaluating the evidence and reaching a decision on the merits, in my judgment, either the lateness of the railroads to ask for mediation or Amtrak's position that it doesn't want to mediate, at least at this point, should not play any role in our decision. May play a role in our decision whether to order mediation in the future, but that is a separate decision, not on the merits of this case. So I want the record to be clear. I see that Karen has her hand up, and I don't know if any other board member want to comment on that point, but Karen?
Not on that point. But Bill, you talked about Wick Mormon who's obviously served on both sides of the aisle, and I had the pleasure of working with him on a number of NS projects for the benefit of Amtrak, the Englewood flyover and the acquisition of lines in Michigan. I want to go back to my notes of what Mr. Mormon said at the beginning of this hearing a number of weeks ago. He said, with respect to RTC modeling, there are a number of principles. The parties must agree on assumptions and inputs. There must be transparency. The model must reflect existing operations. And then you add trains to determine what delays those trains might cause. And then finally, you analyze the impact of added capacity. Do you agree with those principles with respect to RTC modeling?
Absolutely.
Thank you.
Any other board members?
Yes, Marty, I have
Go ahead, Patrick.
Bill, if the board were to process it under A, would the totality of the agreement between Amtrak and the host railroads be subject to that proceeding?
The totality.
So an A, as you know, when the board has an A proceeding, the board is examining all of the issues in the agreement and not cabined off to say a particular question on a particular segment. So if the board were to engage in an A proceeding, would the entirety of the agreement be called into question in that proceeding, or would it be able to cabin off?
Well, I think the agreements would certainly come in and be part of the discussion. There are provisions in the agreement, without getting into specifics, that provide for Amtrak to get additional service. Amtrak didn't invoke those agreements. So there are agreements in place that govern proposed new service where certain standards have to be met if you're going to propose new service, and there has to be an agreement of the parties. If the parties can't agree, you go to A. So in that context, yes, the agreements would be part of that.
And so no provision within, as you know, the agreements are extensive, no provision in the agreement which can pertain to multiple lines would be off limits?
I don't believe so, but I haven't researched that, to be honest, member.
Okay, and then, Amtrak obviously filed in March of last year, and I just want to be absolutely clear on this point. Before Friday, over a year since they filed, did Norfolk Southern make any definitive statement in the record that this should have been an A case?
Before Friday?
Yeah.
No.
And can you think of another board case that was processed under a certain subsection and the board took legal argument about the standard and everything else required to satisfy a subsection and then changed course after a year?
I can't think of one off the top of my head, but I believe that has occurred before. Like, for example, well, in some ways, remember, folks, that's no different than what you do when you look at whether a merger should be minor or significant. You take the evidence, you look at the competitive analysis, and then you convert it to a significant versus a minor. I mean, I suspect that I could find a case that where they've done exactly what you suggested. I don't have one off the top of my head, but the board has the flexibility to determine how its statute should be applied and to how best to apply it.
Well, I mean, without belaboring the point, minor significant, there's a determination that's met initially. Wouldn't the proper analogy be that the board has made a designation, no party argued for a contrary designation? So suppose the board designated something as minor, no party definitively argued that it should be significant. The board then processes and goes through the entire procedural schedule. And then at the hearing, after all of the evidence is submitted, a party were to come in and say, no, this should have been significant. And the board has never done that, right?
Okay, I would say this, if that occurred and the evidence showed that, in fact, the competitive analysis at the end of all of the pleading showed that it was going to be highly likely anti-competitive issues, I think the board could, at that point, convert it to significant, because at that point, you didn't yet have the evidence. You now have the evidence. You're going to hear more evidence. And I think you could, but let me also think, I'm just thinking off the top of my head, how is this any different than when we take a notice of exemption or a petition for exemption? You've taken all the evidence on a petition for exemption or a notice of exemption. Let's say you've held a notice in abeyance and you've taken all these comments about the notice of exemption. You decided after the time, after all the evidence is in, you've said, you know what, this isn't appropriate for a notice of exemption, or this is not appropriate for a petition for exemption. And you have converted it to an application. You've done that time and time and time again. How is this any different of what we're suggesting?
You know what, Bill, I'm going to weigh in on that question because I think Patrick has raised a very appropriate point. The difference is that in the kind of case you just outlined, we then give the parties ample time to fill out an application. The concern I have is that if you're correct that this should have been filed as an A proceeding, that issue could have focused on and ruled on before the parties engaged in a year's worth of litigation, RTC modeling, discovery, et cetera. And at this late date, you know, everybody says they want to avoid delay. You know, I know that Amtrak didn't start this in 2006, but Katrina did. And to then say, now we should convert it to an A and then have a new pleading schedule does seem to me a little bit different because all of the other parties litigated this for the last year under the reasonable conclusion that this was proceeding as an E case. And the footnote that you alluded to hardly says to Amtrak, we should spend all of our time litigating this as an A case instead as we go forward. So I think there is a difference. We're not going to rule on the question now. It's an open question, but there is some equities involved here. And in terms of the public interest in getting this resolved, there definitely are problems raised by your now saying we should have done this as an A case all along.
I could say Mr. Chairman, I would say this in the case of this exemption analysis that I just brought up. I can think of many cases where there've been 6 months, 8 months of litigation over whether something should be a note or, you know, comments filed on whether something should be a notice or a petition for exemption. And after the end of say a 6, 8 month, 9 month process, the board has said, you know what, this isn't a petition for exemption. Go file an application. And when you go file an application in that instance, there's statutory requirements that then require, for example, an abandonment, a whole nother long 4 or 5 month process.
Well,
so
I don't want to belabor it.
Sure.
The difference is that under that scenario, everybody knows they're litigating whether an exemption is warranted. We could have spent, I would have hoped we wouldn't have, 6 months briefing whether this should be A or E. Everybody would have at least known that's what they were litigating. They haven't known that. And I'm not sure, you know, continue to litigate it, but we understand your point.
I do understand the point, Marty. And I do also want to mention that I think to my first question, you know, in terms of rolling over the evidence, it seemed to me that Bill was suggesting that if no issue within the agreement is off limits, it seems to me that there would be significant additional evidentiary processes if it were an A case. Bill, unless I'm misunderstanding that.
Well, certainly not on the evidence. I mean, the evidence is pretty much already on the record. You could have an argument as to whether a certain provision of the contract is met by the evidence. Of course.
But if no part of the agreement is cabined off and parties want to argue over other sections of the agreement, as they do in A cases, that might require additional evidence to be taken, right?
It might, yes. But
so I only wanted to make the point that just the rolling this over into an A case, not only have we spent a year arguing for one standard that no party ever suggested to the, I should say, made a definitive statement to the contrary, but it's also the case that converting it to an A case is not so simple because A involves more issues.
Can I make another suggestion? And a point well received, Patrick. I would say this. There's also another option, one that hasn't even been debated or on the table, which is, why doesn't the board say, why don't Amtrak go under the contracts? Read those agreements. Amtrak has the right under those contracts to ask for additional service. And then if the parties don't agree, there's an arbitration provision. We could have been filing motions to dismiss on the basis that this should go under the contracts, not A, not E, but under the contracts. Now, the weakness of that from an NS standpoint is that the contracts do not allow us to, it's Amtrak that is the one that has to initiate to come to us to say, we're invoking provision XYZ to ask for additional service. And then we have to say yay or nay and agree. And then if we can, it goes to arbitration. Amtrak skipped all of that. They didn't want to go under the contracts. Why did they not want to go under the contract? Because they want the historic precedent of we can just get on a line whenever we want and we'll deal with infrastructure later. That's what they want. And I'm saying that's not good policy. And I'm saying that's not something you should do for the next 50 years. So whether it's make them go under the contracts, whether it's make them go under A, or whether you use your inherent authority under E as advocated by Ray Atkins, I would say it's access with infrastructure.
Thank you.
Thank you, Bill. Okay. Are there any other questions for Bill?
I have a comment about how this maybe has all come down over the last couple of years. When this dispute started, wasn't entirely clear where the money was going to come from. Amtrak just can't pay for this stuff out of its own pocket. And a comment that I made at last week at the APTA Rail conference in Philadelphia, entitled Connecting American Cities, is that the Congress has now given us $66 billion for rail. And some of that's going to go to the Northeast Corridor that's cabined off, and some of it may go to entities like California High-Speed Rail that has its own right-of-way, but most of this money is going to go on our freight railroad system. I was surprised that almost nobody from the freight railroads was there to hear the representatives of FRA talk about how it's all going to be administered. So I just want the parties to now keep in mind that there are opportunities for funding additional projects if the board deems they should be funded that haven't existed. But that window is going to open and shut real fast. Excuse me. There's going to be a lot of competition for that money. So I think we should look for the quickest resolution we can find to this dispute so that the parties, I don't know what's happening in my voice, can access that money that the Congress is making available. Thank you.
Chairman Hamlin, can I react to that and say that I couldn't agree with you more? There is money available. We don't understand why the insistence of we don't want to use that money here to pay for the infrastructure. And I would say one of the quickest way to get this done is to have board-sponsored forced mediation and let the parties hash this out.
Well, let me just, I want to weigh in
Marty?
on this. I'm sorry, Michelle, go ahead. And then
I just had one quick question. If you were following up on Karen, go ahead. I didn't know if you were moving on.
No, go ahead. I was just going
Bill, just to follow back up on Patrick's question, if the board would decide this case under subsection A and the agreement would come into play, would the board have the authority to limit the scope of consideration only to the lines at issue, or would it open up the contract in its entirety?
It would only be the lines at issue in our opinion. And I think if you go back to, the Guilford case in 98 and then the CN cases, it's really just the line at issue and not the contracts as a whole, not the network as a whole. It's the line at issue.
Thank you.
any other board member have a question? I'm just going to make a couple of observations as we go forward. We're here in a proceeding under E. I would ask council from this point forward to focus your attention on E, unless the board asks some questions about A, but arguing this should have been under E, could have been, should have been under the contract are interesting points, but they don't advance our ability to adjudicate the proceeding that's in front of us. And it's an open question about how many late new arguments that haven't been raised in the last year we should entertain at this point. The only other observation I'm going to make, because it keeps getting mentioned here at the beginning, and including by board members, is that there's plenty of money. It's taxpayers' money. That doesn't mean that the spigots are open. If we have the authority to order infrastructure, and I'm only speaking for myself, we don't spend the money, that's some other agency. They may well be influenced by whatever conditions we order. And we shouldn't just open the spigots and say, well, there's $1.2 billion, so let's build gold rails along the Gulf Coast. So let's just keep that in mind, that the evidence in this case, when I know the parties contend this, but is on what's needed to meet whatever the statutory standard is, which still hasn't been defined by the parties yet. In fact, there's plenty of money out there, to me, is actually not even relevant. May be relevant, but it's certainly not the central issue in this case. So I don't want to dwell on it any longer, but we have a long proceeding to go into, and I think I've allowed us to get a little bit off track more than I should have, and I'll take responsibility for that. If there are no other questions for Bill, let's shift over to to the port. Rob Wimbush.
Good morning, Mr. Chairman. Can you hear me?
I can hear you.
Okay. Chairman Oberman, Vice Chairman Schultz, Member Primus, Member Headland, and Member Fuchs. Phrase I'm about to use here is one I never thought I would be using before this agency, but may it please the board. My name is Rob Wimbush, and I am appearing today on behalf of the Alabama State Port Authority and its Rail Common Carrier Division, Terminal Railway Alabama State Docks, or collectively the port. I am joined here today by my co-counsel, Jim Hellenhaus. Today's hearing is indeed significant, is a significant point in the history of this agency. This proceeding is unprecedented. It is of potentially far-reaching significance. And perhaps most of all, it is unfortunate. Over the years, Amtrak and its freight carrier hosts have had their moments of friction, to be sure. But as a general rule, they have worked toward accommodations that reasonably have balanced the interests of all stakeholders. And here, missteps along the path have triggered hard feelings, immoderate posturing, and impatience that underlie Amtrak's application. Such hardline, winner-take-all confrontation has eclipsed the principle, in our view, that redoubled effort toward a collective accord is the best path to advance the public interest in both interstate freight commerce and intercity passenger service. Frankly, it should never have come to this. To be sure, observers quickly would have noted that a dialogue among Amtrak, CSX Transportation, and Norfolk Southern Railway over the return of Gulf Coast passenger service got off to an admittedly rocky start. From there, it seems that the freight carriers and Amtrak have harbored very different perspectives on the obstacles to a mutually acceptable accommodation. But the path remained open for a negotiated resolution, including under a process potentially overseen by the good offices of this board, be it mediation or under some other format. This is precisely the path that the port long has advocated for, and the port has continued to urge throughout this proceeding. Unfortunately, that was the path not yet taken, at least not yet. Rather, Amtrak has insisted upon litigation driven by impatience, retaliation, and frankly, an outsized sense of entitlement, revealing Amtrak's complete disregard for railroad freight transportation and, in turn, interstate and international supply chains. Recently, as this past Friday, Amtrak told us that it believes that it is entitled to an order from this board directing CSXT and Norfolk Southern to facilitate Amtrak's Gulf Coast service even if that order would impair unreasonably railroad freight transportation. And in so doing, Amtrak also recently reiterated that it is unwilling to commit to a single dollar to railroad freight service protecting infrastructure. That is hardly a conciliatory or reasonable gesture, and it is a harsh signal to all others of whom Amtrak may in the future demand access for new or additional train operations. Ford has only ever wanted to engage in constructive and fair dialogue with Amtrak and other stakeholders having an interest in Amtrak's service proposal. It reasonably has expected that Amtrak would afford the port's concerns and mitigation proposals due attention, and that Amtrak would be willing to explore arrangements accounting for the port's important and growing role in domestic and international commerce. Instead, Amtrak has made it clear that it is not interested in the port's concerns. Consistent with this stance, Amtrak has insisted that the board should ignore the port's evidence and argument, even if the port were to demonstrate that Amtrak's proposal would unreasonably impair the port's freight railroad operations. And incidentally, the port will demonstrate in this hearing that Amtrak's proposal, if granted, would unreasonably impair the port's railroad operations. It is troubling also that passenger rail advocates aligned with Amtrak have falsely and without basis claimed that the port is categorically opposed to Amtrak's Gulf Coast service proposal, despite the port's repeated and genuine explanations that it would not oppose such passenger service if implemented responsibly. As you may have grasped, the port is unhappy to be taking part in this hearing today. It is unhappy that it has been pulled into the vortex of avoidable and costly litigation. By now, board-sponsored mediation would certainly have narrowed the issues if it did not resolve this dispute entirely. But Amtrak, and Amtrak alone, has refused this path. The port knows that it cannot stand by when Amtrak's zero infrastructure proposal would do grievous harm to port operations. The port, for example, cannot stand by when Amtrak repeatedly has expressed indifference at best to the port's concerns. It cannot stand by when Amtrak repeatedly has insisted that this board should simply ignore the port. And it cannot stand by when Amtrak contends that the port is not legally entitled to board protection, even if its railroad operations were to suffer unreasonably. It is for these reasons that the port has no choice but to defend itself and its interests. If nothing else, the port is buoyed by the understanding that other ports, terminal railroads, and short-line railroads are watching this proceeding. Those same observers know that appropriate board action will moderate Amtrak's strategy in future cases and bend the passenger carrier to constructive and conciliatory engagement. So the port has left to press its case, and it will do so, knowing that if Amtrak's application were to be granted, this board, not CSXT, not Norfolk Southern, and not Amtrak, but this board will have, as a consequence, allowed port railroad operations to be harmed substantially, disrupting supply chains, snarling international traffic, and extensively delaying interline railroad shipments, among other things. The collected record evidence in this proceeding already clearly militates in favor of denying Amtrak's short-sighted and draconian application. Specifically, CSXT, Norfolk Southern, and the port already have demonstrated to you that Amtrak's proposal would do definite and massive harm to the port's railroad operations, just as it would harm freight operation on other parts of the affected service corridor. In the evidence it will present in this hearing, the port will prove as follows. Amtrak is indifferent, if not hostile, to the port's concerns. The port's railroad operations are heavily dependent upon CSXT corridor in Mobile, including portions of the CSXT line in Mobile, over which Amtrak intends to undertake 8 daily train movements. The port railroad operations are complex and varied, and they require extensive track time over CSXT lines that Amtrak now proposes to use in the capacity of a first priority carrier. Amtrak's proposed operations will render the port railroad's daytime cross-corridor operations an impossibility, even though the port railroad is currently and by necessity, a 24-hour operation supporting customers, stevedores, and various connecting railroads. Amtrak's own extremely limited evidence dealing with the port's railroad operations actually shows that the Mobile terminal will face significant congestion. A point further exploration in this hearing will reveal is far more consequential than Amtrak would care openly to admit. In fact, Amtrak's traffic scheduling witnesses acknowledge that remedial steps, including additional Mobile railroad infrastructure, would be advisable in the face of Amtrak's service proposal. Also, the evidence offered by CSXT and Norfolk Southern, most notably through its RTC modeling of freight traffic impacts analysis, will once again demonstrate potentially catastrophic port railroad service deterioration. In short, the evidence clearly will show that the port's railroad operations, involving tens of thousands of carload and container movements each year, will be impaired unreasonably under Amtrak's zero infrastructure service proposal. Because Amtrak has insisted that it cannot wait and will not deviate from its current demands, the board has no choice but to deny the application as Amtrak has presented it. But Amtrak has a choice to avert denial of its application. First, it can jettison litigation in favor of collaboration, mediation, and negotiation. Second, if it continues to think that an adversarial process is more in its interests, then Amtrak can and should pursue relief under 49 U.S.C. Section 24308A, a provision that can accommodate board-imposed infrastructure, unlike the current proceeding. There is some very limited reason for hope, however. Amtrak has very recently reached out to the port, asking about potential terms of an agreement under which the port might withdraw its current objections. It is not clear to us whether Amtrak is genuine in its outreach. There has been little more to this development than a handful of preliminary emails. Perhaps there will be more progress on this front, but that seems rather unlikely when Amtrak has devoted its energies to litigating the issue. Thank you. That concludes my opening statement, but I understand that you were interested in me perhaps addressing the enumerated issues from the board's March 13th order, and if you'd like me to do that, I can proceed to do that now.
Please do.
Okay. First of all, board members, the first two questions that were posited in the March 14th order, items 1 and 2, are ones that we have chosen not to address. They are not pertinent to issues of relevance to the board as they relate to contract relationships among CSX, Norfolk Southern, and Amtrak. And so we express no opinion or view on items 1 and 2. With respect to items 3 and 4, I would like to respond categorically by pointing out that this is a proceeding that Amtrak chose to initiate under Section 24308E and not under Section 24308A. Similarly, in its order from August 6th, the board initiated a proceeding that was specifically under Section 24308E. Consequently, it is our position that questions regarding 24308A's remedial provisions are premature and that the board does not have before it a Section 24308A proceeding. So categorically, with respect to Sections 3 and 4, I would like to state, as I think the board has made clear throughout, that if these issues are to be explored, that is the scope of potential remedial action in the board's prescriptive authority, that presupposes a proceeding that does not now exist, proceeding under Section 24308A. But let me be clear, 24308E does not contain any provision and does not entitle this agency, and historically has not entitled the Federal Railroad Administration, who was previously entrusted with 24308E, to impose infrastructure as a condition to a request for access. Specifically, here, Amtrak has presented you with an application. That application asks for access with zero infrastructure. Your decision here is based on Amtrak's application as presented, not on some hypothetical and not on a non-existent 24308A proceeding. That is not to say that Amtrak could not have initiated a proceeding under Section 24308A at an earlier phase. It could have chosen to do so. It chose not to do that because it has staked itself to a position that no infrastructure is required. If the board agrees, the board can order access under 24308E. If it is inclined to think that infrastructure is appropriate, to us, that signifies that this particular application before the board should be denied. As to issue number 5, you've asked again about sharing and costs, and I think consistent with the points I've already made here, Section 24308A is not before us, and so I think the question you've asked may be premature. That is the port's position. Again, I think you need to take Amtrak's application as it's been presented. But for the sake of preliminary discussion on the subject, we believe that longstanding precedent would establish that if you determine that infrastructure is required as a precondition for Amtrak's access to these lines, if that is required as a precondition, then longstanding precedent would establish that Amtrak is the but-for cause for those infrastructure requirements. And as such, Amtrak should be required to fund 100% of those infrastructure conditions that you may choose to impose under a Section 24308A case.
I'm sorry, were you finished?
I am. Thank you, sir.
Yeah, thank you. Couple of questions. First of all, let me make an observation. You opened up by saying you were sorry your client had to be here. I've never met a litigant who wanted to be in court, so I don't think you stand in an unusual position to the extent it's like a court. But I want to be clear. Your position seems to be very different from that offered by Mr. Atkins and Mr. Mullins, that we have the inherent authority under E to condition an order allowing access on the built infrastructure. You think we do not have that authority under E. Our only authority is if infrastructure is needed to deny the petition. Presumably then Amtrak could file a new case under A. Is that your position?
That is correct.
All right. The only other question I had is that you've referred to early on that late last week, I think you said Amtrak announced its position, at least to you, that it was entitled to access its 4 trains, even if the evidence showed unreasonable impairment. Is that what you said?
Yeah, that is correct. That is actually reflected in Amtrak's filing from April 1st, from this past Friday.
Well, that
I
was
know you haven't had an opportunity to read that yet, but it is contained in their brief from April 1st.
Well, that was my question. That statement, which you contend they made, that's in the record someplace.
Yes, it is in the April 1st filing that Amtrak tendered. They have argued there in response to, I think it's your question number 4, that even if you were to find that there was unreasonable impairment, that you could nevertheless order access in light of that finding, because the unreasonable impairment is not an absolute bar to a favorable order in favor. And Amtrak can speak to this better than I can. I'm simply characterizing the way I read their brief, so I want to be clear about that. But they did say at that point, as I read their brief, that even if there was an unreasonable impairment finding, that did not preclude a favorable decision in favor of Amtrak, and that the impairment issues could be sorted out later.
Okay, well, that was my question. Where was that in the record? And you've answered it. Karen has a question.
I recall that in the statements made at the earlier part of this hearing a couple of weeks ago, you or someone else from the port criticized FRA for, quote, not having paid any attention to the port. I also understand that just about that time, the port received a $25 million grant from the Department of Transportation. You don't have to respond to this now, but at some point I would like to know what that $25 million is going for in terms of improvements to the port, and does any of that affect the rail access to the port?
Commissioner Headland, it happens that of our two witnesses for this proceeding, one of whom is the chairman, the CEO of the court, John Driscoll. We can certainly be prepared to address that during his examination when our turn comes.
Thank you.
All right, any other questions from any board members? All right, we have one more opening statement. We've been going a little over 2 hours. How's our court reporter holding up?
I'm good, thank you.
How do the board members feel about Amtrak's opening statement and then taking a break, or should we take a break now?
I'm good with the opening statement, Marty.
Too.
All
Me
right,
too.
Michelle?
I'm good, Marty.
All right. Ms. Amundson, you are on.
Thank you, Mr. Chairman, and good morning to you, Mr. Chairman, and to members of the board. Jessica Ring Amundson, and I have the honor of representing Amtrak in this proceeding. I'm joined by my colleagues, Kali Bracey and Alex Trepp, who will also be participating in this hearing. On behalf of Amtrak, at the outset, we want to thank the board for its diligence and thoughtfulness throughout this proceeding. And we also want to very much thank your staff who have worked very hard to make sure that this proceeding goes off without a hitch. And we greatly appreciate their efforts to work with us. As you heard in their opening statements, CSX, NS, and the port have tried to turn this into a case about RTC modeling and infrastructure improvements. But this is fundamentally a case about Congress's vision for the national passenger rail system and whether private railroads can essentially exercise veto power over that vision by making inordinate capital demands. Amtrak does not believe that the private railroads should have that power. Amtrak has a statutorily mandated responsibility to bring passenger rail to underserved communities, and Amtrak has embarked on a national strategy to carry out that responsibility. CSX and NS want to preserve the status quo, but that is not an option for Amtrak. And it's important for us to just take a step back for a moment and remember what Amtrak is. Back in the late 60s, freight railroads were losing hundreds of millions of dollars in providing passenger service. Railroads were going bankrupt. Congress realized something had to be done, so it enacted the Rail Passenger Service Act of 1970 to, quote, relieve the freight railroads of further responsibility to provide passenger service. With the act, Congress shifted financial responsibility for providing passenger service from the freights to the federal government by creating Amtrak. However, there was a quid pro quo for the enormous financial benefit conveyed upon the freight railroad industry. Freight railroads were allowed to exit from providing passenger service only on the condition that they agree to allow Amtrak to operate over their lines, that Amtrak pay only incremental costs for doing so, and that Amtrak trains would have preference over their own freight trains. CSX's and NS's predecessors accepted that bargain, and CSX and NS have inherited it. Of course, Congress understood that running passenger service on rail lines owned by freight carriers would impact freight rail service. And of course, Congress understood that giving Amtrak preference over freight transportation would sometimes cause delays to freight railroads or require them to alter their own operating plans. That was the whole premise of the bargain Congress struck. And 10 years after the Rail Passenger Service Act, Congress enacted new legislation to emphasize that it meant what it said about the obligation of the freight railroads to allow Amtrak to operate passenger service, including when Amtrak wanted to run additional passenger service on freight lines. That is the statute at issue here, now codified at 49 U.S.C. 24308B. And if we can just pull up the House report 96-839, you can see how this legislation unfolded. Page 32 shows that the original legislation simply said that when Amtrak notifies the FRA that it's unable to reach voluntary agreement with a rail carrier to operate additional trains over that carrier's track, it shall notify the FRA. And the FRA shall order the carrier to allow Amtrak to start running within 60 days at the fastest possible operating time. There's no mention of unreasonable impairment here. Instead, it just recognizes Amtrak's right to operate. And the committee explained why at pages 20 to 21. It says that the committee, quote, remains concerned about the lack of cooperation private freight railroads have demonstrated toward Amtrak, specifically by refusing to permit Amtrak to operate additional passenger trains on a densely populated corridor. And so Congress said, quote, to enable Amtrak to secure expeditious relief from such intransigence, the reported bill contains a provision which enables Amtrak to obtain an order from the Secretary permitting the operation of additional passenger trains over the lines of freight railroads which have contractual agreements with Amtrak. The legislation then went to conference. And if we can bring up House Conference Report 96-1041 and go to page 42. You can see that the conferees agreed with the legislation, but no doubt after some lobbying, now say that the Secretary can consider whether an order would unduly impair freight operation, with the carrier bearing the burden of showing such impairment. And here is the key paragraph. The Congress is concerned that in the past, Amtrak's efforts to add or modify service have involved protracted arbitration proceedings and have often prompted requests by the railroads for inordinate capital improvements, which are paid from appropriations authorized for Amtrak's operating expenses. It is important that Amtrak have available to it an expedited procedure for making necessary modifications or additions to its operations. The conferees have agreed that rather than being absolutely constrained, the Secretary should have discretion to take into account any serious adverse impacts on a railroad's freight operations, which may result from additional service. However, it is the purpose of this provision to ensure that such service may be added where no significant impairment of freight operations is demonstrated. And you can take that down. So you can see that the default here is to order that Amtrak can add trains unless the freights show they will suffer serious adverse impacts. As the statute says, the board has discretion to consider whether the service would cause unreasonable impairment. What does unreasonable impairment mean? CSX and NS have told you what that standard means, and we accept the definition that they offer at page 14 of their rebuttal brief, where they say that the standard they must meet is to show that the addition of Amtrak service would, quote, make worse or do harm to freight transportation in a manner exceeding the bounds of reason or moderation. And let's take a look at what they say exceeds the bounds of reason or moderation. Primarily, it's the possibility under their RTC model that when Amtrak's passenger service is introduced in their model, freight train speeds could decrease from 14.8 miles per hour to 14.1 miles per hour. That is what they claim exceeds the bounds of reason or moderation. To meet their burden under the statute, they offer the board merely a series of percentages about what their RTC model says about how their freight transportation hypothetically could be impacted in things like modeled freight train delay per 100 miles, or modeled dispatching conflicts, or modeled potential need for recrews. But as you will hear from Mr. Tom Crowley and Mr. Daniel Pfaff of Peabody and Associates, those percentages are much less dramatic when converted into real numbers. CSX and NS nonetheless repeatedly claim that their freight transportation will be, quote, degraded. It's unclear what they mean by this degradation standard or where it comes from. Again, of course, Amtrak service will have some effect on their freight transportation. Again, that is the whole premise of the bargain Congress struck. But will Amtrak service cause the Carter to grind to a halt? No. And CSX and NS admitted this in their February 24th filing. You will hear from Mr. Fapp and Mr. Crowley about the many flaws with the RTC model that CSX and NS offer here as their only evidence of unreasonable impairment. But perhaps the most important thing to remember is what CSX and NS say about what it is their RTC model was trying to achieve. And this is a quote from page 49 of their opening evidence. Their RTC model was designed to come up with enough infrastructure recommendations such that, quote, no aggregate freight service delays would result, no schedules would be adjusted, and passenger service will achieve a 95% on-time performance rate. That is not a model that is trying to determine unreasonable impairment. That is not a model looking at whether freight transportation has been harmed beyond the bounds of reason or moderation. That is a model designed to gold plate a railroad. Even though they admit that introducing Amtrak service now would not cause the Carter to grind to a halt, you've heard CSX and NS say it's not about what happens now. It's about what might happen 20 years from now. But if every time Amtrak wanted to add or modify service, Amtrak was required to fund infrastructure to avoid all hypothetical impacts on hypothetical freight traffic that hypothetically might exist 20 years from today, Amtrak's right and obligation to expand passenger service would be a nullity. And a 20-year horizon is clearly not what Congress contemplated in the statute. Congress said it wanted an expedited procedure for Amtrak to add service immediately. It told the board to hold a hearing or explain why it wouldn't hold a hearing within 30 days. And it said that after the hearing, the board should order that service can start within 60 days. Congress said nothing about looking at what happens in 20 years. Congress said nothing about conditioning an order for passenger service on infrastructure to mitigate hypothetical future impacts. Congress said nothing about requiring RTC modeling as a prerequisite to adding service, or indeed about requiring any type of modeling. All of these are requirements that the carriers have sought to engraft onto the statute. But if the carriers want to amend the statute, that is something they need to take up with Congress. They cannot amend the statute in this proceeding. This statute is about adding Amtrak service now. Infrastructure. There's been a lot of talk in this proceeding about infrastructure. And on this, the parties are very far apart. CSX and NS say that Amtrak has to fund $440 million in infrastructure before Amtrak can run a single train. That is certainly an improvement over the position that CSX took in the Gulf Coast Working Group, that it would cost at least $1.1 billion and perhaps up to $2.3 billion before a passenger train could run. But even insisting on $440 million to construct 14 different projects is effectively a veto of passenger rail service. And I think it's important to recognize what CSX and NS are really asking for here. They want $440 million in public funds to build or improve infrastructure that they, as private companies, will own. They will own that infrastructure, including the longer sidings that only need to be constructed because they're running longer trains, regardless of whether the Gulf Coast service is still operating in 20 years. They want $440 million in public funds to address the potential for increased delays in places where they admit they already have significant delays. And they have demanded that Amtrak provide them $440 million in infrastructure for their freight operations without so much as considering first whether there might be lower cost operational efficiencies, schedule changes, or technology solutions. $440 million is about $3 million a mile for this route. If CSX spent $3 million a mile on infrastructure for its 21,000 mile network, it'd be spending $63 billion rather than the $2 billion Mr. Foote told you they were spending when he appeared before you last month. Think about that. CSX spends $2 billion a year on infrastructure for 21,000 miles, but they want public funding of $440 million for this roughly 150 mile stretch. That can't be right. Amtrak has shown, and as you heard Mr. Atkins say here today, they have conceded that there is sufficient capacity on the corridor to accommodate passenger service right now. You will hear from Mr. Clayton Johansson about our capacity study. And where there is sufficient capacity, the railroads can operate efficiently. We believe that it's now been 16 years since Amtrak service last operated. There have been 6 years of working groups and studies. There have been 3 RTC studies. There have been 2 statutes from Congress exhorting the parties to find out a way to get this service to run. And now there's an STB proceeding. Enough is enough. One final word about the statute. The statute charges the board with determining whether there's unreasonable interference for the carriers over whose line Amtrak seeks to run. As the parties have stipulated, the port is not a carrier over whose line Amtrak seeks to run. Amtrak certainly recognizes that the port is an important stakeholder in this proceeding. And Amtrak is certainly willing to engage with the port as an important stakeholder in this proceeding. But the board is not charged under the statute with determining unreasonable interference for anyone other than the carriers over whose line Amtrak seeks to run. Amtrak also recognizes that the board has heard from a lot of stakeholders in this proceeding with a lot of views about what the board should do. And Amtrak recognizes that the board spoke at our pre-hearing conference about its views that it needs to protect the public interest in this proceeding. Here, Congress already said what was in the public interest in 24308E. And that is for Amtrak to have an expeditious procedure to add passenger service to overcome the intransigence of freight railroads who are imposing inordinate capital demands. Amtrak believes that if the board follows the plain terms of the statute and congressional intent, it should order the Gulf Coast service to start. I'd be happy to address, if you like, the questions that we briefed in our Friday filing. First, at the outset, it's Amtrak's position that 24308A is not implicated in these proceedings. This is a proceeding brought under 24308E. 24308E3 says that unless the parties already have an agreement that establishes the compensation for such service, the board shall decide the proceeding under A. Here, the parties already do have such an agreement. When Amtrak initiated It's outreach to both CSX and NS. Amtrak proposed both a schedule for this service and compensation for this service in accordance with its operating agreements with both CSX and NS. The second point I want to make with respect to our Friday filing is to make clear that the parties' agreements treat infrastructure costs very differently from operating costs. And so the costs of maintenance for infrastructure are handled one way, while the costs for operating infrastructure are handled another way. And then finally, we would agree with what Mr. Wimbish just said, that 24308E does not give the board the authority to order infrastructure. And if the board has questions, we'd be happy to answer them.
Yes, thank you, Jesse. Jesse, I don't know you as well as the other lawyers, so I hope you don't mind. If I use your first name, if you do.
That's fine, thank you.
We're going to know each other pretty well after this week, I think. But thank you for your presentation. I do have a number of questions. I'll try to take them in the order that I made some notes here. Is it Amtrak's position that the words that ended up in the statute, unreasonable impairment, are equivalent to words you found, I've seen them in the legislative history, serious adverse impacts, and there was one other phrase that you mentioned, no significant impairment or serious adverse impacts. Is it Amtrak's position that the statutory words unreasonable impairment are equivalent to those words?
We think those words certainly inform the unreasonable impairment standard, but as I said, we're willing to accept the unreasonable impairment that CSX and NS have put forth in their brief.
All right, well, they put that forth in their rebuttal, as you pointed out, not in their opening statement, which I noted, what you noted about no degradation at all seems to be where they were going. Well, obviously, get into that. I think with the witnesses, you were the only attorney who addressed the question of defining unreasonable impairment, and even using the language from CSX's rebuttal about exceeding the bounds of reason or moderation. Is that, I don't have the brief open.
Yes, that's correct.
Is that right? It's a little bit circular. The bounds of reason and reasonable don't get me much beyond that circle. And one question I'll ask you now, and I don't want to bring the others back up here, but I think should be addressed as we go through the hearing, is how are we supposed to measure reasonableness in other contexts in the law? For example, we all learned in law school that negligence is measured by what would a reasonable person, we used to be reasonable man, but what would a reasonable person do under the circumstances? So you can look to other kinds of behavior to measure it. So for example, by measuring reasonable impairment, are we supposed to look at other rail lines, similar rail lines, all rail lines, other rail lines of this carrier only? That's just one possible question, but nobody has addressed this as to what to put. We've got a lot of metrics. We don't know what to put them up against. Do you have a position on that?
Yes, Mr. Chair, and I think that's a great point, and that is one of the points that we have tried to address, which is if Amtrak operates, what Amtrak is seeking to operate here is 2 round-trip passenger trips a day on a freight line that has about 12 trains per day. And Amtrak operates throughout the nation, much more frequent passenger service on lines that have much more freight service. So by comparing what Amtrak is doing here to what Amtrak is doing throughout the country, it's quite clear that this is not unreasonable impairment of freight transportation, nor could it be. And you'll hear from Amtrak's witness, Mr. Jim Blair, who will talk about Amtrak's experience throughout the country in operating service on far busier lines, including lines owned by CSX and NS.
Well, I think, excuse me, I think it would be enlightening to compare the metrics which are being put forward. I think it'd be enlightening for CSX and NS to compare them to metrics in other situations, and not just that you have, we know you have passenger service in other parts, but I think they're asking us to look at the delay, so forth. So I guess I'm just raising this, that I hope all witnesses will address themselves to that analysis. You said that Mr. Atkins today and in their pleadings before, CSX has conceded that the line can accommodate passenger service. What were you referring to?
I was referring to what Mr. Atkins said in talking about the DB study, which is that there is sufficient capacity on the line right now to operate 4 passenger round trips. So it's conceded that there's sufficient capacity.
I heard him say that that was not the study that should be relied on, however, because it's not an RTC study. So I don't, he conceded that there was a study, but I don't think he conceded that. You said he conceded that the line can accommodate passenger services.
Yes, I believe those were his exact words, that the line could accommodate passenger service. And I think his point was that, but you know, sort of at what cost? And our point is that Congress gave Amtrak a right to operate passenger service on freight lines. There is capacity to accommodate the Amtrak service on the freight lines. What the freights want to do is not have to alter a single thing that they are doing right now. And that's what their RTC model is designed to do. They don't consider, for example, whether they can operate more efficiently, whether they could adjust a schedule 5 minutes to better accommodate passenger service. They just want to keep operating exactly in the status quo. And so the fact that there is sufficient capacity, the parties should be able to use that capacity efficiently to make sure that Amtrak service and freight service can both run reliably.
But it's fair to say that, so just to be clear, you're not referring to a pleading and whether any concession is made. I just wanted for the record to know you're talking about his opening statement this morning.
Well, I believe that in CSX's and NS's February 24th response to Amtrak's SAR rebuttal, they did concede that there was sufficient capacity on the line to accommodate.
All right, we'll take a look at that. I appreciate that. By the same token, I don't find anything in Amtrak materials pointing out changes in scheduling or operational plans that would reduce any negative impact on freight railroads. You haven't submitted any such details yourself, have you?
Well, you'll hear from Mr. Clayton Johansson of DB about how what their methodology is designed to do is to show that where there is sufficient capacity, you can in fact consider things like operational changes or technology changes that will allow, like I said, freight and passenger service to both run reliably on the line.
I understand you're saying you could put it in the abstract, but in terms of specific operational or technological mechanisms, you haven't offered any specifics to say if you do X or do Y, then the running times will be better and so forth, have you?
We have always indicated a willingness to work with CSX and NS, but no, in this proceeding, there's nothing that I can point to specifically in the record that says adjust the schedule 5 minutes. We've asked CSX and NS to consider schedule changes and been rebuffed.
Well, I'm only asking because if we're going to make a decision on this record, you indicated that we shouldn't be taking into account hypothetical operations 20 years in the future, and I don't know how we can take into account hypothetical operational changes currently if they're only hypothetical So I just wanted to be clear whether we'll see anything in the record on that. And we'll let the witnesses go as far as you think the record can take them without objection, unless there are objection.
Certainly, you'll hear in the record sort of what the line looks like right now, and Amtrak's past experience in operating on that line, and Amtrak's experience throughout the country in operating on much busier freight lines with much more passenger frequencies. And so the idea that this is unreasonable impairment when you compare it to Amtrak's experience nationwide just is not possible.
All right, next question. Mr. Wimbush said, and I haven't read it, as I said, I think we just got it this morning, that in your April 1 filing, you took the position, Amtrak took the position that that it was entitled to have us order the trains on the line, even if unreasonable impairment is shown by the railroads. Is that your position?
Our position is that the plain text of the statute does not make unreasonable impairment a bar to ordering service. And so if you look at 49 U.S.C. 24308E2, it simply says the board shall consider when conducting a hearing, first, whether an order would impair unreasonably freight transportation of the rail carrier, with the carrier having the burden of demonstrating that the additional trains will impair the freight transportation. And then second, when establishing scheduled running times, the statutory goal of Amtrak to implement schedules that attain a system-wide average speed of at least 60 miles an hour that can be adhered to with a high degree of reliability and passenger comfort. So those are both things that the board has to consider when holding a hearing, but the statute does not preclude the board from ordering service, even if it makes a finding of unreasonable impairment.
So is it your position that it is up to the board's discretion to determine how unreasonable the impairment is before we say you can't order the trains, or how are we supposed to apply this? I noticed the language, a long time ago, and I'm glad you said because no one else has. How are we supposed to apply it?
It is our position, and I want to be very clear about this with respect to infrastructure costs. Amtrak's position has been consistent ever since the Gulf Coast Working Group report. The CSX and NS have sort of painted a caricature of Amtrak's position as saying that it says that it will never spend a dime on infrastructure. That's just not true. What Amtrak wants is it wants to be able to start service and then to have infrastructure investments informed by the actual experience of operating on the line, rather than facing a demand that it build $440 million of infrastructure before being allowed to run a single train. So our position is simply that the board should order that service can start. It should recognize Amtrak's commitment to working with CSX and NS to fund infrastructure over time, including with the $66 million that's already dedicated for this service. And I guess I also, just referring to the statute again, I want to make clear, if Amtrak fails to live up to that commitment, if the board orders service to start and Amtrak does not work with CSX and NS to fund infrastructure over time, where it's demonstrated that that infrastructure is needed to ensure both reliable passenger service and improve trip times, enhance efficiency, et cetera. The carriers are not without recourse. So 24308C always allows them to come to the board and ask for relief if they believe that providing Amtrak with preference over their lines will materially lessen the quality of freight service that they're able to provide. Or if on-time performance becomes an issue, they can come to the board under 24308F and ask for an investigation into on-time performance and recommendations about how to improve it. They're not without recourse. Our position is that the board should order service to start now while recognizing Amtrak's commitment to fund infrastructure over time based on the experience of operating on the line.
Well, you say we could recognize Amtrak's commitment, but you've taken the position we do not have the authority to condition your running the trains on your building infrastructure, even if that condition was, we'll build it over time. You don't have to build it all before you start trains. You don't think we have any authority to make a condition like that, I take it?
I want to be clear. We don't think the board has the authority to order Amtrak to fund infrastructure. As we said in our pleading on Friday, we think that it is possible that, I should say at the outset, we don't think that the carriers have or will be able to meet their burden of showing unreasonable impairment. But we think that if the board were to somehow conclude otherwise, it could in an order say, we believe that there is unreasonable impairment now, but these are the things that would mitigate unreasonable impairment. And if these things were mitigated, then the service could go forward. But we don't think the board can order infrastructure to be funded.
Well, so are you suggesting the difference between an order which says without X amount of infrastructure, we won't allow the trains to run? And you can either choose to build it, or CSX can choose to build it, or no one can choose to build it. Is that the way you understand the statute?
We understand the statute to be about adding service now. So we understand the statute to say, if no unreasonable impairment is demonstrated, then Amtrak should be allowed to run service. But if the board concludes otherwise, it could also make findings about what might mitigate that unreasonable impairment.
Well, Ray Atkins suggested it would be in the nature of a declaratory order, which might not order you to build it, but might find that without building it, you can't run the trains. Do you think we have the power to issue that kind of an order?
We think you have the power to issue an order that would set forth what Amtrak could do to mitigate unreasonable impairment. But to be clear, we think that the burden is not met here. We think that the right thing to do.
I understand that. Let me ask you this question. Your contention is, not without some justification, that the papers filed by the railroads is an all or nothing. You have to build 440 million in order to avoid unreasonable impairment. On this record, and I don't know how the record's going to fully evolve yet, if we determined that something less than $440 million is necessary to avoid unreasonable impairment, do we have authority to condition? In other words, even if we found that CSX and NS haven't met their burden as you contend, if we find that there will be an unreasonable harm to freight without some infrastructure, on this state of the record, do we have the authority to condition or in a declaratory order say that some lesser amount must be built before Amtrak can start running its trains?
I'm not sure on the state of this record that CSX or NS have put forth any sort of priority of projects. As I said, Amtrak has consistently said that there are already $66 million in capital funds allocated for the service, and Amtrak is willing to work with CSX and NS on what their priority projects for infrastructure are.
Well, do we have the authority to issue an order that says don't run the trains until you've committed the 66 million to specifically identified projects, just hypothetically?
We think that the better formulation of that is to say that the service can go forward. However, we expect Amtrak to live up to its commitment. And if not, the parties can come back to the board. Well,
here's my concern. I'm only going to raise it because I want the parties to deal with this during the course of this hearing. And that is, even if we determine that CSX were not to have met its burden of proof as far as the litigation finding in this case, because as I believe we are required to keep our attention ultimately on the public interest. If we conclude, you're saying that Amtrak's position is start the trains running and find out how much interference there is with freight and then fix it later. But fixing it could take months, could take years. And in the meantime, if no infrastructure was built, there was a problem, a real problem. Let's leave aside the statutory standard for freight. Might we not be adversely impacting the public interest if we just let the 4 trains go forward without requiring some infrastructure to be built? And I'd like you to, you don't have to, unless you want to, address it now, but I find that to be a question that we as a board have some obligation to consider aside from the specific pleadings of the parties, because always we have to worry about the public interest. And so there's some meaningful argument on the other side, even if you think their arguments are too much at the extreme end of the spectrum, that just putting 4 trains on there is going to be problematic if nothing is done in terms of infrastructure. And that is a problematic question in my mind.
So a few responses, Mr. Chair. So first, I think it's important to remember that their infrastructure demands are based on a 20-year look ahead. And when you look at their case about what actually happens when Amtrak service is introduced now, the impacts are very minimal, and you'll hear from our experts about that. So the idea that Amtrak service could be introduced now and the parties could then work together on phasing in infrastructure over time, that would be completely fine. The alternative, of course, Mr. Chair, is that delaying service yet more years while Amtrak has to again try to negotiate with CSX and NS to build the infrastructure that needs to get built. That this is already taken. We've tried this now for many, many years. And so if it is conditioned on the cooperation of CSX and NS, they've shown that they are not really willing to cooperate in terms of building infrastructure.
Right.
So we think that the proper framing would be order the service to be able to start with recognizing Amtrak's commitment to work with the CSX and NS to phase in infrastructure over time as it's demonstrated that it's needed.
Well, perhaps my phrasing of it was not as clear as I'd intended. My question is not whether we have the authority to argue to go and negotiate with them. One possible outcome of this hearing is that instead of ordering you to do just what you said, that we order the running of the trains conditional on specific infrastructure to be built. So nobody's arguing about it. It's already laid out by the board, and you're past that. Rather than just launching the trains with no infrastructure. That's really the question that I find to be of concern. I'll reserve judgment on whether that's an appropriate answer, obviously, till we've heard the evidence, but it is an issue which is certainly raised by all the evidence that's been put before us.
Well, as I said, Mr. Chair, the infrastructure that they want is about a 20-year look ahead. And
but, you know, I'm beyond that. I'm beyond the 440 million. I asked you hypothetically, there was some lesser amount. So I'm assuming for sake of my question that 440 isn't needed, but some amount is needed in our view to avoid impairing freight in a way that's unreasonable. Do we have, you know, and I guess it's just not clear to me about what our authority is. You say your preferred approach is to start the trains running now and see what disasters happen in the future. And I'm trying to find out if it's not our obligation to see if we, based on all the studies that have been, can't anticipate those disasters and mitigate them, and beginning with some infrastructure. And under our authority under E, that's really how I'm tying this into what our powers are.
Well, as I said, Mr. Chair, we have always sought to engage CSX and NS on what their priority projects are with respect to the $66 million that is already allocated for capital improvements on the Gulf Coast line. And if I may, Mr. Chair, I realize that I didn't directly address your question about the public interest. And just for a moment, I just wanted to say that certainly we recognize that the board always acts in the public interest. And in fact, there are statutes that specifically charge the board with taking into account the public interest. This particular statute, of course, does not specifically reference the public interest, but that is nonetheless always a consideration for the board. We think, though, that Congress has spoken clearly about what the public interest demands here. We think that what Congress was trying to get at was this statute was exactly this situation. Amtrak trying to fulfill its statutory mandate to bring passenger service to underserved communities and being stymied by a lack of cooperation and demands for inordinate capital improvements from the freight railroads.
Well, I would just say this, Jesse. We've heard now from parties for all, lawyers for all parties, that these matters are better done through negotiation and resolution. And it's been years of not being resolved through negotiation. And now the case has been brought to us. So we're going to decide a case. Unless you settle it before we issue a decision, that's why you're here. So all this talk about these things should be negotiated. In my view, I encourage people to negotiate right up until the jury comes in. But that's not going to prevent this board from fulfilling its statutory obligation to decide a case that's brought to us. And so what I am getting at is our authority, how far it goes to decide the issues that are contested. Let me just ask you one other, just for clarification. Mr. Atkins took the position that your existing contracts with CSX does not cover this line. And until you reach a contract which covers this line, you can't resolve this question under A, as I think I understood his position. I think Mr. Mullins took the position that, that the contract does apply, their contract. You seem to be saying, well, I'm not clear on your position on that question, whether your existing contract with CSX covers the issues involving the Gulf Coast line.
Our existing contract provides for additional or modified service, and it is pursuant to that provision that Amtrak had always been reaching out to CSX and NS in the past. It's provision 3.2, and that provision sets forth that, in fact, payment for the service will be in accordance with the parties' agreement. And so when Amtrak reached out to CSX and NS in January of 2021 with respect to the schedule, Amtrak also proposed payment for the service. And that was, again, in accordance with what is set out in the parties' agreements.
So let me see if I understand it. As to the amount of payment, the contract is an agreement to agree. It doesn't set forth the amount of payment for this line already. It's something you'd have to agree to. Is that the way it works?
No, the agreement says that for additional or modified service, the payments shall be in accordance with what is already established, and those are.
So I'm understood, and your contention is that governs this line.
Yes.
Okay. But we're not supposed to take that into account under E.
Well, you are supposed to take that into account under E. When you get to E3, E3 says, unless the parties already have an agreement that covers compensation for this service, then you go to A. And we're saying you never get to A because the parties already do have an agreement that covers compensation for this service.
Got it. I understand. Did you lay this out in the brief you filed? How this
Yes, we did on Friday.
All right. Well, I think that answers the questions I had. Karen has her hand up. So let's try to get through these. And then when we finish, we're going to take a break. Karen?
There's a question about the statute that I've had for some time in the context of this matter. And it's the language of E, which says when a rail carrier does not agree to provide or allow Amtrak to provide for the operation of additional trains over a rail line of the carrier, then Amtrak can apply to the board. Amtrak currently does not run service over the line between New Orleans and Mobile. Is that correct?
That's right. Although the sunset limited is still in the contracts, I believe.
But when you initiate this service, it would not be part of the sunset limited. My understanding is this would be a state-supported service rather than part of your long-distance service. Is that correct?
Yes, these would be additional trains beyond the sunset limited.
But so if it's not part of the sunset limited and you're not running trains on this line right now, why does this qualify as additional trains? Additional to what?
Additional both to the sunset limited service that already ran there and additional to the service that Amtrak runs just on all of CSX and NS's lines. These are just additional trains that Amtrak wants to run with the same payment terms that are already in its contract. And that's what section 3.2 of its contracts contemplates.
So if you wanted to run a train over a line over which you have never provided service, you could still access the board under subsection E because it would constitute an additional train?
So long as we had an existing agreement with the carrier, yes, we believe so.
In addition, an agreement that doesn't mention that line?
An agreement that contemplates additional or modified service, which the contracts at issue here do.
Okay, well, then maybe we can get into, I still don't understand what additional means. And I know that Amtrak voluntarily suspended service on this line after Katrina. It did not take any action really to resume service for many, many years because the service was unprofitable to begin with and was always running late because it was part of long distance service. And now you want new service for which Amtrak will not pay the full operating costs and will constitute state-supported service where, you know, the states actually have to pony up at least part of the operating costs. So that's just the point of kind of my confusion, but maybe you can address that again, maybe when we're talking more about the existing contract, because I'm confused about that. And I don't know what was intended here by the Congress. Let me ask you one other question. If we were to simply find for the freight railroads, what would you do?
If you were to find that there was unreasonable impairment and therefore Amtrak could not.
No, we just said they've met their burden of proof. It's unreasonable impairment. We see no reason to hold for Amtrak. What would you do? Do you have any other recourse other than filing an appeal in the federal courts?
I haven't thought about that, Member Headlands, but because we think that we think that the carriers will not meet their burden here. But yes,
well, I understand that, but I mean, a litigant usually has to figure out, you know, you got to think a couple of steps down the line. You've said that you know, we can't order specific infrastructure. So if we can't do that, then we got to pick A or B. And if we pick B, what are you going to do?
well, Member Headland, I again want to clarify that what we have said is the board can't order Amtrak to construct certain infrastructure. We think the board can make findings that, again, we don't think the board should find unreasonable impairment, but the board can make findings that we have seen that there is some unreasonable impairment, but that unreasonable impairment could be mitigated if Amtrak were to fund infrastructure projects. So again, we don't think the board can say, Amtrak, you have to fund these infrastructure projects and saddle Amtrak with the responsibility of funding infrastructure. The determination in the end remains Amtrak's, depending upon whether the infrastructure projects that the board orders are of an order of magnitude beyond what Amtrak is willing to do in order to start the service.
But it's not really Amtrak. It's really, because it's a state-supported service, you're just standing in the shoes of your stakeholders. Is that right?
That's right.
But you are saying that we could find for the railroads, but say that if the following infrastructure were built, setting aside who builds it, you could operate. We do have the ability to do that.
I believe so, yes.
And then what you're saying is if we do that, then it's really up to you and your stakeholders to decide whether you want to do that at all.
Yes.
And
One clarification, Member Headland. You had said that Amtrak didn't try to restore service for a while. Amtrak actually reached out as early as 2006 to try to restore the service, but in any event.
and to pick up, yes, I'll be brief, understanding I might be standing in between lunch. So to pick up where Karen left off, we have if we find that the freight's met their burden without infrastructure, we have the authority to order infrastructure, and we also have the authority to pick out some intermediate ground that isn't the entire freight contention for how much infrastructure is needed, correct?
Yes, although I do just want to, again, I know I'm being kind of a stickler about this. When you say order infrastructure, we think that the board could find that if the freights have met their burden of unreasonable impairment,
Right.
such impairment could be mitigated if Amtrak were to,
We can't direct specific parties. We can't direct specific parties to fund certain infrastructure.
Exactly.
But then the last question I have then is, but even without the direction to specific parties, the constant is that freights would always be obligated to accept the infrastructure in their right of way?
I suppose it would depend upon how the board structured its order, but if it said sort of, if this following infrastructure is built, then Amtrak can start the service. I think that it goes along with Amtrak's statutory right to operate the service, that yes, Amtrak would, the freights would be obligated to accept the infrastructure.
I just want to just make sure I'm absolutely clear, because I saw in your Friday brief that you said presumably the board would order CSX and NS to cooperate. What statutory authority would we be relying on?
It would be the statutory authority that says that Amtrak has the right to operate. It would be sort of the whole grand bargain that I talked about, that Amtrak has the right to operate over freight rail lines. And so if a condition of operating over those freight rail lines is that certain infrastructure be built, then CSX and NS have the obligation to cooperate with Amtrak on ensuring that that infrastructure gets built.
Isn't that right contained in subsection A?
Well, as I said, we don't think subsection A is implicated here because the parties already have an existing agreement. So you don't get to A because we already have.
Yes, but I guess, well, what access right are you suggest? I mean, where is the access right found if not in A?
The access right is in A, yes, but it is also just part of the whole grand bargain that we talked about. It's in E as well. It's you'd be ordering under E. Amtrak has the right to operate additional trains.
Okay, and well, and so that it is under E, CSX and NS would be obligated to accept infrastructure that would mitigate unreasonable impairment.
Right.
Okay, thank you.
Any other board members have questions? Jesse, I have one other area I meant to you dealt with in your opening statement. We had a follow-up question in terms of the port and your argument that the port is not the carrier. You know, E talks about the operation of additional trains over a rail line of the carrier. And then A talks about unreasonably impair freight transportation of the rail carrier. So I have two questions. I've been struggling with this language as well. Suppose CSX entered into a trackage rights agreement with NS to run all the trains over this line, and CSX didn't run any. and that were the current state of affairs, and you came in to ask for 4 trains a day, could either NS or CSX come back and say, well, we're going to show you that these trains unreasonably impair the operation of the NS trains using the trackage rights? Or would you say, no, even though NS has all the freight traffic on this line, it's not their line? So how would you handle that situation?
We think it does talk about the freight transportation of the carrier over whose lines you seek to operate, but presumably CSX would say that, you know, it is impairing it would impair their rights as well to use the line. So NS would just be sort of a stand-in for CSX in that context.
Well, in this case, apparently CSX has some agreement with the port to use a part of its line. I assume it gets paid for it. I don't know exactly what the relationship is. But if CSX is contracting out in some way with the port to use 1.5 miles or whatever it is of its line, where are we supposed to draw the line as to when CSX gets to say you're interfering with our freight transportation? We've contracted with the port to use this part to provide freight transportation. Why is that not something we should be taking into account at least?
Mr. Chair, as I said, we think the port is an important stakeholder, and we are certainly willing to engage with them. But in terms of what the statute contemplates, it's the carrier over whose line Amtrak is seeking to run. So it would be CSX advocating for the port or for its contracts with the port in those instances. It would not be the port is not sort of contemplated under the statute, at least, as a carrier over whose lines Amtrak is seeking to run.
Well, I'm not sure what difference it makes. It is, are we going to pay attention to whatever problems the court claims your trains are going to cause? Whether it's CSX coming on to this hearing saying you will interfere with the operations we've contracted out to the port, and in order to prove that, we're going to ask the port to come forward and put on evidence. What difference would it make? It just seems to me we're dancing on the head of a pin here as to how much weight we're supposed to put on, or whether we're supposed to consider at all the issues raised by the port.
Well, Mr. Chair, we raised these arguments in opposition to the port's motion to intervene, and the board allowed the port to intervene, and we, so we respect the board's decision in that respect. We continue to believe that the port is not, under the statute at least, an entity that has the burden of showing unreasonable impairment.
Well, I guess the question is, it's a separate question, it seems to me, as to who has the burden. It may be that ultimately CSX has the burden for that part of the line, but do you agree that that burden can in part be met by showing what this might do to impair the port's operations?
To the extent that that impacts CSX's operations, ultimately it's CSX's operations that are at issue. CSX is the carrier over whose lines Amtrak is seeking to run.
Well, but it talks about freight transportation. Doesn't freight transportation broad enough to encompass other railroads that are allowed to use CSX's line to transport freight? I guess is another way to phrase the question.
Well, it says impair unreasonably freight transportation of the rail carrier. Right. So that's who freight transportation is at issue.
Right. And CSX has, I assume, maybe they'll tell us, maybe I should already know and I don't, has a contract with the port to have some freight transportation on CSX's line carried out by the port. That doesn't count as freight transportation of CSX if it's done under their right to control their own line by contracting this out?
So, Mr. Chair, the CSX and NS in their RTC model have certainly accounted for freight transportation other than that is directly provided by CSX and NS. They've put into their RTC model sort of, foreign trains and guard trains and other New Orleans railroads, et cetera. So The board chose to give the port sort of a special status in this proceeding, but we don't think that the port is a recognized entity, at least under the statute. The rail carrier can put on whatever evidence it wants of unreasonable impairment. It can include evidence about impairment to the port, et cetera. But in the end, it's the burden on the rail carrier. We don't think that the port, unreasonable impairment on the port itself is not really a consideration under the statute.
But now you've confused me. If the CSX evidence shows that there's unreasonable impairment on the port, are we supposed to ignore that evidence? That's really my question.
You are supposed to consider the impairment of the rail carrier, which is CSX.
Well, I think we're going around in circles. Let's get to it when we get to the port's evidence. Any other questions for Jesse?
I have two.
Go ahead, Michelle.
Jesse, what's been an issue has been a lot of discussion about subsection E versus subsection A. And perhaps this is contained in your most recent filing, but I wondered if you could speak to why Amtrak brought its case pursuant to E versus A.
Because we believe it is an E case. It is a case about our interest and right to operate additional trains over the lines of CSX and NS in the Gulf Coast. So it's not a case about where terms and compensation have to be decided. Compensation is all for additional service is already part of the parties' agreement.
And I believe you said this earlier. I believe it's also Amtrak's position then that pursuant to E, the board is not then permitted to consider infrastructure. Is that correct?
I want to be careful about the language. What I said is that the board can't, under E, we don't believe, order Amtrak to construct certain infrastructure. What the board could do is make a finding, and again, I want to just back up and say we don't think that there is unreasonable interference, but if the board were to conclude otherwise, it could say we think there is unreasonable interference, but we further find that that interference could be mitigated if the following infrastructure were built. It can't order Amtrak to build the infrastructure. And as I said to both the chair and to member Headland, I believe that and I believe also Member Fuchs, that in the end, it has to be Amtrak's sort of choice, whether the magnitude of what the board thinks needs to be constructed is something that that Amtrak and its stakeholders want to go forward with.
Thank you. And then just final question, has Amtrak done its own RTC modeling?
Amtrak engaged in the 2020 RTC modeling, which, as the board is aware, fell apart because of the unwillingness of CSX and NS to share basic data with Amtrak and the unwillingness to deviate from an insistence on only looking at what infrastructure has to be built for a 20-year look ahead, as opposed to for the short term, which is how Amtrak does its planning. Amtrak plans sort of 5 years out in terms of its service planning. And so that RTC study did not go forth. Amtrak has not put forward an RTC study in this case. And
you've not done an independent one, is what you're saying.
Excuse me?
Amtrak has not conducted an independent RTC study.
But let me just also make sure that the board is aware that Amtrak did not have the data to do an independent RTC study. So, and you'll hear from our experts, Mr. Crowley and Mr. Fapp, about this. But for example, you'll hear that the data that was used for the RTC study is all based on, for example, interviews and narratives between CSX and NS personnel and their field personnel. Amtrak has no way of verifying that. Amtrak has no access to CSX and NS field personnel to verify whether the hundreds of trains that they say are operating are actually operating. So Amtrak could not have done its own RTC model with the data that exists.
In other areas of the country, does Amtrak do its own independent RTC modeling?
Absolutely. On the Northeast Corridor, Amtrak, and so I do want to make this clear too. I feel like to some extent CSX and NS have tried to make this a case about RTC modeling and whether it's the gold standard or not. Amtrak is not anti-RTC modeling writ large. Amtrak does RTC modeling all the time on the Northeast Corridor, for example, when it's for its own service planning. But when Amtrak does RTC modeling, Amtrak works cooperatively with its partners. They share data. They share the inputs and assumptions for the RTC model. That was the exact opposite of what happened with respect to the 2020 study. And Amtrak, with respect to the data that was finally provided in this proceeding to Amtrak's experts, and let me be clear, it was provided only to Amtrak's experts and attorneys. Amtrak itself has no access to the data, still cannot actually look at any of the data. Amtrak is not able to use that data to do its own RTC study.
Okay, thank you.
I would like to just follow that up with 2 points that are going to break for lunch. Has Amtrak, as I was going to defer this till your witnesses get on the stand, and you may want to defer it as well, Jesse, but the question I have is, you've already said you did not run your own model, your own study. Did you do any runs on CSX's model and modify the inputs in any way?
You'll hear from Mr. Pfapp and Mr. Crowley about what they had available and what they were able to do. And
all right, that we'll explore it with we'll explore it with them. I just want to follow up on one question that Karen Hedlund asked, which has puzzled me a little bit. You know, I'm probably you too are used to operating in a more formal courtroom procedures with motion practice and so forth, which we don't really do here. And the question on the table, I think, and you don't, unless you want to, need to address it now. But when CSX and NS finish putting on their case, and we have to determine whether a prima facie case has been made to satisfy their burden of proof, the question then is, in the event we were to hold that they had made a prima facie case, I think what Karen may have been addressing in part was, what evidence will Amtrak then go forward with to contradict that prima facie case? And it then becomes burden of going forward on Amtrak at that point, if we were to so hold. And so you don't have an RTC study to contradict their study. So are you, I assume you're going to be relying on all the other evidence that you disclosed. Is that a fair understanding?
yes, Mr. Chair, but I do want to just address sort of the framing that you used. And we addressed this in our brief on Friday, which is about the prima facie case. So the statute does not contemplate any sort of burden shifting here. The statute contemplates that the burden remains at all times on the carriers. Amtrak does not have its own burden to come forth and rebut the evidence of the carriers. It is, the statute is crystal clear that it is the carrier's burden to demonstrate that the additional trains will impair their freight transportation. There's no talk of prima facie or burden shifting. So that said, we will put on our witnesses. They will, so you'll hear from Mr. Crowley and Mr. Pfapp about the RTC modeling in this case and why that RTC modeling is flawed and why it was built to a standard that is not at all about unreasonable impairment, but is instead about sort of gold plating the railroad. You'll hear from Mr. Blair about how Amtrak operates nationwide in numerous circumstances with much higher passenger frequencies on much busier freight lines. So to contend that this is unreasonable impairment just doesn't comport at all with Amtrak's experience. And Mr. Blair will also discuss the fact that the Gulf Coast Corridor is not at all unique. And then finally, you'll hear from Mr. Johansson, who will talk about the capacity study that Amtrak conducted and that shows that there is sufficient capacity on the line to add 4 passenger trips per day. And that if the railroads were just willing to operate more efficiently, et cetera, that and willing to sort of cooperate with Amtrak on service planning that both reliable freight and passenger service could run.
Well, just to be clear, I wasn't suggesting, and let me state this the way I see it. The other board members may disagree and the parties may disagree, but I think it's fair as we go forward with this proceeding for us all to proceed on some similar understanding. The statute speaks of burden of proof at a hearing on the record. I believe it is not contested that a hearing on a record is a trial-like proceeding that we have begun with direct testimony, cross-examination, and the board ultimately making a decision. There is a difference between a shifting of the burden of proof and a party having the burden to go forward if a prima facie case is made. I know we all understand that. So I don't think you're saying that if we were to determine at the end of the railroad's case that they've met their burden of proof, there's nothing that you can do about it. Karen asked you, what are you going to do about it? In my view, you have the opportunity to offer evidence that would then destroy or undermine their prima facie case. And that is one way you could go forward. That is not a burden shifting. That is to finish the trial. You may take the position at the end of their case that if they haven't made their burden of proof, the trial's over. We haven't been faced with that request and we're not considering it at this point. But I think the question is, I think you've answered it, that if, let me state it, I want to make sure we're all on the same, I was going to say the same plane, but this is a railroad case, so I won't say that. If at the end of the railroad's case, they have met their prima facie case to establish their burden of proof, then the evidence that you have to contradict the prima facie case is all the evidence you've just sort of generally outlined. I don't mean to limit you. Whatever evidence you've proffered is how you're going to combat their prima facie case. Is that understanding?
Yes, I think that's correct. We don't think that the board should reach a decision about whether they have met their burden of proof until after the board has heard all of the evidence.
Well, that is another question which we can determine at the time if any party raises that issue. And you may have already told us your position, so we'll see. All right, unless any other board member, Karen has her hand up. Sorry. You're muted, Karen.
I'm sorry, and with all due respect, Mr. Chairman, in fact, my question was a little broader than the way you have characterized it, although I think that is a very useful way of looking at the issue. And it was really suggested by Jesse, your comments that if the board holds for Amtrak and things get mucked up, that the railroads still have the ability to come back under 24308C and maybe F and maybe some other section to get relief. But if we were simply to hold in favor of the railroads, and if it's your position that you have an agreement that covers this, you do not have the ability to come back and seek the assistance of the STB under A?
Member Headland, I haven't, I'd like to reserve responding until I've had more time to think that through. It's, as I said, we don't think that they can meet their burden in this proceeding. And so
no, I understand that. I'm just, as you can see, we're trying to figure out what our options are in dealing with this problem and what we can do to solve it, and meet our obligations to fulfill the public interest. So I'd be interested in that. And I'm from all the parties, I would be interested in a little more on whether this contract or the two contracts you have with NS and CSX do or do not apply in this case. Thank you. That's all I have.
All right. Thank you. Karen, and thank you all. If we are done for the moment, the opening statements, which have lasted far longer than they're scheduled for, but that's okay. I think a lot of progress has been made, are over. It is 12:57. Let's recess until 1:30 and we
Hey,
will.
Marty,
Yes,
sorry to interrupt.
go ahead.
Can I ask for a special request? Can we recess till 1:40? I need a little bit of time to take care of something.
1:40 is fine.
Okay.
Thank you for raising that. We will reconvene at 1:40 and we will begin with CSX's first witness. Thank you all. All right, good afternoon, everyone. Matt, are we on?
Yes.
We
Mr.
are.
Oh,
All right,
I apologize.
okay. All right, with that, we are ready to call our first witness, Mr. Atkins.
Mr. Chairman, you have me for this witness examination, Matt Warren.
Who is this, Matt? Matt? I can't
Yes,
see
this is-
anybody. Okay,
This is Matt. I should be.
let me go to the gallery. All right,
All right.
Matt, I'm stuck with you. Is that what you're saying?
You were stuck with me for right now, but not.
All right.
not too much longer.
No, well, given the. what's
Hey,
going
we
on,
are barely hearing you. Is
Barely
that
hearing you.
CSX?
Yeah, this is CSX. Can you hear
Yeah,
me?
your
now?
audio is really low.
Yeah, you're on it. Yeah, it's a little bit low, Matt.
Okay, our apologies. Let's see if we can turn that up. Testing. How's our audio now?
Better, much better.
Getting better. Maybe up a little bit more, please.
Okay. How about now?
I think that's better.
Okay.
All right. So Matt, we are delighted you're with us. And we are ready for you to begin.
Okay, Mr. Chairman, CSX and Norfolk Southern call their first witness, Mr. Charlie Banks.
I am going to be the bailiff today and we're in our witnesses. Mr. Banks, I assume you've done this before. Please raise your right hand. Do you swear or affirm that the testimony you are about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I so affirm.
All right. Thank you, I'm sorry, Matt, proceed.
Charlie, would you please state your name for the record?
Charles Harold Banks,
And what is your profession?
management consultant operating exclusively in the rail space.
Could you please summarize your experience in the rail industry?
Yes, I am currently president of R.L. Banks and Associates, Inc., named after founder, my father, Robert L. Banks, who founded this consulting firm in 1956 after employment in the passenger department at the New York Central Railroad. My father testified before the STB and its predecessor agency on dozens of occasions. He loved the business, he loved the industry. And as a result of his enthusiasm, I have spent my entire adult life in the rail space. In 1970, I was 18 years old. I started working for a railroad. I ended up working in 6 departments of 5 railroads in 4 different states, as well as the District of Columbia. After working for those railroads, I entered federal service and worked at the United States Railway Association. I had 2 jobs there. The first was manager of capital and rehabilitation expenditures. And the second, which is more germane to these proceedings, I was the chief of public sector purchases with responsibility for all intercity, regional, and commuter rail services in the Northeast and the Midwest.
And Charlie, when you say that you work in the freight space, are you only talking about freight railroads?
Mr. Warren, I said I worked exclusively in the rail space, not the freight space, and
Yes.
that's the case. We have designed our business to achieve a balance. We do work for freight railroads, although frankly more for short lines and regionals than class 1s. But we also do a lot of work for passenger rail entities, operators, state DOTs, state supporters of state intercity service, and also the federal government and Amtrak for that matter.
what lines of business does RLBA offer to its passenger clients?
I would say there are two principal lines of business. One of them I would characterize as planning and feasibility. In that line of business, we perform the same kind of analysis that presumably Amtrak has done in coming up with a plan that's at the heart of this matter. That is to say, looking at what the ridership would be, how many trains should operate to respond to projected ridership, what the consists of those passenger trains should be, at what stations they should make stops, what should be the size of the parking lots, et cetera, et cetera. The second primary line of business in the passenger area is what I would call, in contrast to planning, implementation, which is generally achieved through negotiation of access to shared track on tracks generally owned by freight railroads.
Could you provide the board with some specific examples of each of those lines of business?
I'd be happy to. I think a particularly useful one is the work that we did on behalf of the Virginia Railway Express, because we were hired to do both the planning feasibility work as well as the implementation and negotiation. So in the case of the Virginia Railway Express, again, we did all of the elements that normally go into a feasibility study. There's a way of doing it right and comprehensively. And so we did all of those, and we're talking about a line on CSX, which extended, I think, initially to Fredericksburg, Virginia, but has ultimately been expanded further south to Spotsylvania, and also a line that is on Norfolk Southern, essentially to Manassas, although it's been extended to Broad Run, Virginia. So we did all that planning work, and then it took several years for that work was done for the Council of Governments of Greater Washington, D.C. It took several years for the political elements to figure out who was going to do what in Northern Virginia, and two regional agencies, multi-county agencies, collectively hired us to help them negotiate with a predecessor railroad of the current Norfolk Southern for that trackage going west from DC in the I-66 corridor, and a predecessor railroad for CSX, the Richmond, Fredericksburg, and Potomac for that portion. And then from the Arlington County line, shoreline of the Potomac River, across the Potomac, parallel to the 14th Street Bridge, and then through L'Enfant Plaza and beyond. That track at the time was controlled by Conrail. So we had to negotiate track access also with Conrail. And last but not least, Amtrak then owns access into Union Station, and in fact, below the Capitol, I believe. And so we had to negotiate access with them. We also recommended at the time that VRE contract with Amtrak to operate the trains. So we had yet a fifth negotiation.
Thank you. Are there any more recent projects that you could describe to the board?
Yes. We do a tremendous amount of work in California, which has really been a hotbed of passenger rail activity in the last few years, last few decades. I'll talk about two of them. There is a highway between a major interstate called the 5 in California, which we Easterners would refer to as I-5, between San Diego and Los Angeles. And the California Department of Transportation basically issued a preliminary report saying it was going to widen the highway in each direction, either 2 or 3 lanes between Los Angeles and San Diego. And the environmental interests threatened to sue on the basis of the fact that Caltrans had not followed its own environmental regulations. Ultimately, the parties agreed to hire a consulting team to examine whether much of the future demand could be handled by enhanced passenger rail service. And R.L. Banks and Associates was hired to use a model called RTC to model the trains, the increased number of trains that would be appropriate to handle the forecast increase in demand. So that's one project we did recently. And another recent project was done on behalf of Facebook, which is now calling itself Meta. Facebook's campus is in San Mateo, right on the edge of South San Francisco Bay on the peninsula. And a lot of their employees live in the East Bay because the cost of housing is much less. Facebook wanted to explore the use of a railroad bridge, which is in reasonable shape, would have to be rehabbed, which connects the city of Newark in the East Bay with Facebook's headquarters, which is literally at the shoreline, and to points beyond. And so again, we were hired to do an RTC analysis of running essentially a Facebook shuttle. It would connect up ultimately with Caltrans. Non-Facebook employees could use it, but it was essentially a Facebook shuttle.
Have you done work for commuter rail clients?
All over the country.
Can you give some examples?
Sure. One example, which I think is particularly germane, is we did some negotiations with representatives of NS and CSX and Conrail during the time that CSX and NS were dividing up Conrail. So there were representatives of all three railroads at the negotiating table. We were working for New Jersey Transit that was seeking to put in light rail service on a freight track between Camden and the capital of New Jersey, Trenton, on the line that where we did reach a successful negotiation outcome. And it's now operating as the River Line of New Jersey Transit. Another example is we worked on a transaction which was the largest in terms of both dollars and scope. My father and I were hired by Los Angeles County, separately San Diego County, and separately Orange County, which lies between them. All of whom wanted to put in commuter rail service. San Diego County from the ocean side in the northern part of the county south to San Diego, and the other two into Los Angeles Union Passenger Terminal. We realized very quickly that while it was in our interest to have three clients paying us to do the same thing, it wasn't in their interest. And so I came up with something called a joint offer where the three of us worked together, three counties. We convinced them to work together and then to bring in the other two counties that also wanted commuter rail service. And it took 6 months to pull that coalition together, another 1.5 years to bring Santa Fe back to the table. But that deal also was consummated.
Were you involved in the recent initiative by the Commonwealth of Virginia to expand passenger service in Northern Virginia?
I was involved and I remain involved. There are really two separate deals. There's one with CSX that it involves, and frankly, I never thought this would happen, but the extension of the Northeast Corridor from Washington, D.C. to Richmond, and the rights to operate service beyond Richmond down to Petersburg, and then branching off of the CSX main down into North Carolina, near Raleigh, North Carolina. So basically the beginning of the Southeast High-Speed Rail vision. And there's also a piece of that work that has involved adding service, state-supported service now we're talking about, between Washington, D.C. and Roanoke, and in fact, extending it south of Roanoke to a place called Christiansburg, which is near Virginia Tech.
Have you done work involving Amtrak?
Yes, we've done work both directly for Amtrak and involving Amtrak.
Can you give an example of work you've done directly for Amtrak?
Yes, in 2015, December, I believe, something called the FAST Act was signed into law. FAST, an acronym standing for Fix America's Surface Transportation. That law required Amtrak to develop a methodology to help guide decision-making with respect to the addition or subtraction of routes or additional trains or stations. In other words, guide its future growth or elimination for those routes that weren't working out too well. We were part of a team that contributed to that study.
Can you give an example of work you've done that involves Amtrak where Amtrak was not your client?
Yes. The most important one, I think the most interesting one, is that in the mid to late 80s, Amtrak service between Washington, D.C. and Montreal was in trouble due to the fact that a short line had reduced the speed of its tracks down to 10 miles an hour for 60 miles. So it was taking 6 hours to go 60 miles. And a competing short line also was a tenant on that piece of trackage rights and was being hurt economically by the slow speed. And so they got into a big fight, and the short line and RL Banks and Amtrak were on one side, and the owning short line and actually the Association of American Railroads was on the other side. The ICC ruled in favor of our position, but it was appealed. In fact, it was appealed all the way to the United States Supreme Court.
Have you done any work involving the Federal Railroad Administration?
Yes. In 2020, we were hired by FRA to conduct an analysis software program, a standalone software program that would help FRA be able to gauge the financial impacts of decisions made by Amtrak to add or subtract to its network. And we currently have 2 contracts with FRA, one in which we are the primary contractor and one in which we are a subcontractor. Excuse me.
Charlie, based on the extensive experience that you just testified to, do you believe that it is possible for freight railroads and passenger railroads to successfully share use of a rail line?
I do. There are dozens of examples of it around the country. I don't see how anyone could have reach any other conclusion.
So when a passenger or a commuter railroad is seeking shared use of a freight line, how do they ensure that that shared use is not going to unreasonably impair the freight transportation on the routes?
Well, the interests of passenger rail development agencies and the interests of the freight railroads are somewhat aligned, but the interests are not completely aligned and perhaps not even particularly well aligned. In the old days, we would just sit there and bicker across the table at each other and get extremely frustrated. But now, fortunately, in fact, since at least the year 2000, there is a mechanism, a simulation tool that is very granular, very accurate. I would argue very transparent to allow both freight and passenger interests to manifest in detail what their interests are. And this simulation program will spit out a variety of outcomes, which the parties can then focus on.
And Charlie, which simulation program are you talking about?
It's called the Rail Traffic Controller, shorthand RTC.
Could you please briefly explain what RTC is?
I think the best way to understand it is in three pieces. In the first piece, the modeler puts in everything that is germane about the supply of capacity. Think of it as infrastructure, if you will. So we're talking about the number of tracks, the location of tracks, the beginning and end of every siding, the speed at which trains can go into those sidings, the signal system, movable bridges, horizontal and vertical curvature, et cetera, et cetera. Any factor that will affect the supply of capacity. Shorthand, infrastructure. Step two is you put in the demands on that infrastructure. Many of those demands are trains. So you put in all of this into this computer model. You put in the number of trains, the weight, length, tonnage of those trains, how frequently they run, when they have to run, if they have to run at a particular time, things like that. But it's not just trains, it's any occupancy of capacity needs to be put into the model to take advantage of its capabilities. And that includes things like leaving cuts of cars on the main line so that a local can go conduct its switching and come back and pick up the cars right there off the main and proceed down to the next customer. And the opposite of that, light engines running around without any cars behind them because the engines maybe are coming from a train and need to be fueled or going to a train. Maintenance of way work that needs to be done out on the track so that the track remains in a fair condition. High rail vehicles that are taking, for example, people who work on the movable bridges, to them, any occupation goes in the second tranche. The third and final part is running the model. And the model either runs or it doesn't run. If it doesn't run, you need to either add infrastructure or reduce or change the operating parameters or reduce the number of trains running until it does run.
But Charlie, you testified a moment ago that RTC was transparent. What did you mean by that?
It is as objective as it can be. It runs on data. It produces data. People who see the results can make adjustments very quickly, and they can isolate the effect of any individual adjustment if they want. But the simulation is so powerful that one can make multiple changes in a scenario as compared with the previous scenario. And it, again, will be able to calculate it. So what I mean by transparent is you can see the information that's coming in and you can see the information that's going out. And if you want to slice it up into pieces, you can see the individual impacts associated with making individual decisions by the model.
How does RTC compare to other planning tools that might be used in the rail industry?
It is the gold standard. RTC was not designed to support procedures like this, litigation. It was designed to assist railroads in planning how to tweak their networks so as to maximize the utilization of the assets that any railroad has. And as a result, it is currently licensed to every Class 1 railroad in the United States and has been for years.
Approximately how many RTC simulation projects have you been involved with in your career?
Approximately 20. We do 1 or 2 a year. I don't remember the year that we first started paying our licensing fees, but 1 or 2 a year is pretty average.
And I asked you earlier about the work that RLBA has done for, passenger rail and commuter rail and involving passenger projects. Does RLBA do work for freight shippers?
It does. Approximately a quarter of our work on a 5-year rolling average would be related to passengers, about a quarter on behalf of individual railroads, about a quarter on behalf of shippers, and another quarter on behalf of suppliers of both financing and equipment. So we have a very broad portfolio, and it's by design.
Has RLBA done work for freight shippers in Surface Transportation Board litigation against CSX?
As the STB staff would know, yes, we've been on the opposite sides of, for example, standalone cost cases against both CSX and Norfolk Southern, and at least BNSF as well.
So how is it, Charlie, that RLBA can do so much work for freight railroads, passenger railroads, commuter rail interests, and freight shippers?
Integrity. We have an excellent reputation for telling it the way it is. We've had several clients literally write us letters saying, thanks for telling us what we needed to hear, not what we wanted to hear. And the reason those clients come back to us over and over again is because our process is the same. Our approach is the same. And our results are the same, regardless of who pays our invoices.
Charlie, in Amtrak's opening statement, they argued that Amtrak operates all over the country, and they operate over lines involving CSX, and they operate over lines that are Norfolk Southern lines. What, in your view, is different about the Gulf Coast?
It is an extremely challenging territory, even just to operate freight trains, let alone the addition of Amtrak. The 2 gentlemen who are going to follow me to the podium here will be able to provide details to the members in a way that I couldn't possibly. But essentially, it's a combination of both physical constraints and some of the operational demands. Let me go through the physical constraints first. I think I would start with the fact that it's mostly single track territory. There are some sidings, but there are not very many sidings, and a lot of them must be short because there are either bodies of water that prevent the lengthening of the sidings, or there are grade crossings. Now, the number of grade crossings per mile on this particular rail line segment is not much different than that ratio across the country as a whole. However, those grade crossings tend to be concentrated just west of Pascagoula and end up making the sidings shorter and also making the location of the sidings much less than ideal, which constrains the corridor. In addition, there are 13 movable bridges that affect the capacity of the corridor. 7 of them are actually on the segment, but 6 others have ripple effects that affect the capacity of the line. And speaking of ripple effects, New Orleans is one of the largest interchange locations in our entire country. Tremendous amount of interchange is going on. And for the interchange to be accomplished to and from CSX, all those trains have to go over the NS line. So interchange trains to and from the Western carriers from both NS and CSX all have to go over that one single NS line. It's the combination of those physical constraints and the volume and complexity of the interchange at New Orleans that really sets this particular corridor apart.
And Charlie, to remove any unnecessary suspense, when you refer to the 2 gentlemen who would be talking in more detail about some of these physical constraints and the combination of those with the operating needs on the line, who are you referring to?
I'm talking to Ricky Johnson, who representative CSX, and Randy Hunt, who will provide the Norfolk Southern perspective.
Thank you. Charlie, in your experience, is there any route on the Amtrak system that has this combination of complicating both physical and operational factors that you just described on the Gulf Coast?
No.
So in a situation like this one, what is the best way to evaluate how Amtrak service might be successfully added to this complicated route without unreasonably impairing freight service?
The best, and I would say the only solution that I see that minimizes subjectivity is to employ RTC and then negotiate over the outcomes that the RTC suggests.
How did you come to be involved in this proceeding?
We signed a contract in August of 2021.
What were you asked to do in that contract?
We were asked to audit the inputs, methodologies, and assumptions that were reflected in a draft Gulf Coast RTC report. And when I realized the nature of our assignment, I asked one of my associates, Larry Guthrie, to join me in heading up the RLBA contribution, because Larry had headed up the section that ran RTC projects at a major railroad in the United States a decade ago.
Matt, I'm sorry to interject. Mr. Banks, could I just ask you to repeat, because it somehow got past me, your beginning of your answer, what you were asked, I think the question was, what were you asked to do?
Certainly. We were asked to audit the inputs, assumptions, and methodologies manifest in a draft RTC report that had been produced by a gentleman named Mark Dingler, Dingler, an employee of HNTB.
All right, thank you. Sorry to interrupt.
No problem. So Charlie, so you brought in Mr. Guthrie to help. What did you and Mr. Guthrie do to carry out your assignment?
Well, of course, the first thing we did was read the report and make a list of a couple of dozen questions that we had. And fortunately for us, the railroads had the wherewithal to recognize our need, and they put together something that became known as the Clean Team, because the purpose of the Clean Team was to scrub all the assumptions, all the inputs, and all the methodologies that went into the draft report. In addition, Mr. Guthrie was part of a small cadre of consultants that visited the line and with paying particular attention to the major choke points along the line, a multi-day trip. And that trip was bookended by two, I believe, multi-day visits to Mr. Dingler. Mr. Dingler ran the model. Mr. Guthrie sat next to Mr. Dingler and asked him an exhaustive list of questions that we thought were more appropriate to ask Mark while sitting next to him, so that the model's inputs and outputs could be reviewed directly there on the screen.
Charlie, was there a point where the scope of RLBA's assignment changed?
Yes, over time, we became more comfortable with everything that was being done. And we essentially came to see the assignment slightly differently. The assignment, as we ultimately understood it, was to do everything possible to ensure that the infrastructure that was manifest in the model accurately reflected what was out there, out on the ground, plus some improvements that I believe CSX proposes to make between now and 2039, which improvements were already reflected in the 2039 model runs. To make sure also that Amtrak's service and scheduling needs were properly represented in the model. And third, to make sure that the freight requirements, both local and switching and road trains and all the other needs were properly represented in the model. And at that point, we expressed our willingness to add Mr. Guthrie's name to the Gulf Coast RTC report that was ultimately submitted to the STB.
And Charlie, will Mr. Guthrie be testifying later in this proceeding?
I sure hope so.
So, Charlie, you testified earlier that you've been involved in about 20 RTC models over the course of your career. How would the process that went into constructing what became the 2021 Gulf Coast RTC model, that's Mr. Guthrie and Mr. Dingler, put into evidence in this case, how does the process that was used to create that model compare with the process that you've seen in previous RTC models that you've been involved with?
Process was the most comprehensive, most thorough, most complex, and most vetted process of any project I have ever worked on, going beyond RTC, even going beyond the 35 years that I worked at RLBA, going back to the time when I was essentially an internal consultant to 3 railroads. This has been thoroughly vetted. If it wasn't, our name would not be on it.
What did the Gulf Coast RTC report show would be the effects of granting Amtrak's request for immediate passenger service with no infrastructure improvements?
Serious degradation to freight operations.
And what did the Gulf Coast RTC report show would be required to avoid that serious degradation?
Well, responsive to the board's directive of the summer, the team came up with a set of improvements based on the feedback that the RTC runs gave us, both regarding 2019 and 2039.
Charlie, based on your experience and based on the work you've done in this case, what do you think is the best way for the parties to move forward to evaluate how Amtrak passenger service could be added to the Gulf Coast without unreasonably impairing freight service?
I think it would be foolish not to take advantage of the RTC model, because the industry is very lucky that such a model exists and can essentially play a neutral role, putting in the inputs, getting out outputs, multiple outputs, which both sides can have similar access to and capability of working with.
Mr. Chairman, I have no further questions on direct.
All right. Do I assume, Matt, that I shouldn't make any assumptions that NS will not, these are joint witnesses, right? So they won't have any.
Yes, I think I don't have Mr. Mullins, Mr. Donahoe here, but I can represent that they don't have any direct questions.
Okay. So I think up next is the port. Mr. Wimbush. Rob Wimbush.
Try it now. The port has no questions.
All right.
Jim Miller.
All right. Amtrak. Who is appearing? Is that Miss Bracy?
Yes.
Okay. You're on.
Chairman.
Yes.
So, Mr. Banks, you've submitted 41 verified statements to the STB. Is that correct?
I don't know.
Well, you've never submitted an RTC model to the STB before. Is that right?
I'm not positive, but you may well be correct.
Okay. And the RTC model is a computer program. Is that right?
It is a simulation program, yes, done on a computer.
Okay. And it's a model that's only as good as how it's programmed. Is that right?
Would you repeat that question, Council? Sorry.
Sorry about that. It's only as good as how it's programmed. The model is only good as how it's programmed. Is that right?
I would say no, that's wrong.
You work with Mr. Guthrie and Mr. Dingler on that model, correct?
Yes.
Did you work with anyone else?
Mr. Dingler was it depends, Council, on what exactly you are seeking. Mr. Dingler was the only person who specifically operated the model.
Okay.
Mr. Guthrie, as I alluded to in previous answer, sat in the chair next door to Mr. Dingler on several days across 2 trips and asked specific questions and observed a number of items. Mr. Guthrie, and I spoke before and after every one of somewhere between 12 and 18 Zoom calls that the clean team held. And after those calls, Mr. Guthrie and I would often compare notes, and I would give to Larry my thoughts, and he would translate those thoughts into questions which would either be addressed in the next Zoom call, or if more appropriate, were saved for Mr. Dingler when they met one-on-one.
To whom did you report your results?
I'm sorry, I just didn't hear you. Say that again.
Sure. To whom did you report your results?
So the clean team would make recommendations. Sometimes Mr. Dingler himself would bring questions before the team and ask for guidance. Whenever new results were available, Mr. Dingler would discuss them on these clean team calls. Sometimes the results were provided to us in advance of the call, sometimes in the course of the call. Is that responsive to your question?
Yes. Did you run prior models that caused less delay?
I think that is a question that's best held for Mr. Dingler.
Are there?
Well, Ken, I'm sorry. Can you answer the question, Mr. Banks? Do you have any knowledge?
If forced to answer, I would answer, I don't think that there were that there were runs that operated in obviously less delay, but I want to add two caveats. One, when you make changes in the model, which was the whole purpose of bringing RLBA on, you get differential results from making a certain change. You make the change because it's the right change to make, okay? The result could be that it's advantageous, there's less delay on NS through trains, but there could be more delay on CSX local trains. So I just want you to understand it in the context. The context is that you make the changes, at least the way I interpreted the assignment, we make the changes that we think are the right changes to make. We communicate them to Mr. Dingler. Mr. Dingler runs the model. He comes back and communicates the results. Some of those results may go in one direction. Some of the results may go in the other. But even if the directions were such that we ultimately ended up with a higher number, more delay, that doesn't mean that that was the purpose of it. The purpose of it, the purpose of the RLBA contribution was to produce, oversee the production of the most accurate model that we could achieve.
Well, Mr. Banks, just for the record, I'm not forcing you to answer anything. I'm only suggesting that you're required to answer anything that you have knowledge of. If you don't know, you can tell us you don't know.
I don't believe there were such, but now that I've introduced my caveats, I'm perfectly comfortable providing the answer. Thank you, sir.
All right. Sorry to interrupt, Ms. Bracy.
Thank you. CSX determined the inputs for the RTC model. Is that correct?
It's a very complicated subject. I'm going to try to give you a 30,000-foot view answer. There will be opportunities to talk to Hannah Ross, probably tomorrow at the rate we're going, and talk with her specifically about the inputs. You need to start somewhere, and the inputs that were provided by both CSX and Norfolk Southern are central to building a strong foundation in that model. As one of Mr. Warren's questions alluded to, we have been on the other side of the table from these two class ones and others. And it is better to have the most informed data that one can get. We did receive information, obviously, from CSX and from Norfolk Southern, and it was our job to audit that information, just like it was to audit the ongoing work in the model itself.
You audited the information, but you also drafted your own report. Is that right?
Yes.
Have you reviewed the prior RTC study from the Gulf Coast Working Group report?
No.
And in this case, Mr. Dingler was instructed not to have any aggregate train delays for the freights. Is that right?
I'm not sure I understand your question. Would you mind rephrasing it?
Sure. In this case, you were instructed not to have any, this is not rephrasing. And in this case, you were instructed not to have any additional train delays for the freights. Is that right?
Sorry, I'm not trying to be difficult. I just don't really understand your question.
Withdrawn. And you were instructed not to alter the schedule for the NS and CSX freight trains in your model. Is that correct? Or in the Dingler model? Is that correct?
No, that's wrong. We, in fact, received no instruction of any kind. However, on our own initiative, we did look to see if freight trains departed at the same time as Amtrak trains. And in one instance, we thought we saw that there was a conflict. And so we were in the process of directing Mark to move the freight train so it wouldn't obviously conflict with the Amtrak train, when we discovered, in fact, that because of the time zone issue, there was, in fact, no conflict.
Okay. And so Mr. Dingler was instructed to decrease Mr. Dingler was not instructed to decrease the current inefficiencies on the CSX and NS lines. Is that correct?
Just one more time, please, ma'am.
Sure. Mr. Dingler was not instructed to decrease the current inefficiencies in the lines, on the NS and CSX lines. Is that right?
What inefficiencies are you talking about?
The current inefficiencies on the lines.
Well, I'm trying to understand, ma'am, what you mean by inefficiencies.
The failure to dispatch the trains on time. The current failure to dispatch the trains on time.
Are you referring to some testimony that I have sponsored?
I'll withdraw that question. You were instructed not to move the freight schedules even 5 minutes. Is that right?
We received no instruction whatsoever from Norfolk Southern or CSX or the port as to how to dispatch trains, including departure times.
Okay. So you didn't model any operational changes, or Mr. Dingler didn't model any operational changes?
I think that's a question better directed to Mr. Dingler.
Okay. And Mr. Dingler didn't model any structural changes?
What do you mean by structural?
Any sort of new signals or something of that type?
I can't answer that question. I suggest you address that to Mr. Dingler as well.
Okay. And the only thing you were instructed to do was to add more infrastructure. Is that right?
We were not instructed to add any more infrastructure.
Your conclusion was to add more infrastructure. Is that correct?
Our conclusion collectively reached was that in the absence of adding infrastructure, Amtrak could not possibly achieve the goals that it has set as far as service delivery.
Okay. And that conclusion to add more infrastructure was based on not moving a single freight train and not moving the proposed schedule of a single Amtrak train. Is that right?
Would you please repeat that?
Sure. And that conclusion to add more infrastructure was based on not moving the schedule of a single freight train and not moving the proposed schedule of a single Amtrak train. Is that right?
It is correct.
The RTC model has certain default settings. Is that right?
Yes,
And those settings are based on the average railroad experience in the real world. Is that right?
I think this line of questioning is better directed at Mr. Dingler than I.
Can we just get an answer? If you don't think so, one way or another to that question, please?
If I could hear the question one more time, I'll do my best to give you an answer.
Thank you.
These default settings are based on the average railroad experience in the real world. Is that right?
The reason I can't give the member an answer is because I really am unclear about the use of the word average. And I think Mr. Dingler is better positioned. He is an RTC practitioner. I am really a manager of the audit process, if you will, of the RTC. So you're welcome to direct the question to my colleague, Mr. Guthrie, also if you want, but I think Mr. Dingler will be in the best position to answer your question. Sorry, that's the best I can do.
You can adjust the RTC model default settings. Is that right?
Yes.
And you can adjust the inputs. Is that right?
Yes.
And one of the inputs you adjusted was crew walking speed. Is that right?
I believe so.
And that is the time it takes for a crew to go from the front of the train to the back of the train and vice versa. Is that right?
That is my understanding.
And the setting in the RTC model is 3 miles per hour. Is that right?
I don't know the answer to that, but you will be hearing from 2 modelers, one representing CSX and one representing Norfolk Southern. And those 2 modelers will be in an excellent position to answer your question about why the settings were adjusted to the extent they were adjusted.
And just for the record, who are those people?
Hannah Ross with 2 N's, H-A-N-N-A-H. Ross, I think it's R-O-S-S-E. And Holly, H-O-L-L-Y. Sincannon, I think it's S-A-N-K-A-N-N-E-N, I believe.
So this is the highly confidential portion, Chairman Oberman.
All right. Matt? So this is highly confidential, right? Okay, that's a double limit.
Yes.
All right, Matt, you're on.
Yep. Stand by 1 second. I just need to remove a couple people from the list and then I'll send you guys away.
We don't mean it to sound sinister when he says he's removing people.
Yeah, Mr. Chairman, we are also have asked our 2 witnesses without access to the highly confidential information to exit the room, and they have.
Okay. Anybody else to exit the physical rooms where they're located?
Our client has exited the physical room, sir.
Okay. All right, Matt, you'll tell me when we've moved, or are we moved?
Stand by 1 more second.
Okay.
All right, I'm sending you guys now. If there's somebody that is accidentally gets in there, which I think we're pretty good, please just click the leave breakout room button at the bottom right-hand side of your screen when you get in there, and it'll just bring you back to the general session here. Here you go.
Okay, I am unmuted. Thank you. Okay, we are back. And I thank all the people who may still be watching us for their indulgence. But we have no other way to protect the proprietary information, as I indicated at the beginning of the hearing, but to take these breaks. So we will proceed. Ms. Bracy, you may continue.
You mentioned a clean team. Who was on the clean team?
Clean team included Mr. Dingler, Mr. Guthrie, myself, Holly Ross, whose name I gave you earlier. Sorry, Hannah Ross, whose name I gave you earlier. Holly Sincanen, whose name I gave you earlier. Ricky Johnson, who you will be hearing from after me. He's a CSX executive. And Randy Hunt, who is a Norfolk Southern operating department executive. There may have been others who joined particular calls, but that was the call, that was the core of the team. And because of the confidential and highly confidential nature of some of the numbers and the issue we just discussed offline, there were lawyers to make sure that those of us who had access to all the information didn't violate the confidential and highly confidential verifications, I guess, that we signed.
And when you mentioned the others who may have been on some of the calls who were part of the clean team, do those people work for Norfolk Southern and CSX?
Some of them might have been but for sure there were attorneys representing those railroads on the calls to keep us from violating anything that we had signed.
Okay. So you've testified that several questions are better put to Mr. Dingler or Mr. Guthrie. Does that mean that those questions that those issues didn't come up during your audit?
No, doesn't mean that.
Can you please explain what it means?
It means that those gentlemen are better qualified to give you the answers to your questions.
Switching gears for a minute.
Could I just ask a question? I'm sorry to interrupt. Better qualified by terms of their qualifications or by their knowledge of the facts of this case? Which do you mean, Mr. Bank? Because I think there's an interest in all of us directing questions to the people who have the knowledge and not just pursuing it to find out who has the knowledge. So maybe you could speed this up.
They are what I would consider practitioners of RTC modeling. I've sat in the chair of the modeler before at RLBA, but I didn't sit in the chair or next to the chair that was controlling the model. So I thought those who had, i.e. Messrs. Dingler and Guthrie, would be in a better position to answer the question.
All right, but you're talking in terms of their familiarity with this record, not their qualifications as experts in the field. That's
no, not their qualification. That has nothing.
Well, that's what you use the word qualification, which threw me off. I'm sorry.
My mistake.
Ms. Bracy, go ahead.
So switching gears for a minute to talk a little bit about operations that are modeled in the RTC. throughout the day, a train may switch cars, is that right?
Yes,
And a train may change crews, is that right?
yes,
And the switching of cars can happen on a siding, is that right?
yes,
And the changing of crews can happen on a siding, is that right?
I suppose so.
And the switching of cars can happen in an industrial complex, is that right?
Yes,
And the changing of crews can happen in an industrial complex, is that right?
I suppose so. I would defer to the two gentlemen who follow me because railroads sometimes have their own every railroad has its own operating rules, and the operating rules of Class 1 railroads are largely aligned, but they're not completely aligned. So I think that question would go better to Messrs. The next two gentlemen who are going to follow me, Mr. Johnson and Mr. Hunt.
Crew changes on the main line have the effect of slowing down the model, is that right?
As compared with what?
As compared with models where you don't have crew changes on the main line.
So if you're comparing two model runs, one in which there is a crew change and one in which there isn't, is that the hypothetical you're posing?
One in which there's a crew change on the main line and one in which there is not.
Well, where is the one where there is not, where is the crew changing? Because if it's changing on a siding and you have to slow down to go into a siding, I don't know that I would give you the same answer. In fact, I wouldn't. Because if you have to slow down to go into the siding, then yes, you're consuming time and slowing down and accelerating to get back out, which may or may not be the same amount of time you've consumed changing crews on the main. We also would need to establish whether the train is going to come to a complete stop or not. On some railroads, the trains don't stop when the crews change. They keep going. They slow, to be sure, ma'am, but they don't stop.
Okay. You wrote in the RTC report that movements of the trains are supported by the Ross and Sinkonen rebuttal verified statement. Is that right?
I believe so.
And they rely on dispatch data. Is that right?
Are we talking about reference to something in particular?
Well, in their rebuttal verified statement, they rely on dispatch data.
They rely on several pieces of data, and dispatch data is part of that.
Okay. And this dispatch data is confirmed by field personnel. Is that right?
That is my understanding.
Okay.
We went to the field personnel to verify the data so that when they handed it to Mr. Dingler, they could assure him that it was as accurate as possible.
And those field personnel did not provide verified statements in this case, correct?
That is my understanding.
And those field personnel are not witnesses in this proceeding?
That is also my understanding.
And the statements of the field personnel have not been provided to Amtrak. Is that right?
What statements?
The statements the information that they provided to Ms. Ross and Ms. Sinkanen has not been provided to Amtrak. Is that right?
My understanding is there are no statements. Ms. Ross, Ms. Sinkanen interviewed the people in the field and they took notes. The essence of those notes were communicated to Mr. Dingler, eventually to Mr. Guthrie. I did not understand there to be any statement. I could be wrong.
Those notes that Ms. Ross and Ms. Sinkanen took were not provided to Amtrak. Is that right?
Actually, ma'am, I do not know that because that would have been done through the lawyers.
Okay. So we're going to talk a little bit about the permit file. The RTC model allows the user to program maintenance windows at certain locations. Is that right?
I understand.
And programming maintenance windows is done in one type of permit file. Is that right?
Similar, that's my understanding.
And one type of permit file includes bridge openings.
Yes,
And another type of permit file includes track failures. Is that right?
it sounds logical, but I can't confirm it. You should ask either Mr. Guthrie or Mr. Dingler about that.
Track failures require maintenance. Is that right?
Yes,
And maintenance windows also require some degree of maintenance. Is that right?
I really don't understand your question, ma'am.
Well, when those maintenance,
Windows require maintenance. Maintenance windows are put in the model to represent the occupation of the track required to perform the maintenance.
and in the model, the RL Banks and Guthrie and Dingler model, the maintenance prevents freight trains from using the track. Is that right?
Yes,
But it allows passenger trains to proceed. Is that right?
I believe that is correct, because our objective was to provide as unimpeded a path for the Amtrak trains as possible. Because again, the objective was to replicate what we think would happen in the real world. And in the real world, CSX and NS would go out of their way to schedule the maintenance at a time when the Amtrak trains would not be operating.
So are you familiar with the term on-time performance?
Yes,
And per the FRA's regulation, Amtrak trains have to meet the metric of 80% on-time performance. Is that right?
that's right.
And an abbreviation for on-time performance is OTP. Is that correct?
Correct.
And you modeled a 95% OTP. Is that right?
I'm not going to directly answer your question. We didn't model any percent. We chose the on-time performance was an output of the modeling assumptions that we made with or without improvements. We did not target any OTP.
The 95% OTP is higher, 15% higher than the 80% required by the FRA regulation. Is that right?
Yes,
And the model assumed that the 95% OTP in the RTC model equaled an 80% real world customer OTP. Is that right?
would you please repeat that?
Sure. And the model assumed that the 95% OTP equal an 80% real world customer OTP. Is that right?
I would prefer not to answer that yes or no, but let me give you an explanation. And if you want to follow up, I'll do the best I can to respond to it. The model didn't assume anything. We made assumptions about, we made a whole series of assumptions quite clearly. And one of those assumptions was that we would need to have a much higher OTP than THAN 80% in order to achieve the additional OTP metric that Amtrak had communicated it wanted us to achieve. You cannot set the RTC for the Amtrak newly enhanced OTP metric. So we had to go above 80%. And it was we discussed this, I'm sure, on at least one clean team call and maybe more than one. We had to agree on a percentage above 80% in order to make sure, have great confidence that we would be able to achieve the more demanding OTP that Amtrak communicated to us they wanted us to achieve.
And you did not rely on any studies or analyses showing a 95% OTP would equal an 80% real world OTP?
We did not. It was the collective judgment of Mark, Larry, and Charlie. Between us, we have, I don't want to count, 80 plus years of railroad experience. And there were others on the call, I'm sure, who contributed, including an ex-dispatcher.
And who was the ex-dispatcher?
It's either Holly or Hannah. I'm sorry, I don't remember which one.
So the 95% OTP was arbitrary, is that right?
Well, you can use that word, ma'am, if you want. I wouldn't use that word. We did not have a scientific basis to inform us as to how much higher than 80% we would have to go in order to satisfy Amtrak as a customer. So we talked about it, probably ad nauseum, and the collective consensus was we better shoot high because it's an extremely exacting metric.
You used the 95% OTP as the basis for your conclusion that 14 infrastructure projects were required. Is that right?
I don't really see it that way. That was not the driver standalone of these projects. We're trying to satisfy a lot of different requirements. Amtrak requirements, to be sure, but we also had the requirements of our connecting carriers, of the customers that the locals serve, of the through trains, of the people being delayed at grade crossings. We had a lot of gods we had to satisfy. And so there's no one particular driver. I would not say that the 95% OTP figure you keep referring to was the driver of the 14, of any of the 14 projects.
An exhibit to your study was the Niemeyer report, is that right?
Yes.
And the Niemeyer report contained cost estimates, is that right?
Yes.
And those cost estimates were based on the results of your RTC model, is that right?
Well, let me word it this way. And if you seek clarification, I'll be happy to help. Mr. Niemeyer was a subcontractor to R.L. Banks and Associates. The modeling effort resulted in identifying a series of, if you want, pinch points or particularly problematic areas. It was the responsibility of the clean team to come up with projects that would mitigate most of the deleterious effects of adding the Amtrak trains. We communicated the problems and the locations of where the problems occurred on the RTC model. As far as I know, Ted never saw the RTC model, but we communicated to him the projects, the set of projects that we thought would best address the combination of problems that the RTC communicated through its outputs. And it was always Mr. Niemeyer's responsibility to cost out whatever projects we sent to him based on his firm's prior experience in determining units and, of course, applying unit costs. Mr. Niemeyer, by the way, and one of his associates were on the same extensive visit to the pinch points that I referred to during part of my direct that Mr. Guthrie was also part of. We thought it was important for him to see the specifics because of all the water problems and the swamp problems and grade crossing problems. You can't always build things exactly where you would like to, and when you can't, then things end up costing more money than they otherwise would. There is no substitute for seeing rail lines in person, and so he did attend those, and I'm sure his costs reflected that visit.
He also could not have done his own RTC model because that was not his expertise. Is that right?
That's correct.
Okay. The RTC model also contains trains that are not actually trains. Is that right?
Well, I would prefer not to put it that way. What the RTC model does is keep track or account for, if you prefer, all occupations. I think I referred to this when Mr. Warren led me through the step 1, step 2, step 3 issue. In step 2, any occupation of the track that consumes track capacity needs to be reflected in the model if the model is going to accurately depict what the host railroads and Amtrak are going to encounter should this service be implemented. Doesn't matter to the model whether something is a train or not. Trains generally have symbols, but if something doesn't have a symbol, train symbol, that doesn't mean that it doesn't occupy the track. But if you run an Amtrak train into a cut of cars, there's clearly track occupancy. So you should not think of it as trains. It's going to, no pun intended, lead you down the wrong track.
And the trains or the parts of trains that you're referring to include blocks of cars, is that right?
That is correct.
And also include high rails, is that right?
High rail vehicles and light engine moves. Yes, ma'am. And track occupations that you referred to in an earlier part of your question.
And
Sorry,
also,
for maintenance of way, sorry.
No, go ahead.
Did you hear me? Maintenance of way work is also a track occupation.
Okay. And train movements, is that right?
Yes,
Are also included? Okay. And these are not represented, the blocks of cars, the high rails, and the train movements are not represented in the data file. Is that right?
that is a question better put to Mr. Guthrie.
Ms. Bracy, let me just ask, no intent in cutting you off. What is your estimation of how much longer you have with this witness?
$10 minutes?
Say it again.
10 minutes?
Okay, because we're getting close to a break, but I'd like to let you finish if that's the I'm not going to hold you to 10 minutes. I just want an approximation. So proceed.
Thank you, sir. You counted a single train making multiple movements as multiple different trains in the model. Is that right?
That is correct.
And you identified 174 yard train movements as individual trains. Is that right?
I haven't committed that number to memory. Either Holly or Hannah are primed to answer that specific question. But I understand why it was done. It's difficult for me to express it adroitly, but I think you will be satisfied by the answer you get to that question of the following witnesses.
Well, the more trains that are in the model, the more congestion there appears to be. Is that right?
For a given supply of capacity or infrastructure, the more occupations, whether they're trains or any other occupation, is going to constrain the available practical capacity left.
And that means that the model is going to run more slowly if you add additional trains. Is that right?
Well, I'm inclined to say, run the scenario and let's see. There is a trade. It's not as, I don't think I can give you a simple yes or no answer. If you ran more shorter trains, there are some advantages of running the shorter trains. They can fit into more sidings. But there's some disadvantages because you're running more trains. And it is precisely because human beings can't make, because it's a complex set of equations that one would have to think through, that the RTC model is such a good model to rely upon because it's built to answer those very what if questions.
And based on your inclusion of trains that were not in the data, your model also included more trains that were foreign trains, i.e. not CSX or NS trains than actual CSX or NS trains. Is that right?
Would you please repeat that question?
Sure.
Don't rephrase it, just repeat it, please.
Okay. And based on your inclusion of trains that were not in the data, your model also included more trains that were foreign trains that were not CSX or NS trains than actual CSX or NS trains. Is that right?
Yes, as I alluded to in an answer to one of Mr. Warren's questions, New Orleans is a very large interchange point, certainly one of the 5 largest interchanges in the United States. And there's a tremendous number of trains between NS and the Western connecting carriers in New Orleans, as well as between CSX and those same carriers. And we need to reflect on within the RTC, the movements of those trains, or we are overstating the capacity, the practical capacity available to host both Amtrak trains and freight trains.
And it is unusual to have, let me not withdraw. There were also 140 trains that have no underlying data because they were based on descriptions provided by NS to the modelers. Is that right?
Again, I haven't committed that number to memory, but I believe Holly, when she speaks on behalf of NS, she was the primary modeler who provided inputs to Messrs. Dingler and Guthrie. I think she will be able to answer your question about that number.
Did you ever run the model to less than 95% on-time performance?
I would ask Mr. Dingler that question.
If I could just have a minute before I finish.
Certainly, Ms. Bracy, go ahead.
I have nothing further.
Thank you, Ms. Bracy. Before we begin, Matt, do you have redirect, and if so, ballpark of how much time you need?
I have exactly one question, Mr. Chairman.
Why don't we do it and then we'll take a break? But that's it. If you ask more than one question, we're taking a break.
Okay.
All right.
Charlie, earlier Ms. Bracy was asking you to see if you could recall as many members of the clean team as you could, and you, in your list, you named Ricky Johnson. Just to clarify for the record, was Ricky Johnson from CSX a member of the clean team?
I can't say for sure if he was. There were, oh, I'm sorry. No, I'm sorry. There was another individual who was essentially a stand-in for Mr. Johnson, representing CSX. His name escapes me at the moment, but no, Mr. Johnson was not.
Thank you. Only one question.
All right. Well done, Matt. So here's the plan. We're going to take a 10-minute break. We've been going for 2 hours. I have some questions. Board members may have some questions. So Mr. Banks, we'll ask you to stick around. And the thought occurs to me, Matt, I'll say it now while it's fresh in my mind. I want to think about this. You know, this is a proceeding without depositions, and I have no criticism of any counsel. Obviously, if you take depositions of witnesses, then you have a much better idea about where their knowledge starts and stops, and you can proceed accordingly. Ms. Bracy did not have that advantage, and so we were constantly running up questions where perhaps a different witness would be better. It strikes me that because you have several witnesses who were all involved in this study in one way or another, we may run into a situation where some witness says, well, Mr. Banks is the person who knows the answer to that question, and Mr. Banks will already have testified. So I could anticipate the possibility, I'm hoping this does not happen, depending on the importance of the question, we may find ourselves a need to recall some of these people as the back and forth goes, because we just don't have, it shows you the advantage of having thorough discovery to make trials move faster. We just don't have it. So I'm just making the observation. I'm not asking anybody to agree or disagree. Hope the problem will not arise. But I'm sympathetic to Ms. Bracy trying to plow through with a witness without knowing exactly where his familiarity with the case starts and stops. So with that, we are at 3:42, so we will reconvene at 3:52, or as close there to as we can. Thank you all. Right, we are back in session. And I have a few questions for Mr. Banks, and other board members may as well. Mr. Banks, I'd like you to tell me your role. You said you were brought in to conduct an audit. In the context of your job and this RTC study is an audit. What did you do?
I use that word, sir, as a shorthand, shortcut to the following.
Fill it in for us if you can. Thank you.
Sure. We were hired to review, make recommendations, and propose fixes based on our review of the Gulf Coast RTC report draft that was then extant.
When you say we, you mean your firm, you
My
and Mr.
firm.
Guthrie.
Me and Mr. Guthrie, yes, sir.
And when you say the RTC report that was then extant, do you mean the one that was done by HDR?
No, I mean the draft that Mr. Dingler had prepared.
Okay, and that draft has not been submitted to us, has it?
You have a thoroughly vetted version of that draft.
And you mean the final report?
Yes, sir.
Well, we don't know what it looked like before you changed it.
That's correct.
Who wrote Exhibit 23D, the one you've been looking at?
Just a moment, please. Are we talking about the RTC modeling report dated November 3rd of 21?
Correct. That's what I'm talking about.
The report was, even this version of the report, sir, was drafted by Mark Dingler, but both Mr. Guthrie and I suspect, I cannot confirm, other members of the clean team were circulated this report and asked to make comments. And speaking only for myself, I made a number of comments about it. You can ask the other witnesses when they come up what comments they may have made.
All right, so, well, you said you made comments. Did you edit the language?
That's what I mean by edit. Yes, sir.
Well,
Track change.
Comments and edits are not always the same thing. I'm trying to
Well,
figure
okay.
out.
Also, I suggested some substantial reorganization of the report because I thought it would be difficult for the members to read the way it was organized.
Well, there are a number of questions I have about the language in the report, and I don't want to waste your time or the board's time. But do you stand behind the language in this report? I mean, do you sign off on it before it
I
was
do.
finalized?
I do.
Because there were quite a few questions, and I don't want to get into this where you said ask somebody else. So I'm trying to find out, when you say audit, it was you and Mr. Guthrie. What did you personally do as it relates to this project?
I personally read the report, first version thereof, communicated my comments, discussed my concerns and questions and comments with Mr. Guthrie internally. And to the extent the two of us decided to forward those comments into discussions of the clean team, we advance them, either Larry or I, depending upon, I guess, whose question it was. We worked as a team, hence the name Clean Team. So I can't tell you this paragraph is mine and this one is Larry's and this one is Mark's, et cetera, et cetera. We worked collectively, very effectively and very collegially to produce a document that we all felt comfortable signing. I'm happy to entertain questions about specific pieces, and if I need to redirect you to somebody else, I will, and if I can answer it myself, I will.
Were any of your comments and edits rejected?
I can't think of any.
Well, did you have a written record of the comments you made on the draft? Did you retain that?
I believe I have.
Well, I would say this, Mr. Banks. Mr. Warren has presented you as one of the leading experts in the world of that we're dealing with here in modeling and RTC work and so forth. And I think it may well be enlightening to know what's in here that you didn't agree with or that came out differently. I'm going to leave that for the moment, but I am raising it as an issue that I'm personally, as a board member, would find enlightening. But let me direct
May I
you to.
respond to that, sir, even though it's not in the form of a question?
Sure.
There is nothing in this report that I don't agree with. I may have made an edit and it may not have survived to the draft that the members have before them. But if I didn't agree with it, it wouldn't be in the draft before you. But you need to appreciate that we worked as a team, so somebody may have had a better idea than my edit.
Right. Well, whether it was a better idea, though, I think ultimately is for this board to determine. That's why I asked the question. And I don't know what they were, so I'm not making any prejudgment, but I can't make a judgment on something I haven't seen. You said that the model, when Ms. Bracy asked you if the model was aimed at attaining a 95% on-time performance, according to my notes, you said the model didn't aim at any percentage of on-time performance. Correct?
That is correct.
But it is true that the 14 projects that were selected so that the model would produce a 95% on-time performance. That is correct, is it not? Well, let me move this along, Mr. Banks. I'm in my version of the report. I maybe it got out of the Xerox machine differently. I'm on page 27. It's section 3.5.
Okay, I'm with you. Thank you.
Are you there? The
I am.
second sentence in 3.5 says the project selection must meet the following criteria. Number one, provide capacity to achieve above 95% on-time performance for passenger trains. So that's a true statement. You stand behind it. You said nothing would be in here that you didn't agree with.
What I'm trying to communicate, apparently not very effectively, is that any individual improvement among the 14 has differential effects on a series of metrics that we have shared with you in this report. And yes, we wanted to make sure that collectively the improvements yielded enough, what would be the right word, enough of a differential so that in reality, the host railroads were confident well, we were confident that the host railroads would be able to deliver service in accordance with Amtrak's new OTP metric. And as I said in response to the cross, there is no, one can't push a button or turn a dial on the RTC report to achieve that. So it is really an expert judgment call.
Well, I appreciate what you're saying, but I wonder if you could answer the question I put.
All right. I'll try.
14 projects were selected. So when they were put into the RTC model and you ran it, it would provide above 95% on-time performance. That's what you wanted the RTC report to be able to turn out by the project selection, correct?
That's one of the things we wanted it to.
Yes, there's three things here. That's one of them.
Yes.
All right. Now, I want to follow up on what you just said. You said in your answer to Ms. Booley that there was no scientific basis for the 95%. I'm not sure what you meant by scientific. I assume that you meant, but you tell me if I'm wrong, that there's no data that we can look to say that if you need 95% in order to achieve 80% in the real world. There's no data that you relied on, correct?
That is correct. And even if there were such data, we don't know that the data that it was based on would apply to this corridor.
So it is the judgment of you, Mr. Guthrie, and Mr. Dingler that said, we're going to pick 95% as the measuring stick in order to have confidence that in the real world, there'll be an 80% OTP. Is that your testimony?
Yes, sir.
And did any of you come up with a different idea on 95 other than 95% before you all agree that 95% was the number?
If we did have that discussion, I do not recall. I'm sorry to do this, but I think that's a good one for Mr. Dingler.
Well, you were in the discussion, so it's a good one for you too, isn't it?
Yes, sir.
When did you have the discussion?
It would have been somewhere in October or September. I did not keep an agenda of which items were discussed during which calls.
Did you make any notes, rough calculations of how you, well, let me withdraw that. Were you one of the people who suggested 95% or was it somebody else and you agreed with it? How did that come up?
Somebody else and I agreed with it.
Somebody else brought up the number.
Yes, sir.
Who was it? Who was it?
I do not know, but I would start with Mr. Dingler. Ask him.
All right. Did you make any notes at the time of your own thoughts about whether 95% was the right number or how you got there?
No, I didn't, because it seemed to me that it didn't really lend itself to a lot of the kind of grounding that one would like to have, because it's unprecedented.
Did Mr. Dingler, to your knowledge, make any notes?
You'd have to ask him.
Well, I'm asking to your knowledge.
My knowledge, no.
How about Mr. Guthrie?
I don't know that he made notes on this particular topic either.
Are you the only three experts in the rail world whose judgment you would respect on whether 95% is the right number, or are there others out there?
Of course not.
Of
course, there are other experts.
Other experts whose judgment you respect, sir.
Yes, sir.
So all we have to go on is your statement that this is the combined wisdom of three people who have been brought forward in this case on your side of the case. There's nothing else we can look to determine whether achieving a 95% in the RTC model is the right number.
That is correct, but
Oh,
one
all
of the
right.
reasons I keep returning to the RTC model is we could run it with a different percentage and see where we end up.
You
See what
could.
that would mean in terms of improvements.
I'm just looking at the evidence that's in front of me right now, Mr. Banks, and I understand there could be other evidence, and we may get there someday in this case. Secondly, again, on page 27 in section 3.5, the report states, and you stand behind it, the project selection must meet the criteria, number 2, of restoring freight traffic performance to at least the same as before passenger trains were added. You approve that language.
Yep.
So that the standard by which we are to determine whether, and you know, you've probably heard the lawyers say, some lawyers say we have the power to make some orders regarding how much infrastructure needs to be built. If we ordered all 14 projects to be built, the information that your study is providing to us is that would allow no degradation or diminishment in freight traffic performance, because it would be the same as it was before passenger trains were added, correct?
I can't answer that with a straight affirmative. I think the wording of number 2 could have been better. I think we were trying to get our concept across, and I certainly okayed the wording, but if you look, for example, just at page 34, just as one example, you will see that we provided a series of metrics. Some of those metrics, none of those metrics match, because when you put in a particular improvement, let alone a set of a bunch of improvements, they're going to have differential effects on these metrics, METRICS metrics. And so what is unfortunate about the wording of 2 paren on page 27 is that it suggests that it's exactly the same, and it isn't. We were attempting to achieve a balance, okay? But some things are better and some things are worse. Whether we would put the improvements in or not, that's just the nature of the beast. We shared as many metrics as we thought the members would find useful.
Mr. Banks, you were brought in here as one of the foremost authorities on RTC studies. You audited the process that resulted in this product, and CSX and NS are offering this to us as evidence on which to reject Amtrak's petition. And I am looking at language which you said you signed that says the project selection must meet. You don't say approximately to meet or may meet, or it would be helpful to meet. You say it must meet a level to restore freight traffic performance to at least, it's not the same, not approximately the same or close to the same, at least the same as before passenger trains. Now you're telling me that that's an unfortunate way to express it and I shouldn't rely on it. Is that where we are?
I think you can rely on it, but I don't think the wording is as exacting as it could be. And I've attempted to explain to you why not.
Well, you know, when you say that, Mr. Banks, it causes me to wonder, do I have to go through every line of this report and find out which of the wording is something that could have been stated better? This is all I have. So I'll just leave my observation there on this point. But you know, when you say something's the gold standard, and then you start having to say that the gold standard has defects in the way something's presented, I wonder if it is the gold standard and how we are supposed to have a record on which we can rely on.
All due respect, sir, you are conflating the model with the report.
Well, the report is of a report of the workings of the model. That's the way I understood it. I have a few other questions here. Is Mr. Niemeyer, who you referred to, the person who came up with the costs of the 14 projects?
Yes.
He's not listed as a witness. Is there any witness to your knowledge here who can tell us how the costs of these projects were arrived at?
I'm willing to attempt to answer those questions. Mr. Niemeyer was not listed as somebody Amtrak was interested in talking to, or we would have produced him. But I'll do my best to answer your
Well,
questions.
I'm not faulting anybody for producing or not producing witnesses. I'm only trying to find out if I don't want to waste your time or the board's time in asking questions about costs of somebody who can't answer them. So I have to find my notes on this subject, but if you can speak to how the costs were arrived at various projects, then I'd like to direct some questions your way on that point.
So I don't want to interrupt, but Mr. Chairman, if it would be helpful, I mean, Mr. Niemeyer's report is in the record, and Amtrak agreed that they wouldn't call him as a witness, or that we didn't need to produce him as a witness, just as we agreed with one of the witnesses who put in evidence for Amtrak. So I think his verified statement is already testimony that's in the record. And
no, I understand.
Mr. Banks can answer your questions to the extent of his knowledge. That's fine, but I don't think it's quite right to say that there's nothing in here, because we do have written testimony.
I'm sorry, Matt. I didn't suggest there was nothing in here. The question whether I have a witness I can ask a question about, Mr. Niemeyer isn't here. So let me just try one. I'm not going to go through all of them. There's a list of projects that I have that from your study that have costs associated with them. And for example, one of the projects is to build a double track from Choctaw to Brooklyn, which is 14,000 feet, which is just under 3 miles. And the cost estimate is between $66 million and $71 million, which is, over $20 million a mile. Are you able to talk to how that number was arrived at?
Not specifically, no.
All right. Well, those are the kind of questions I have. So should I not waste any time asking you about them because you couldn't specify?
Yes.
And by I say waste time, I don't mean to criticize you at all. I just want to ask the witness who has knowledge.
If I could,
is there any way for? Pardon me?
If I could just speak to the process.
Sure.
Mr. Niemeyer and I discussed how we would proceed, and he did it in a very conventional way. The same way, frankly, my firm would have done it had we had the capacity to produce all of these expenses in a relatively short time frame. He went out and looked at the territory. He developed units, various units, and then he applied unit costs based on his project work that he had done all over the country, including on behalf of Metra. And then he checked his unit costs individually with CSX and NS to see how his numbers stacked up against theirs. And if he thought it was inappropriate to make an adjustment for something that was specific to the area, he made that adjustment.
How do you know that? Did he tell you that's what all the things that he did?
No, that's what I told him he was gonna do.
Didn't he know how to do it without your telling him?
I just wanted to make it clear to him what the process was gonna be.
All right. When he came back with his numbers, you didn't study them to see if you agreed with them?
Well, I'm not an engineer, sir. That's exactly why I provided the work to him, but I didn't see anything wrong. I did look at them and they looked reasonable to me.
Well, it may be that they are. I'd just like to find out how they got there. Let me ask you this. In doing your work here and coming up with the costs, were you aware of the estimate that came from CSX back in 2016 that it would cost roughly $1.1 billion to build the needed infrastructure between New Orleans and Mobile?
I was aware of it. I had not studied it in detail.
So you didn't try to compare that to whatever numbers your study was coming up with? See
No,
why
I did
such a
not.
big difference?
I did not.
Were you aware that back in that time frame, there was a period of time where CSX changed its mind and came up with a number closer to a little over 400 million, which is what the number is now being proposed in the current RTC report? Were you aware of that?
No,
So that had no bearing on your coming up with a $405 to $440 million number in this report.
it did not.
Were you aware that in 2021, according to news reports, CSX estimated the infrastructure that would be needed was only $140 to $160 million?
I was not aware of that.
Well, it was in the press, so I don't know if they did or didn't. We'll find out, I suppose, before this hearing is over. Were you in any way responsible for which runs, I guess is the right way to say it, were run by the RTC modelers? Did you have any input into, this would be something Mr. Dingler did originally, is that right?
Yeah, he did them originally, and I think the best answer I can give you is that to some extent, the comments that Larry and I and other members of the clean team gave to Mr. Dingler resulted in additional runs. Whether there were runs that preceded our involvement in the job and remained, I just didn't keep track of.
Did you?
There could have been some originals that remain in what you said.
But you were in a position to tell Mr. Dingler runs that you would like to see made, and you did so. Is that right?
Yes, but our advice, we think, Larry and I thought that the structure of the way in which the report was originally put together, not its communication, but its structure, was structurally sound. Our analyses, our critiques went more to specifics of the inputs. So there was always a 2019 base case, and there was always a 2019 passenger case and a build case, and same for 2039. That didn't change. But what was in those cases is what we gave a thorough scrubbing of.
Well, did you have the ability in your assignment to tell Mr. Dingler you'd like to run another case, the one that he hadn't run?
Yes.
And did you?
No.
So you thought all the cases that he had run were adequate for the assignment you were given? Fair
Yes.
statement?
Yes, sir.
All right. Well, one of the questions I have is that there were a lot of cases that were run. I've tried to keep track of them. There are too many. really for me to have in my mind, but I have notes here, so let me find them because I have a couple of questions about that. I just had them in front of me 2 seconds ago. Here they are. So you ran the 2019 base case, and then you ran the passenger case, and then you ran the build case with the 14 projects, 2019.
Yes.
Correct?
Yes, sir.
When I say you, the team,
Yes.
Mr. Dingler with your input. Then you also ran the 2039 base case. Then you did the 2039 passenger case without any infrastructure. And then the build case with the 14 projects, right?
I'm sorry to introduce this complexity into it, but we actually build the 2039 build case first. And the reason for that is that we don't want to introduce improvements in 2019 that we don't need in 2039. So this is a very conventional RTC approach for experienced modelers. You build the improvements you think you need for 2039, and then you see if you still need them in 2019.
All right, so you go up to the future and work backwards is what you're telling me.
Exactly.
All right, but so when I said and then, I didn't mean to suggest what order you did. I don't know what order you did the tests in. We just have the results of the test, which is what you want us to pay attention to.
Exactly.
And you ran a 2039 passenger case with the FRA infrastructure projects, i.e. the ones identified in the Gulf Coast Working Group, separate and apart from the 14 projects that you're now recommending, right?
Correct.
But I do not see, Mr. Banks, that you ever ran a 2019 passenger case with the FRA projects. That's correct, is it not?
I don't know that we did. Sorry, I can't sit here and tell you that we did. My focus was really on the 6 primary cases that we ran.
Well, but you said that part of your role was to tell Mr. Miller if you thought other cases should be run. You reviewed what he had run, and you must have known what he ran in order to conclude that ran was an acceptable number of cases.
I didn't place a priority on running our case with the FRA improvements because we had already come up with an independent set of improvements, and I thought there were enough cases out there.
Well, I'd like to see if I can get a clear answer to the question I put. Somebody determined to run a 2039 FRA case. Who made that decision, Mr. Digler?
I believe so.
And you told me a minute ago, you were in a position to say, Mr. Dingler, I think here's another case you should run if you thought it should be done, correct?
Yes.
That was part of your assignment. When you say audit, one of the things you were supposed to do was to determine and evaluate the work Mr. Dingler had already done.
I agree.
You said you didn't place emphasis. My question is, did you make a determination to run an FRA case with passenger trains on the 2019 case, as well as the 2039?
I'm sorry, I forgot how your question started, but I did not direct him to run the FRA improvements in those 2 years.
All right. Did you consider whether it would be enlightening to find out what the 2019 case would look like with the FRA improvements as distinguished from your projects, your recommendation for the 14?
I understand your question.
Yeah.
I didn't.
You didn't think it was, well, why did you run it for 2039? Why'd you run the FRA case for 2039?
I don't recall.
Well, you just told us you didn't put much priority on the FRA projects because you already had your own projects. So I can't figure out the distinction of why we have a record that has the 2039 FRA case, but no 2019 FRA case. Can you enlighten us on that?
The best I can enlighten you is that we had set up, we had finished a number of these runs. I would have been happy to not include them, but we discussed it and we thought, well, we've done the run. Maybe somebody will find it enlightening, so we'll include it.
That's your best answer, then that's your answer. I apologize to my fellow board members, but I do have a few other questions. And I promise them they will have ample time. You may have to come back in the morning. But I'd like to finish my questioning as much as I can here with their indulgence. In the 2039 case, I'm looking at page 21. I'm sorry, 23. Section 3.3 of the RTC, same exhibit we've been looking at. The report states.
Any particular paragraph, sir? I should.
Right at paragraph 3.3.
Okay.
In that paragraph, the last line says, refers to a 2% annual growth mentioned in the FRA guidance manual. You see that language?
I do.
And the FRA guidance manual deals with what?
I don't recall. This was not my ad. I do remember looking at it, but it seemed to me the important issue to me was that we were not attributing growth in excess of guidance provided by the FRA.
Well, but to know whether it made sense to know whether whatever number you took in comparison to the FRA guidance, wouldn't you have to know the basis on which the FRA arrived at its 2% guidance?
I knew at one time. I don't know now.
Did you know last fall when you were working on this project?
That's what I meant by one time. Yes, sir.
So in doing your work on this project, you made no independent evaluation of whether using 2% as a starting point. And I understand you say you actually reduced it to 1.5. You made no independent evaluation of the soundness of using that number to do this study. You just took the FRA's word for it. Would that be fair?
That is correct, but I personally do a lot of forecasting of freight rail growth all over the country. 2% growth doesn't strike me as out of the realm of reasonableness.
Mr. Banks, when you do your forecasting, do you also look at the experience of the railroad that you're actually doing the forecasting for? Or do you just pick the number out of the manual and always use that?
When possible, which it usually isn't, I like to base the forecast on the customers who will be generating the freight, talking to them directly. Unfortunately, that is very challenging. So yes, I do tend to look at the growth rates in the absence of being able to talk with the shippers directly. Obviously, looking at historical trends is a good idea.
Well, Let me ask this question. Do you look at the historical trends for the railroad that you're actually evaluating it for? They're not all the same, are they?
Yes,
Yes, you do.
yes, I do.
In signing off on this RTC study, did you look at the historical trends of CSX's growth?
No,
Do you know if anybody else on the team did?
I don't.
Would it make any difference in your conclusions about what growth rate to use if you had learned that since 2005, CSX non-intermodal carloads have actually declined over time over the last 17 years? Would that affect the growth rate you should use of any growth rate going up?
Well, first of all, what you said doesn't surprise me. But what happens when you take coal out of the mix? Then what happens?
Well, I'm not really here to answer your questions, Mr. Banks. I'm just wondering if you would have changed the number you would use if you had learned that their non-intermodal traffic had declined over time over the last 17 years in terms of predicting the growth rate over the next 20.
If it is difficult, I like to stay away from averages because the fact of the matter is that while CSX and NS, everybody thinks of them as Southern railroads, the fact of the matter is they also serve the Midwest and they also serve the Northeast. And the average masks the fact that the Southeast economy, insofar as it affects freight railroad carloads, is much stronger and growing in a different direction. So I don't really care that much. I don't think it's that useful to just look at the gross average carloads. I understand why you went there. It's perfectly reasonable, but it isn't that informative to me because the economies of Alabama in particular and Mississippi, Louisiana is a very strong generator of railroad freight traffic, and increasingly traffic is businesses that use rail are moving to states like Alabama and Louisiana. It's been a while since I've done specific projects in Mississippi, but Mississippi is also pretty strong, and those are moving in completely different direction, unfortunately, than the Middle Atlantic states where I live. So the average is to me not particularly important.
Well, then I guess the average that the FRA uses to arrive at 2% wouldn't be very important either. Would that be right?
No, but it has the patina of legitimacy.
And that's the basis of your using it, the patina? Well, good. You don't need to answer that question. Would you put any weight in estimating future growth on not only, you pointed out there are different economies in different parts of the country, would you put any weight though on, to any degree, on the experience of the railroad involved? Because railroads have different growth strategies, as you know, and therefore, would you agree that CSX's growth experience or lack thereof would at least be a relevant factor to consider in figuring out the projection to be used here? Or would it not? Would it be irrelevant in your view?
I mean, I would consider the number, but I don't think I would put the amount of weight I would put on it would depend upon what other things I might be considering as well. And if any particular number was an outlier, then obviously I wouldn't rely on it. If a whole bunch of numbers lined up approximately the same, then it would give me confidence, more confidence in that number.
All right, but you didn't consider it here because you didn't even find out what the growth history was in CSX.
That is correct.
And to follow up on your point, which I think is a very pertinent one about looking at the economy in different regions, did you ask CSX to, or NS, but in mostly CS, to provide you with the growth history on this line? Even if you couldn't go out and talk to individual shippers, they have numbers, don't they, that would show you the growth or lack thereof of freight service on this line? Did you ask them for that?
I did not.
So you chose to not get any other input in approving this report in terms of building the 2039 case, other than for the reasons you just stated, to use the FRA guidance manual and then to discount it down to 1.5%. That was 100% of the basis of how you chose the 1.5% figure.
That is correct. Yes, sir.
Now, you may not be able to answer this question because it's somewhat of a legal question, but based on your extensive experience, can you tell me whether there's anything in the statute under which we're operating, 24308E, that directs you to consider a 20-year growth pattern in terms of measuring unreasonable impairment? And if that's a legal question, then I don't want you to take a stab at it and go beyond your expertise. But if you have some insight into it, I'd like to know the basis on which we should consider freight growth for the next 20 years.
I think it does call, excuse me, for a legal conclusion, but when we are doing work for our clients, whether they are railroad clients or suppliers of capital to the United States, it is standard practice to not just focus on the current year or a recent year. How far out someone goes varies from project to project, but I don't find it unreasonable to look out 20 years because the investments that the railroads make, whether they make them on their own or they make them in the context of a merger proceeding or direction from someone like the STB, a party like the STB, these are long-lived investments, very, very long economic lives. We're talking about decades of investment, and it seems, and they're expensive, and it seems to me that it makes sense in that context to be trying to look at forecasts. Forecasts are rarely correct, but it seems to me inane not to look out into the future and try to get a sense of how things might develop.
Well, I know that you are aware in this case that CSX is taking the position that this isn't a question of CSX choosing to spend its shareholders' money and making an investment based on such a projection, but it's CSX asking that the taxpayers spend this money. And we're charged with protecting the public interest, among other things. While we don't hand out the money, what we do may have an impact on what gets spent. And I'm trying to figure out what basis the board would have to say, you know, the taxpayers should spend $440 million because Mr. Banks came in here and said he was going to assume a 1.5% growth for the next 20 years. And as you know, Mr. Banks, the railroads so far have said all of that 440 million, they've retreated down to a little bit less than that lately, must be spent now before any trains run. So I'm looking for something in this record that would support a decision on that basis. And that's why I'm exploring these questions with you. Do you have any
thoughts?
Thing to give us comfort on that scale?
I'm sorry, give you comfort on what specifically, sir?
That we should order the taxpayers to spend $440 million today based on your report, the RTC report?
Well, in my response, I'd really like to break the issue into two pieces. One of them is whether the money should be spent or not, and the other one is when it should be spent. I have great concerns that if the money isn't spent before Amtrak service commences, that the service will fail, and that the failure will be blamed on the host railroads. Because who else are you going to blame? I mean, you're not going to blame Amtrak. So, and I have personal experience in traveling on Amtrak. In fact, every other weekend for several years during the time when the Northeast Corridor Improvement Project was going through. Now, that's a much bigger and more expensive project than we're talking about down here on the Gulf Coast Corridor. But Amtrak really could not maintain its schedule. And I am not a civil engineer, but you will have an opportunity to talk with Mr. Johnson about how the maintenance work would be done, the improvements would be done. And I'm extremely confident that he's going to tell you that every one of those projects of those 14 is going to affect the ability of Amtrak to operate reliably, because you're going to have to take track out of service. And there is only one track, one mainline track. So I think it's just imprudent, frankly, to try to commence service. If Amtrak starts with, I think the average was 20 to 30 riders on a train, how many trains are, how long are they going to be running trains that take an extra 2 hours above and beyond what they're forecast to take? If they really want to see the service be successful, they should be patient. I know there are issues pushing them in the opposite direction, but I cannot countenance starting the passenger service knowing full well that you're going to have, I believe, several years worth of improvements that can't help but impact the reliability. I hope you find that constructive.
Well, but your 14 improvements are based on the 2039 case, not on the 2019 case.
That's true, but 11 of the 14, you may recall, differentiated. Some of the improvements were not necessary in the first instance.
They were, but there is no, is there an RTC run with 11 improvements? There really isn't here on which we could base a decision, is there?
I would defer to Mr. Dingler or Mr. Guthrie on that, but I don't believe there was such a run, but we're confident that not all the improvements are necessary to commence service. Frankly, because the growth that you and I spent the last 10 minutes talking about won't begin to manifest itself in a way that really affects capacity until late in the 20s.
Yeah, if it grows at all. Let me do this. I have a number of other questions, but I have been dominating the time here, and I have at least 2 board members who have questions right on this point in the order that they contacted me. It's Patrick and Karen. So I'm going to shift the ball to them, Patrick first, and then Karen, and others if they have any, but we'll undoubtedly be back in the morning. It's 4:45 already. And then I have some further questioning that I ask you before we let you go.
Thanks.
Matt, I hope you don't mind, but I don't see any other way to do it. And I really want the other board members to weigh in here. So Patrick, why don't you go ahead?
Yes, I just wanted to somewhat briefly follow up, Marty, on the 2 points you explored with regard to the growth number and the on-time performance number. Mr. Banks, you did look at the 2% number in the FRA report, correct?
Yes.
So do you recall what that 2% number was in reference to?
I did at the time. I don't now.
So only because, as I understand it, you didn't look at the local economic growth. You didn't look at any of the commodities in the area. You didn't look at historical projections. You didn't look at CSX's internal projections. And you referenced a report from, I guess at the time would be 16 years ago. And I pulled up the report, and it seems to me that the 2% was in reference to mature commuter systems and not to freight. And it was in reference to a different geography than the geography that we're talking about here. So there's two possibilities. One is I'm mistaken in which 2% I'm looking at in the FRA planning model from many years ago, or there's a different 2% number that would be more applicable. But I'm wondering, when you looked at the FRA report, what gave you confidence that the 2% number was applicable? Let me ask another way. Is there a different 2% report than the one referencing mature commuter systems?
I understand your question, and I can't, I'm sorry, but I can't recall it well enough to respond. Maybe I can look at it over the evening and respond in the morning. But overarching, my view is that it is not at all unreasonable to assume 1 to 2% unit growth in carloads on the AAR, the class ones traffic. The revenue increases faster than that, but the carloads increase between 1 and 2%. You have to be careful to look at the commodities that are associated with that particular line.
I totally understand. You're making compelling points about the importance of looking at geography and commodity. I just haven't heard from you that you did that. So the only citation I have in the RTC report is from an FRA report from 17 years ago that seems to reference a number that may or may not apply. So that's the only thing I say is I understand the logic of your argument. I just was hoping that it would be in evidence. And then turning to the 95% number. Could you clarify for me, what is it? What did you base it on again? I missed that. I know there was discussion about people saying that you didn't base it on it, but I missed what did you base 95% on when you were auditing?
We were collectively, the clean team, looking for a number that would be high enough such that it would result in the more exacting on-time performance metric that Amtrak is insisting on, which is essentially, if I recall, stop by stop. It's not just getting to the last point, last station. It's a more exacting or demanding, if you will, metric. And so if you're going to be measured more frequently, then you have to build in more, I hate to use the word capacity, but you need to build in enough, a number enough higher than 80% so that you will meet the metric at all the stations where you're being measured.
So I think that the legal requirement is for a customer OTP at current, right? And so, and your 95% is calculated on what basis? Is it endpoints?
No, the 95% is, instead of coming up with 80%, if we used 80%, that's good. Let's try it the other way. If we used 80%, then the customer OTP would never be 80%.
And so
we had to go higher than 80% so that we could have more confidence that we would be able to satisfy the customer OTP.
And your 95% is by train by station, or is it by train by endpoints? I'm asking what is the basis of your calculation of 95%?
It's customer OTP.
So your 95% is customer OTP.
Sorry. You're asking what the customer, oh, sorry, you're
No,
asking
no,
what the
you're not, what
95%
your
is?
95% on-time performance. Could you, all right, so
It's the-
define
it's
the,
the-
let me ask it this way. This will be a better question. How about, can you define the numerator and the denominator of your 95%?
That is a better question. And why don't you ask that of Mr. Dingler?
Okay, and just, by way of background, I will ask this of a different witness. Did you look at any other state-supported routes, particularly on the NS or CSX, for 95% calculation for that cushion that you're describing? In other words, is there another state-supported route that comes to your mind besides perhaps the Hiawatha, but particularly on the NS and CSX, which I think would be maybe the Piedmont, the Pennsylvania, and the Carolina, and the Niagara Falls? Have you looked at their historical on-time performance to inform your 95%? In other words, are you aware of a state-supported route that would hit 95% as you've calculated it?
The short answer to your question is no. The longer answer to your question is, again, I'm sorry to tell you this, but I don't know how helpful that would be, because what is unique about this corridor, aside from the connectivity to the Western carriers, is the fact that freight operations today, even without Amtrak, have to run a literally a gauntlet from New Orleans to Mobile. You've got swamps, you've got movable bridges, you've got yards next to movable bridges, you've got single track, you've got quite a large industrial complex. I'm sorry, I've forgotten the name of the town, it'll come to me. And then just west of there, you have an extremely high density of grade crossings. Now, the density of grade crossings across the entire line is not unique, but the density just west of Pascagoula is very unusual. And it really makes it difficult for the freight railroads to operate as efficiently as they would like to, because they're just not places to extend or locate new sidings. So the reason I'm going where I'm going.
No, I appreciate that you did.
You can't really compare the two.
Yeah.
And that's our whole point. That's what
Right.
the RTC is good for, because it takes all those comparisons and averages out and says, on this district, this is what you're up against.
I appreciate your insights on that. One last one for me is, as I understand the FRA requirement, it's not an absolute 80%. And then, the host is definitively, responsible for damages. It's the 80% is the trigger for an investigation. And then there's an examination of to what extent the host's failure to provide preference caused the sub 80% performance. With that backdrop, and you talked about the 95% because the way you calculated it was meant to provide a cushion for the way that maybe FRA calculates it with customer OTP. Would you, if it were possible to calculate a customer OTP with the projected service, instead of however you calculated 95%, would you agree that 80% is the appropriate threshold given that flexibility in the FRA standard? In other words, you told me that the reason you didn't calculate it 80% is because you needed that 15% cushion because of the different ways you definitionally calculate OTP.
Yes,
But
sir.
modeling could be done so that you could definitionally calculate it according to customer OTP. Would that eliminate the need for the cushion? It's a complex question, but
I think I understand it. And I think if
Okay.
the model could do it, yes, that would be the way to do it. But my understanding is that that algorithm hasn't been entered in the latest software.
because you can't, it's hard to project where customers will be going on the line.
No, it's, I wouldn't, sorry, sir, but I wouldn't
No.
characterize it that way. The thing is, practitioners, RTC practitioners or modelers don't mess with the software. We give feedback to the person, the developer, and he, I don't know, annually or semi-annually sends updates. Okay? If those updates include customer OTP, we'd be happy to apply it.
Got it.
But
I
I don't know
appreciate
if
it.
anyone's brought that to the developer's attention yet.
I appreciate it. Thank you so much.
Thank you.
Thank you. Mr. Banks, Karen,
I just want to make one thing clear. Your 2039, 14 projects, those are required by growth in freight traffic, not growth in Amtrak traffic. Is that correct, between 2019 and 2039?
Yes, the operation of the Amtrak services was not changed between the 2019 case and the 2039 case.
Right, so that's all
Case is-
based on the assumption freight traffic will increase. By the way, did you take into account in the model planned CSX improvements on the line between now and 2039?
We did. We didn't reflect them in the 2019 because they weren't built, but we did
Okay.
reflect them in the 2039.
Okay. Then I just want to go back to what was stated in 3.5 on page 27. Projects were first selected to mitigate the passenger impact in 2039, not 2019. These same projects were used to determine which subset of projects are required to mitigate passenger operations in 2019, but I think you told us you haven't identified those. And then you say it would not be financially responsible use of railroad resources to propose to build projects that mitigated freight degradation in 2019, but would shortly thereafter become ineffective at reducing expected freight degradation in the near term. Now that's describing 2039. We're not, you say shortly thereafter and in the near term, but we're talking 20 years later. So I think there's a little gap kind of in the reasoning there. This is written in the passive voice, the way engineers typically write, and the lawyers always have a problem with that. And so the question is used by whom and paid by whom. And the point here is you may think that, if we were back in 1965 and the incumbent railroad was operating both freight and passenger service, your statement would be correct, but it doesn't take into account we now have two separate corporate entities, and one of them is supported by the taxpayer. And that's my only comment. That's all I have, Mr. Chairman.
all right. I'm sorry, Mr. Banks, did you have anything to add to that?
Truth be told, I did not, because frankly, when Karen started reading, I had trouble hearing her. I would have asked her to direct me to the testimony if she had a question, but since she had only a comment, given the late hour, I'm ready to call it a night.
I will say, and I don't want to step on any additional members who have questions, and I appreciate that Charlie's ready to call it a night, but I do think some clarifying questions might be useful to the board.
Well, let me say this. We're asking Mr. Banks to come back tomorrow. I have a number of other questions. So if he's ready to call, I was actually going to ask one more question just to make sure I'm clear on what we're talking about. But if you want to ask a series of questions, Matt, I'd prefer you wait until the board members finishing their questions. And you'll have ample time to give, you want to, whatever you want to call this, re-examination, redirect tomorrow. I'm not going to cut you off. Mr. Banks, I just to summarize this point before we move on. If I understand correctly, this whole idea about the 2039 freight case based on a 1.5% growth over 20 years, that is a 1.5% each year. Is that correct?
Yes.
So that your model projects that in 2039, there will be 30% more freight traffic on this line than there is today, or in 2019.
Yes.
Is there any place in the country where have seen an actual 30% growth over that period of time on freight traffic, rail traffic?
We're talking about an overall net number growth. Is that correct, sir?
It's your report, sir. You seem to be talking about a 30% growth.
Well, I mean, 30% growth has been exceeded by intermodal, I would imagine, but there's no intermodal on this line. It's been exceeded by waste by rail, which I think has a very bright future. I'm sure there are other commodities as well.
Well,
and in fact, we do a lot of work, as Mr. Warren directed some questions to me about work we do for shippers. We do a lot of work for shippers. Many of them are before the STB, but many of them are new customers. I think you and the board would be surprised about how many new customers, particularly foreign-owned firms, are expanding their presence in the United States and are trying to increase their movement of freight by rail, in many cases converting from truck to rail, not necessarily intermodal, but converting commodities from truck to rail because they are particularly concerned about climate change.
well, I don't disagree with anything you've said, Mr. Banks. I'm just trying to figure out the basis of a projection on which we're supposed to order the expenditure of $440 million of taxpayers' money. So I think we all could probably use a break. It's 5:04. I said we were going to try to end about this time. I totally respect and would defer to your counsel saying that you need a break. I've had witnesses who've needed breaks, and I think that's wise on everybody's count. Does any member of the board have anything further they'd like to say? We will resume tomorrow morning at 9:30.
And can I ask you just one question, if you don't mind? And you
Yes.
don't need to, please don't, you don't need to answer it. Maybe you could just talk amongst yourselves. So this trial has scheduled 12 witnesses.
Yeah.
We've made it through one, and
Yes,
we
we
haven't
have.
gotten through them yet. So we would just appreciate some guidance maybe tomorrow about whether there's a likelihood this trial will run over into next week, so we can make sure that everybody on our team has accommodations and the like. So if you could just caucus amongst, to give us an idea of what your projected timing is and whether you think you can get this done by Friday, that'd be appreciated.
It's a fair question, Ray. Let me just say a couple of things. One, we are scheduled for 4 days this week. I was actually hoping we wouldn't need all 4 days, but that hope's out the window. I don't know that if we run past Friday, that we can just schedule this for next week. There are many, many things that involve people's schedules. But your request is right on target because we should be looking down the road as to when we can reconvene. And whether we will reconvene virtually or in person, that's also an open question because our office is going to be reopening soon. So I think we will take that, definitely take that under advisement. So because there are a lot of moving parts there, including your witnesses who have schedules. So that's a point well taken. I would also, by the way, just want to re-emphasize, hopefully there's no need to deal with it, but if any attorney has any concern about an overdesignation of confidentiality, you must ask us that in some sort of formal piece of paper so we can deal with it. And if you don't need to challenge it, that's fine. But if you want to challenge it with some sort of motion or some formal request for relief, we're not going to deal with it on the fly as we go through the hearing. All right. Anything from Amtrak or the port before we recess for the evening?
Quick point from Amtrak, Chairman Oberman.
Yes, Ms. Bracy.
We're just asking that you instruct counsel and the witness not to speak over the evening recess.
Well, that is the normal courtroom proceeding when you're in the middle of an examination, and when default, we are supposed to be guided by those rules. And so I will make such a instruction of counsel.
Thank you.
Talked to
Mr.
Mr. Banks
Chair-
during the break earlier, and we were going to send him home and not talk to him till the morning.
Okay, very good. And you understand, Mr. Banks, you are in the middle of an examination. I'm not going to characterize what my examination has been, but certainly Ms. Bracy has a right to further cross-examination. So I'm sure you've testified before, so
Well, number one, this is not my first rodeo, and number
No, I'm
two, the
sure.
last people I want to talk to are lawyers tonight.
yeah. Well said. All right, sir. Thank you all. Thank you all for your patience. It's a long day, but as everybody has said, it's precedent setting and we want to do it right. So we will see you all in the morning. Thank you.
And with that, we are done for the day.